are, incredible in their field. I think we also really need to look at all of the knowledge that was brought to us yesterday by these people that have lived in these communities, like my mom, who you'll hear from for decades and decades, and really let that sink in and the changes they've seen and how this affects them. So again, lastly, I ask Council, please vote no on bylaw 27, vote yes on bylaw 20 to push things through. Thank you so much for your time.
Thank you so much for being here with us. I think we had one other person approach. Deborah Scott, is that you? Sorry, is that you, Deborah? Yeah, okay. We'll sneak you into as our last panelist. Please go ahead.
Right, thank you. I was, kind of thinking you forgot about me, so I'm glad you didn't.
Yeah, I'll just say when I read the folks' names, just make eye contact or give me a wave so I know that it's you that I called. Thanks.
But that's fine. Good morning, Mayor Jeremy and council members. My name is Deborah Scott, and I'm a resident of Haysboro in Ward 11. I grew up in Haysboro, have lived 60 of my 70 years in Haysboro, and when my husband and I decided to start a family, we moved into a house just 8 houses down from where my parents lived, who were still in their family home at that time. I've seen this community change over the years, but I've never seen the potential for changes so dramatic as to what have happened with this zoning law mess. My ask is ultimately simple. Vote no to bylaw 27P 2026 and vote yes to bylaw 28P 2026. Please let me explain why. I care deeply about my community. It's not just the 2 houses I've lived in. It's the streets, the neighbors, family, friends, and even trees that have raised both me and my children. I care about neighbors having a meaningful opportunity to participate in decisions that affect their neighborhoods. I care that Calgarians have a voice in the policies that affect them. As my daughter stated, our family's involvement began when a major redevelopment was proposed directly behind our home at 79 Hillary Crescent, which is one of the 247 properties on the list. As we tried to understand the process, we became aware of broader concerns about fairness, transparency, and public participation that extend well beyond a single property. And in listening to the concerns and clarification questions raised by this council yesterday, I'm glad I'm not alone. My biggest concern about bylaw 27P 2026 is not the planning terminology, it's fairness. What concerns me is that residents have spent months trying to follow this process, and yet it's become harder and harder to understand. The rules seem to keep changing, and that makes it difficult for people to have confidence that the process is fair. I support bylaw 28P 2026 because it recognizes that mistakes were made and need to be corrected. But if errors have already occurred, I think that's a reason for council to be even more careful before approving another large list of exemptions. Looking at the developments in our neighborhood alone, I worry about the pressure created by these deadlines has put too much emphasis on moving applications quickly. Residents want to know that projects have received careful review and that concerns are being properly addressed. Voting no on bylaw 27P 2026 would not stop development. It would simply allow unresolved applications to proceed through the normal planning process while protecting permits that have already been properly established. At the end of the day, Calgarians want clear rules, meaningful participation, and confidence that their voices matter and that they have been heard by their people that they voted for when decisions have been made. So I respectfully ask Council to vote no on bylaw 27P 2026 and vote yes on bylaw 28P 2026. Thank you.
Thank you so much. We have some questions from council members for this panel. First up, Deputy Mayor Kelly, please.
Ms. Scott, come on back. I could ask this question of either of the last 2 of you, so I'll ask you. I'll ask it of you, just because you were the last one standing there, I guess. You'd mentioned that the rules have changed throughout this process, and I'm wondering if you could just dig in a little bit deeper on that, like which rules, when did they change, and any clarity that you can provide for us from your perspective, we appreciate it.
Well, I think, when I'm referring to that, I'm trying to say that the blanket rezoning debacle of the last administration was one set of rules. And then a lot of the members of this council ran on the fact that that was a debacle and that was going to change if you were voted in. You were voted in, and the rules have changed. But with that, there was a vote to repeal, and then there was this grandfathering business that came along. Again, I think that's a rule change, because repeal, to me, is repeal. That should be the end of it. Again, acknowledging applications that have gone through due process, but allowing people to run in and make application very quickly between March 21st and April 8th didn't seem to me like a fair rule.
And so I guess maybe to have follow-up on that, that was my second question when you said like the proper process and whatnot. Looks like for the Hillary Crescent one, the application was submitted on March 30th. At that time, RCG was the zoning on this property. I'm just wondering, from your perspective, what should we, as the Development Authority, have done differently on that day before blanket rezoning had been repealed?
Well, again, I guess it speaks to, a developer kind of running in at the last minute to get ahead of that April 8th deadline. The decision to repeal was actually made in January. The date was given, the actual date of repeal was further down the road. But again, the decision really was made, from my perspective, in October when this council was elected. So if the writing was on the wall at that point, developers didn't need additional time to run and make application before a specific date. If March 21st was the date of repeal, that should have been the date of repeal.
Yeah, and I think that from a legal perspective, April 8th was the date to repeal, and in December we had said in the original notice of motion that there would be these exemptions. So I was just trying to get a bit of a better understanding in terms of from the, you had said like a proper approval process, and I'm just trying to figure out how we could have done it differently.
Well, I think, I have lots of thoughts on that, but I think in this particular instance, exemptions should have been not blanketly granted. So a proper approval would be to look at each property, look at each development on your exemption list, and give it a totally fair shake without lumping all 247 area properties into one exemption list, and quite honestly, in my opinion, a fairly vague exemption list.
No, I appreciate that, and I'm looking at the list right now, and yeah, I think for my colleagues and I, we are looking at all 247 and going, okay, which of these should rightfully follow the proper process and should remain on the list versus which have sort of extenuating circumstances that are a little bit odd, and perhaps we might want to look at amendment of some kind. So thank you for being here. Appreciate it.
Thank you.
Thank you. Councillor Atkinson, please.
Question for Radovan, please. Really appreciated your presentation. I think the focus sort of on the transition period and sort of certainty, and I think that that's really what this council is trying to work through right now. Councillor Kelly kind of spoke to it, right? We did create a set of rules, and while yes, the like outward, what the press are reporting on is that blanket rezoning has been repealed, but obviously with any bylaw changes or whatever, it's always more complex than just sort of the headline, right? And so we had these dates sort of set, and while I recognize we want to provide certainty to also, you know, like residents and people about what's going on beside them. There's also the certainty of when you own a piece of land, you're sort of able to run through those processes. I'm wondering if you can sort of speak to, like, I just found your presentation really sort of measured in that approach, and so how we treat that certainty for all parties involved when we had sort of the layout, and if there are things we got wrong. I think we heard right at the beginning, Councillor Chabot brought up some great points around SDAB challenges that may become later in the process, and ways in which we need to capture that. Whether there are, Councillor Kelly brought up some pieces around if properties are R1, but there's a duplex being, right? Like there's a couple of different points in there that we really need to sort of like hone in on and find those pieces to provide that certainty and clarity. I'm just wondering if there's anything outside of those pieces that you sort of see as where we didn't get it right, or there, where we've got a blind spot.
Yeah, I think there is, sorry, I think there is a lot of in that question to unpack, and I'm not sure how much time you have, but I think, as I mentioned in my presentation, we indeed are sort of in a situation that we do have, you know, one of the larger developments on one side that has been approved when the blanket rezoning was in effect, and we went through multiple SDABs, and there was a lot of confusion in that as well. So I know this is not necessarily directly related to the repeal of the rezoning, but at least from our perspective, even the appeal process seems to be flawed. And I can send you all details on that. We went through multiple SDAB appeals. We won the first one, developer replied, another one, we appealed that one as well. We lost, we took it to the court, and we lost. So this is just an additional piece that we are now looking into, because now on the other side is a development that had been submitted in March or early April, just before the deadline that council set, and I honestly was not aware of. And that's still under review. We submitted a lot of comments opposing this such development. I know a lot of neighbors in the neighborhood did the same, and I don't know where that one is going to lead. But again, what we heard yesterday, that if the appeal process doesn't conclude by August, it's going to go ahead, and I don't think that's right. Again, I cannot say, again, because I understand all the nuances and edge cases, if it's simple, if it's as simple as voting no for bylaw 27, yes to 28, it sort of makes sense. But I think honestly, if the applications are not approved now, why do they go through the rezoning, right? And go public hearing, follow the rules that exist now. Because my biggest concern is that if we have all these exemptions and then we do through the exemptions of the exemptions and look at those and look at those, you're dragging that uncertainty of the transition for next few years. And in a decade, you can end up with properties that are sitting on the land that is not appropriate, and you cannot add fence. And we will be dealing with the same transition 10 years down the road. I know it's going to be a small number of cases, but it will exist, and this will create inequality. So, you know, what is the proper way to do it is sort of above my pay grade. But if I have to look at it now, I would try to minimize the uncertainty going forward. How that looks like, I am not sure. Again, my feeling would be, you know, what's approved now, today, yesterday, when the vote occurs, that's done. And, you know, as we heard, there's not much council can do about it unless you take it to the court. But all the pending applications, I think, should go through the regular process.
I hear that, but like the regular process that was established, I guess, by council through the bylaw was sort of with these marks and measures. And that's the part that I'm like having the friction point with, and sort of we have the set sort of these parameters. When the law came into, like the moment the law came into effect, no further applications from that moment forward were under this. there is these pieces that have to play out, land use change, SDAB, having all of these processes. And that certainty is there for both residents and for folks who are able to construct, right? And so I just want to make sure, like, I've been hearing I think some very positive proposals being brought forward about these edge cases that potentially might not be captured in what's been brought forward. And I think you've seen that whole perspective of taking it through SDAB, seeing it even to the courts. And if there's any blind spots in what we've been talking about and those proposed changes that we need to sort of address.
Again, if you asked me probably a few years ago when before we went through the SDAB processes multiple times, I would agree with that perhaps. But seeing what we've seen with the SDAB, we have our doubt. And again, I can share that with your office. So you can go through the details and see what we see as a blind spot perhaps in the SDAB process itself, and what our legal counsel told us as well during that process. I'll be willing to share that with you and the rest of the council if you are willing to listen.
Sure. I mean, I'm happy to, but I think we also do need to put trust into the processes that are established. We also can't sort of have predetermined outcomes out of processes like SDAB. We have to trust in those. Whether there's always fixing to be done. Happy to sort of take those pieces, but it is really important that we also see processes through and put trust in the institutions that are set up, the courts, SDAB, and these sorts of pieces.
Yeah, I understand that.
Appreciate that. Thank you. Thank you for your presentation. Yeah.
Thank you. Councillor Chabot, please.
Thank you, Mayor. My question is for Ms. Sears. Thank you, Ms. Sears. I have to apologize. All the presenters that I've heard so far, most of them anyways, I read their submission in here, and I don't remember seeing yours. And so you did cite a specific address, and I didn't write it down. I was wondering if you could repeat that for me.
Yeah, this lot was 4706 16th Street, Southwest. And I'm at 1641 Altadore Avenue. I'm directly next door. And then Miss Noble is directly beside me that spoke yesterday.
Okay. So we've heard a couple of cases that had been appealed at SDAB, and subsequently a new application was proposed and inside the 6-month timeline. My understanding from having spoken to administration about those applications specifically is there is a provision in our rule around the 6-month, and that is if an application comes back and it's significantly different, it can be reapplied for within that 6-month window. I suspect that would have been a similar instance in your case, but
It could be why they allowed it. I would argue obviously the other way, that it's not substantially different when it's still a max RCG and the reasons for previous decisions aren't changed at all.
Yeah.
So I'm sure that's why they allowed it, but it was 3 months later and it was still the exact same massing, scaling, all the other issues.
I'm not going to dispute the merits of the application with you, but and it may be a case where you could appeal it again and get the same result that you did initially at SDAB. I just wanted to clarify that there's folks in the industry out there that really understand our process and know what they can do to sort of get around some of those rules, and I suspect that that's the instance.
Yep.
What happened with yours as well as the previous one that we heard just yesterday. So again, the question is whether or not due process has been followed. That's a question that I think we all struggle with, and hopefully we can get to a solution there, especially on pending applications. And then again, we're not the approving authority. We govern. We don't manage. We don't enforce. We don't regulate. So that's the challenging part, is how do you get to that level? Anyways, I think what you've provided us is some additional food for thought, and I appreciate that, as well as everyone here today. And again, I appreciate your submission as well as your presentations,
Okay,
all of you.
and you did find the submission. I was just going to confirm because I did submit 2, and then I did a second attachment, which was just the previous reasons for decision.
Yeah, and like I said, there was thousands of pages. And
Yeah,
I did commit them all to memory. My apologies for that. All right, thanks for being here.
Thank you.
No further questions.
Thank you, Councillor Chabot. We'll get started on our next panel. Thank you so much for our presenters. Do we have Saeed Bashi with us? Christina Provencher? Darcy Dang? Zhejiang? Catherine Long? Come on down, Catherine. Brent Nisnik? Come on down, Brent. Autumn Malsbury-Bogue? Noel Leemberg? Bruce Brander? Okay, come on down, Bruce. Robin McLeod? Come on down, Brent. Brianne Reed? Doug McFadden? Sue Parker? Kim Larson? Okay, come on down, Kim. So that's our next panel, I believe. Catherine, then Brent, Bruce, Robin, and Kim. Catherine, why don't you get us started? Thank you so much for waiting.
Oh, no problem. Good morning, Your Worship and members of Council. My name is Catherine Long, and I'm grateful for your time and the opportunity to stand before you all. Like many who have spoken before me, my involvement and the reason for me being here today came about because of a proposed and now approved development on my street, Hillary Crescent, in the community of Haysboro. I came in here intending to speak about that experience. However, after listening to yesterday's hearing and this morning, I realized my own experience certainly is not unique. Rather than focus my time solely on that development, I want to speak to what those experiences collectively reveal, especially in the light of the very important decision you all have to make. Although each speaker described a different project, the concerns being raised were remarkably consistent. In each panel, I heard residents speak to the concerns about procedural fairness, transparency, and ultimately public confidence in Calgary's planning system. That consistency is what prompted me to step back and consider the broader question before Council today. The broader question before Council, in my view, is no longer simply whether additional applications should be grandfathered, it is how Council should govern the unintended consequences of its own legislative decisions. I appreciate the principle that originally underpinned this transition from blanket rezoning. It was both reasonable and fair to provide certainty for applicants who had already committed significant time and resources before Council signaled its intentions to repeal blanket rezoning. Those applicants relied on the planning framework that existed at the time, and allowing a reasonable transition respected that reliance. However, once December occurred, the circumstances fundamentally changed when the city announced this would be under further review. From that point forward, anyone choosing to submit a new application did so knowing, or reasonably ought to have known, that the planning framework remained under active consideration by Council. Proceeding during that period necessarily involved accepting a degree of planning risk. This raises a very important question about the principles of grandfathering and whether they should end. I recognize that Council may hear concerns regarding the city's potential legal exposure should certain applications no longer qualify for exemption. Those considerations do deserve careful attention. Legal advice is an essential part of a good decision-making, and Council would be expected to consider it carefully. However, legal advice is intended to inform Council's decision. It should not become the governing principle of that decision. Legal risk is one important public interest for Council to consider, but it is not the only public interest before you today. Council must also consider the integrity of legislative process, the expectations created by its decisions, and maintaining public confidence in how those decisions are implemented. I appreciate that this Council inherited an extraordinarily difficult transition. There are no perfect solutions, and every option involves competing interests. Ultimately, however, resolving the unintended consequences of municipal legislation is the responsibility of Council. That responsibility requires more than identifying the option that presents the least legal risk. It requires determining which course of action best reflects sound planning policy and the principles of good governance. As councillors, you are not simply managing legal risk. You are stewards of Calgary's planning framework. Legal advice should inform your deliberations, but sound planning principles should guide your decision. Good planning policy should be grounded in transparency, procedural fairness, consistency, and the public interest, not primarily by the perceived threat of litigation. Otherwise, policy risks become reactive rather than principled. At some point, every legislative transition requires a principled conclusion. That conclusion may not satisfy everyone, but certainly itself is an important public interest. Continuing to expand grandfathering each time another consequence emerges risks extending the transition indefinitely rather than restoring confidence in Calgary's planning framework. One of the themes I heard repeatedly yesterday and throughout today, this morning, was that many residents feel their participation does not end when the hearing concludes. Instead, they feel compelled to continue following legislative changes, scrutinizing evolving exceptions, and returning to defend the principles underlying Council's original decisions. A well-governed planning system should not depend upon continual public vigilance to ensure that legislative intent is preserved. The responsibility for maintaining a transparent, consistent, and principled planning framework rests with Council. Residents should not bear the ongoing burden of ensuring that planning policy remains aligned with the principles Council intended to achieve. Today's decision is about more than these bylaws. It's about demonstrating how Council governs when legislative changes create unintended consequences. For those reasons, I respectfully ask Council to vote against Bylaw 27P 2026. Conversely, I respectfully recommend that Council adopt Bylaw 28P 2026 and adopt Bylaws 24P 2026 and 25P 2026. In my respectful submission, that approach best reflects the principles of procedural fairness, transparency, and maintaining public confidence in Calgary's planning system.
Thank you so much for being here with us.
Thank you.
We'll go now to Brent and then Bruce after that.
Good morning, Mayor Farkas and members of the council. My name is Brent Nesnick. I'm currently living and own 1612 Bonus Road. I'm discussing 1609 Bonus Road Northwest. Yesterday, I was able to sit and listen and understand what the impact of denying these exemptions would be. I went home and instantly checked and found out my development plan was under review, and I went, oh, geez. And I think for the next couple of days, that's exactly what I'm going to continue to do. I went last night and I walked with my dog, and I saw that etched into our road, it says that we're a municipal historic resource. And I think that's one of the reasons why that I'm here and why I live in Bowness. Previously, I lived in the Beltline, so I understand density. I understand the value of density, and I understand the value of community. And I'm not naive by saying I moved into the Bowness and the Hillhurst area, expecting that there would be no density and no changes in building. Over the last century, I've learned that this street has evolved. A lot of houses have been renovated. Over 50% of the homes have been completely ripped down and rebuilt. Every single home has been able to, there's the Riley Community Heritage Guidelines. They've been able to comply with those guidelines. They've been able to build within it. I originally submitted, there's actually two combinations, 1601 and 1609 as part of this development. I was okay converting that from MU1 to an RCG because I said, okay, you know what? We're going to have great homes built in this community. That's why we moved here. It's the heritage. It's the established trees. It's the community that drew me there. Let's bring more people in. And so when I originally supported it, we got that development plan back. We had already just had a 4-unit across the street adjacent to this, a 4-plex with 4 basement units. So we've already going to have 8 new units across the street. They proposed adding another 9 units and 9 basement suites. So with that development, it would actually, 50% of the block density would be increased, which is massive. I also went and we looked in the setback. Setbacks are really important. If you look down Bonus Road, we've got that beautiful lilac center, and all the houses are completely aligned, even if they're the big houses. And I understand people want to build big houses, take advantage, but they all followed the Riley Community Heritage Guidelines and the Heritage Guidelines that have been put in place by this council. So I come here today and ask, it's about the setback, it's about the massing, it's about the parking that they have and that they have no access to street access. It's a cul-de-sac. We already have 8 houses already being built. If we allow this and we allow those setbacks, it's going to be a permanent change. It's going to affect the heritage of this street going forward for years to come. My concern isn't density. My concern is that this level of density can only be achieved from breaking heritage guidelines that have been adopted by this council. I ask this council to deny this exemption, allow the developer, the applicant, to come back, look at the land use, look at the development plan, and come back with something that respects the community, respects the heritage of Bowness. Thank you.
Thank you. We'll go to Bruce, then Robin after that.
Thank you, Mr. Mayor, and good morning to you yourself and members of council. My name is Bruce Brander. I'm the owner and resident of 3861 Brighton Drive Northwest, which has been the subject of some previous presentations. On or about July 6th of this year, I received an undated notice letter from the city regarding this public hearing on bylaw 27P2026. That letter had an attachment referencing 3840 Brighton Drive Northwest, which is about 30 meters from my property, and the 3840 property recently had a development permit for a major redevelopment approved, and that permit is under appeal. The city notice letter provoked quite a lot of discussion in the neighborhood because no two people could agree on what it was saying. So it appears from yesterday that we were in good company when we were confused, but hopefully it's all sorted out now. In case it's not clear, the provisions I'm responding to deal with the exemptions in bylaw 27P2026, and I'm urging council to vote no on the bylaw 27P and yes on bylaw 28P. On the exemptions in general, how to put it, I think some people yesterday were more eloquent than me in describing it, but matters such as the repeal of a citywide zoning vote are always going to require messy steps to clean up. But matters can be simplified, in my view, with some consideration of who was anticipating gains, and who was absorbing or shedding risk. In particular, it was no secret to anyone that the city was involved in a major zoning reconsideration. Developers and applicants were free to take positions based on their view of which way the zoning could go. That's hardly unusual. I've worked in and around the development industry for a long time, and developers take that calculated risk every day. What, in my view, is unusual in the case of citywide zoning is that many developers appear to have believed that the zoning was cemented in place once the new bylaw was approved, but that was their decision and their risk to make assumptions. There's no reason why their free market decisions should be binding on anyone else. Perhaps the city feels it has obligations in dealing with people who got projects into the approval process in the period immediately after a rezoning was approved. But there's no need for the city to make that to assume that obligation in my submission. On paper, some people got a windfall when the city pursued rezoning in the first place. How are they harmed if the city then changes its mind and perhaps takes that windfall away? This was a contentious issue that was contentious issue that was a main factor in a recent civic election, and I think has been observed south of the border from people smarter than me that elections have consequences, and it's not after the city to bail out everybody affected. In terms of planning impacts, and this is a case of what has to be done in the development near my house, is if the exemption applies, then the properties who get them have a permanent entitlement to that higher density zoning. In the case of my place, That means the street will be 24 bungalows with a couple of split levels and one RCG, which is going to have 10 units in it and go up to an 11-meter height. Plus a 5-car garage. It's a bit, I analogize it a bit when you look at the plans to it almost reminds me of going to Scotland, and you'll find these keeps that go back 500 or 1,000 years. They're built in a central area, and this would be like a walled fortress at the high point of the street in Brighton Drive. And if the exemption applies, that's where it will stay. Obviously, nobody else is probably going to get a permit for a fortress on Brighton Drive.
Thank you, sir. You're just at time, but perhaps a final sentence to conclude your thoughts.
I was just at the point of saying, I was about to say, that completes my submissions, and thank you very much.
Thank you so much for being with us. We'll go to Robin, then Kim after that.
Your Worship, Mayor Farkas, and Calgary councillors. My name is Robin McLeod. I've lived in Altadore for 38 years and have witnessed an incredible transformation. I am in opposition, as well as many of my neighbours, to the exemptions for the RCG zoning as proposed under bylaw 27P26. Specifically, those development applications submitted prior to April 8th, 2026, and thereas the developments at 1636 50th Avenue Southwest and the 4706 16th Street Southwest development. I oppose the exemptions for these two properties for the following reasons. Planning of the former South Calgary communities of South Calgary, Altadore, and River Park, dating back as far as 1984, and the South Calgary-Altadore redevelopment plan was way ahead of its time. It imagined a family community including seniors and professionals with higher density and mixed use surrounding the core commercial areas of 33rd Avenue and 34th, higher density around the smaller internal commercial areas, followed by RC2, and finally transitioning to a very small pocket of RC1 zoning. Since 1984, South Calgary-Altadore has undergone significant densification and has contributed to meeting Calgary's housing demand and the city's desire for increased densification. I hear that Marda Loop is a poster child downtown. Less than 5% of the lots in Altadore were zoned RC1 under 1P 2007, and is much less as a percentage now when considering the subdivision, LOCs, and direct control approvals that have occurred over time. The city has advocated for a variety of housing types in communities. Certainly the Marda Loop communities, formerly South Calgary, have responded with commercial, mixed commercial residential, multifamily, infill, and single family. It is not NIMBYism to support the reversion and continued existence of RC1 zoning in the Marda Loop's communities, as it represents a different housing typography and a goal of the community and the city. Furthermore, the few remaining bungalows provide age-in-place opportunities, which are currently very limited. And as you can see with my gray hair, I'm quite interested in this concept of aging in place. Furthermore, I support in an RC1 district legal and registered secondary suites with notice, prior to approval, or backyard suites as discretionary use with a more rigorous approval process than secondary suites in low-density districts as per bylaw 26P 2026 with these amendments mentioned above. However, if the exemptions as outlined in 27P 2026 are allowed to stand, 1636 50th Avenue Southwest and 4706 16th Street Southwest remain RCG, it is my sincere hope that developments be subject to bylaw 24P, no, is it? Yeah. 24P26, where the maximum density is reduced from 75 units per hectare to 60 units per hectare and no secondary suites. I thank you for this opportunity and good luck.
Thank you for that. We'll go to Kim now to wind up our panel.
Mayor Farkas, councillors, good morning. My name is Kim Larson. I'm here to speak in opposition of a proposed development at 2542 10th Avenue Southeast in the community of Albert Park, Radisson Heights. I own the property just beside 2538. Under this mass rezoning bylaw, the property designation changed to RCG from its previous RC1, RC2. With this being changed, the development includes 4 townhouses, 2 front-facing, 2 back-facing, which are back-to-back as one building, with 4 secondary units underneath, 1 under each one, totaling 8 units. Assuming each townhouse has 2 or 3 bedrooms, secondary bath with 1, the huge possibility of on one lot being 16 to 20 or more people living on a 50 by 120 lot. Parking area development on this, for this site, has 4 single garage units in the back. That's definitely not enough for something of this size. So they're going to be parking on the street, and I've had to deal with vehicles parked on the street, encroaching on my driveway, not moving for days, if not weeks, and I've done this for years. This has been an ongoing problem. I'm concerned that this will be a full-time rental unit. And if anybody that knows Albert Park, Radisson Heights, it's largely rentals. And the way that the community is from that, it's not taken as care. It's not taken care of the same way as if you own it.
I'm going to just gently jump in, and I want our public hearing really to be focused on the matter in front of us. I don't want to see from the members of the public or members of council really casting aspersions at the type of people who might live in these properties. So us discriminating or making judgments, say, based on income, whether high income or low income, is not really before us. So I appreciate that was not your intent, but I think just for the public watching,
Okay.
renters are just as much Calgarians as.
Oh, no, I have no problem with renters. That's not the issue.
Understood.
It is largely the area itself of just how it is. So anyways, this is a regular, a concern that, okay. There are problems that come up with this type of setup. Anyways, being a longtime resident, I'm all up for new development in the area, rejuvenating it. And already in the last 2-3 years, across the street, they've taken out the old homes. They built R2 lots, RC2 developments attached. They've been sold. Over the years, I've spoken with the owners. It looks fantastic. It's great for the area. And I don't feel that a development like what's proposed beside me is proper, especially in the middle of a block. So it's not on an end, wouldn't be a row house, but it's in the middle of a block. There are lots of developments in the area, done, completed, some under construction, and others that are proposed or soon to be started. And I don't feel that there has to be an apartment block, so to speak, directly beside in the middle of the block. I just think there's too many problems that can come up from that and can arise. And I'm also concerned about the value of my property, because I don't think something like this is going to help. So in conclusion, I request along with everyone else that I've heard, including all day yesterday, that the rezoning should change back from what it is at the moment to previous mass rezoning. Thank you. I'm here if you have any questions.
Thank you, sir. This concludes the panel. We'll go into some questions from council members. Councillor Tyers, you're up.
Yeah, Ms. Long. In your presentation, you seem focused on the idea that council's discussions and decisions are led primarily by legal risk.
Yes.
I don't speak for councilors, but for myself, legal risk is certainly something that I consider amongst many factors. I was just wondering, what particular, like, did you hear something in a presentation from administration? Did you see something that council said or did that led you to this conclusion? And if you can be specific.
Absolutely.
That'd be wonderful.
Even just watching Global News last night, Mayor Farkas had mentioned on Global News that it was a consideration, both public concern, but also the legal ramifications of how this could, not in that exact verbiage, but yeah, it was on the news last night as well. And just my own personal feeling of undertone of perhaps how this has been driven, or all of the considerations that council has to take into account and what drives that. Yeah.
Nope, understood. Thank you so
Okay,
much.
no worries. I'm happy to answer any other questions.
Yes, absolutely.
Okay.
Mr. Niznik? So I believe the parcel in question that you're talking about is actually Montgomery, not Bowness, but always when we're like, oh, Bowness Road, that's in Bowness, but it's
Bowness Road in Hillhurst.
Okay.
Bowness Road, 1609 Bowness Road Northwest.
Okay, but yeah, I guess I'm the counselor next door,
Sure.
but like we definitely are seeing the exact same issues. And you talked about the respect of heritage.
Yes.
Which is definitely a topic that comes up a lot in Bowness as well. I was wondering, because you did talk about contextual application when it comes to this kind of thing. Is there a way that you see heritage being respected more in the process? And like, how do you see that? Like, is it somewhere in the process that we're missing it, like in the planning process?
So I think when you look, I know our community, the Hillhurst community, worked really hard on developing the Raleigh Community Heritage Guidelines. They spent years working with it, and it was approved by council. And I think what we've seen is through some of the developments, it's been a bit of a battle to try to make sure that when those development plans go through, that those guidelines have been set. Like, for example, the property that we're talking about in question at 1609, they're using half the setbacks that have been set out by those guidelines. And that would really significantly impact. This is the beginning of the street. So if you put a block right in front of that street, you lose the whole I guess the experience of that street, the heritage of that street, where we're coming from. And I think it's really working and I guess guiding the development plan and the people approving it to say, let's look at those heritage guidelines that have been established and let's try to ensure that they're being followed right from the start, and even working with those applicants before we have to submit our objections saying you're not following those guidelines.
Okay, thank you so much. I appreciate your feedback and both your presentations. Thank you.
Thank you.
Thank you. Councillor Chabot, please.
Thank you, Mayor. I'm going to start with Ms. Long. So, Ms. Long, thank you for your presentation. A very
Thank you.
seemed like a very thoughtful and considerate presentation. The procedural fairness aspect of your submission,
Yeah.
you said that as long as, procedural fairness is something that's taken
Sure.
into consideration. The process that we underwent, that council underwent with the original approval of the blanket zoning included extensive public consultation.
Sure.
And lots of advertising. And we didn't follow the same process for this particular repeal. And so from a procedural fairness, I think the reason that council, well, as one of the architects of it, the rationale was we wanted to push it through as quickly as possible and to ensure some procedural fairness without going through that extensive engagement process, that we would allow them to at least make their application and allow them to be processed based on the current land use. Do you think we should have looked at the previous process and gone through that extensive engagement to allow equal opportunity for reversal as it was for the application in the first place?
I mean, in hindsight, I certainly think it could be a consideration. It's not exactly what I was touching on, and when I shaped what I was saying, it was more based on my own experience plus hearing the experiences of fellow speakers in our own perception of the procedural fairness that's been granted to us throughout the process and what the challenges of what we've been dealing with is. But certainly I think it's a great point, and in hindsight, perhaps yes, the answer would be yes. That I do understand the constraints and the challenges of timelines and opening something like that up. And I mean, anything can be considered in hindsight, for sure.
Yeah, and I'm not sure that the outcome would have been any different if we had gone through that process, because it would have extended the time before we would actually seen a bylaw.
Yeah.
So many
I
of
do
those
understand what
applications
you're
could have
saying.
still gone through.
Yeah, I think if I can speak to that from my own experience, the procedural fairness that I can speak to is just understanding now, as this kind of all unfolds and you go through the process, understanding some of the procedures that developers get granted versus homeowners, and some of the information everything from the information we're privy to what we get to participate in, and then what is released to us as far as public knowledge information. It feels a little unfair and one-sided in that way, which I understand can be hard to manage.
It is probably more weighted towards the developers, because this is what they do for a living, whereas the general public doesn't do this for a living.
And I understand that, yeah. And I am in the real estate industry, so for the last 14 years, so I can see both sides of it. But with my resident hat on, that was shaped by that for sure.
Yeah, thanks.
Thank you.
For your
Thank you
no
for your
further
time.
questions for you, but
Thank
I
you
do
for
have
your
other
question.
questions. Thanks. Mr. Larson. So, Mr. Larson, you were referring to a property in Albert Park, and I don't recall the address that you listed. You said it was a mid-block one, and is it one of the ones that's listed in the exemptions, do you know, that property specifically?
That I don't know. I have a feeling it is.
Okay, I'll have to look that up. If you don't mind, let me know what the address is, and I can...
It's 2542 10th Avenue, and I do have, and I was going to ask this question. I was away in March, so my understanding, because I knew the gentleman living next door who was renting the property, and he said the property was purchased 2 years ago, and when I came back from holidays this year, there was a posting on the street, and it said, sorry, let me use glasses. It said, tell us what you think. Submit comments by April 15th of this year. So all of this talk that everybody's talked about, that it all had to be submitted by April the 8th, I'm like, okay, this is after that. It also says that it's a proposed...
Sorry, Alan, if I can interrupt you for a second. If comments were due by April 15th, that means the application would have been submitted significantly before that.
But it says proposed development.
Yes, but I'm just saying, if the comments were listed as having to be submitted prior to the 15th, that means the original application would have been significantly before that.
But should it not have been posted then sooner? Because it was
The
not
application is
posted at
made,
the beginning of March.
And then it's considered by the Development Authority, and then they go out for public input as to whether or not they support. Anyways, the process basically says, to your point, that the application had to be submitted before April 8th. So as far as when it gets reached out for public submission and public input, it follows that process of administration reviewing the application before even requiring them to advertise it before it gets approved. So then you have the opportunity to submit your comments, and to your point, April 15th would definitely imply that the application was submitted certainly within the timelines that had been provided by council.
Okay.
But I will certainly look up that address and find out whether or not it's one of the ones that's been exempted. There may be other things that we'll have to look at on that one specifically.
I spoke to somebody after this with the city, including, I think it's Stephanie Cantley, who's that's her file. And she said that you put in your comments, then she says, but nothing is, because it still has to go through all the channels. It'll be at least 4 months before they do anything on the property. And then I spoke with 2 other people, her included, last week, late last week, and they said it's in limbo, sort of. There's nothing that's finalized. So, but I was just wondering about that, where it says proposed development, and so I'm glad you had the chance to ask that question.
Yeah, thanks. My next question, that was all the questions I had for you, sir. Thanks.
Okay.
Councillor Chabot, if I may, just before you get to the next one, I just want to remind the public at calgary.ca/rezoning, there's 2 spreadsheets that apply to 27P and to 28P 2026. And as just an example, when you go to the 27P 2026 spreadsheet, it shows 2542 10th Avenue Southeast, and then has that application submission date as March 24th, 2026. So for each of these parcels, there's rationale for why they're part of that list and where they are along the process, what was applied for, and so on. Okay.
Great.
Back to you, Councillor.
Thanks. No, my next question is for that gentleman there, and I don't know how to pronounce your last name, so I won't even try.
It's fine.
Sorry?
I blame my parents. It's Niznik.
Niznik. Thank you, Mr. Niznik. If I remember correctly, the site specific that you're talking about, from my recollection of the material, was in a cul-de-sac, and it was a small home that was next to an already developed home, but it was reasonably respectful of the front yard setback.
Yes.
And so the RCG, the contextual sensitivity from a front yard setback isn't as, I guess, restrictive as it was originally intended to be. So 3 meters, and that's your main concern, notwithstanding the issue around parking, the fact that it's a cul-de-sac, right?
One of the cores, it's I think the heritage guideline set for 6 and it's 3 meters right now.
Yeah.
And so that'll significantly change. And when we look at the houses, remember there's the parcel, the property that's on next to 14th Avenue, and then there's the house that's in question, 1609. 1611 is going to be the fourplex with 4 basement suites right next to it. So that fourplex is able to comply. That submitted their process, it went through. This one wants to go out an additional frontage.
It's funny you mentioned 6 meters versus 3 meters, and for some reason I thought that in your submission, in the public submission, it said 25 feet, but that kind of correlates, right? All right. Thanks. No further questions for me. Thank you for your submission.
Bless you. Over to Deputy Mayor Kelly, please.
Mr. Brander, if you don't mind. I was just looking for Andrew's presentation from yesterday because he had a really good listing of the dates that are in there. I didn't find it immediately here. So I wonder if I could just ask you, the document that we have right now shows the Brighton Drive. Oh my goodness, clerks. Holy jeez, I barely mentioned it. I'm impressed. That's crazy. Maybe I don't need to ask my question now that we have it up here. The documents that we have, the spreadsheet that the mayor was just referring to a minute ago that's on the website, has the Brighton Drive listed as approved, but from what I understand from various presenters, it has been appealed to SDAB, but I don't see a hearing date or anything on the SDAB website. So I'm just wondering if you could just, do you know the date that the appeal was accepted or submitted, or?
Oh, well, the one thing I didn't scribble down, the deadline for filing appeals is the 23rd, so that's tomorrow. The one appeal that I know of that got filed was about a week or so ago, still within the deadline. I'll be getting. I'd have mine filed, except it's hard to be here and be getting appeals filed at the same time. So
in your knowledge then, just like this spread table that we're looking at on the screen here was from Andrew's presentation yesterday. Here he says that on July 18th, the SDAB appeal was filed. Do you know, to the best of your knowledge, whether that appeal has been accepted yet or not?
I'm not long time since I've done an SDAB hearing. I don't think it's a matter of being accepted. It's been filed. It's in there. The form's filled out.
No, that's fair. And I realize that I'm asking a question about something that was presented to us yesterday, but I know that just in terms of the neighbors and the group that you guys have been talking a lot about it. The reason why I ask is just because I think for us, when we take a look at this, we're going to have to take a look at some of the things that are in this particular, or some of the properties in this bylaw that are approved previously versus ones that are before SDAB currently, because just from a process perspective, we do have the next bylaw that we're looking at that actually pulls out anything that has gone to SDAB and failed, but we will in October, or I guess in the fall, Q4, I think it says, we'll have another cleanup bylaw for anything that goes to SDAB and has failed there as well. So I just thought I'd ask you about the timeline in terms of.
That's where it says we haven't had a time, because the appeal deadline is still open until tomorrow. So after that, we'll be hearing. I anticipate we'll be hearing from the SDAB about an initial hearing to set schedules and things like that. I understand SDAB is now booking into October and November. So with the surge in activity that seems to be going on, I wouldn't be surprised if we don't get a full merit hearing. Not getting it this year wouldn't surprise me at all. But
yeah, and I'm really glad you bring that up, because I think that's something that we as council need to take a look at in order to make sure that we clean up all of those SDAB ones to make sure.
Yes, sir, because I think somebody may have mentioned it yesterday, because there is the problem. I think your directive to the administration was to come back in Q4 with a cleanup list. And I think we may still be cleaning things up into Q1 of next year. So,
I agree with you. Yes, I don't think any of us anticipated the length of time it would take SDAB to process all of them. So, thank you very much, Mr. Brent.
Thank you, sir.
Thank you. Over to Councillor Atkinson, please.
Question for Brent Nisnik, please. Yeah, thank you. You were mentioning 1609, but it is the combo application.
Combo application,
yeah,
yes.
with 1601 there, yeah. So that's like abutting 14th Street. It is, yeah, I think Councillor Chabot touched on it, Councillor Tyers. It's just to understand the sort of concern. It's because I think these heritage guidelines, it's a new thing, right? Within the LAPs, we didn't have it sort of for the original within North Hill in the same way that we brought it in with Riley. And you seem like you're pretty tapped in. You saw the application next door. Are there certain pieces of that you like, I guess the learnings we can take from that and bring forward into these processes to make sure that because we need to figure out the ways in which redevelopment. I mean, you live in a neighborhood that is surrounded by redevelopment, right? Right across the street, you've got 4-story, 6-story towers that were not there when Hillhurst was first built, right? So that neighborhood is always in flux. So it's about the transition. We're always talking about transitions today, it seems like. So transition, and I guess I'm wondering are there certain pieces within those heritage guidelines that you think really help that transition while allowing the transition to take place and really sort of need to be respected? Yeah, and
I think if I had to look at a couple things, it would be I'll always come back to that consistent setback to ensure that it's aligned with the rest of the houses on the street. We look at the historic character of our street. We've got the lilac bushes in the center. It's the established trees, the replanting plans that happen. Because with this one, I believe they're taking down 3 mature trees that have been around for probably over 50 years. Yeah. I go and I look at the type of structures that are there as well. I think it's that look and the appearance of those houses within those historical communities. You can have a new house that looks amazing, but there's a couple on the house where you go, wow, it's awesome. But they still have the peaks, they still have the roofing, the massing is consistent with everybody. You can be, that fourplex has that type of roof structure, but it's gonna go deeper, right? It will, it'll take up more room. We're gonna allow that density in. I wanna reiterate, I'm not against the density within Hillhurst. It's a beautiful community. We're inner city. I expect more people to come live, but let's just respect those guidelines that are established and keep the historic feeling, the community, the sense, the established I guess it's those trees. It's what makes Hillhurst special. And I think it's tough. If you're working from a desk and you're going just from those type of things, there's only so many pictures. I think those guidelines will help you enforce that. And I think I talked about how I'm checking to see if my DPs, it's under review, that I don't want it to be approved. I hope that if it does get approved and we appeal and we're successful, that there is some type of amendment that allows us to be able to challenge that. I know Councillor Kelly and Chabot have been, you can see that the chatter that's been going on back and forth in Jameson, it's trying to say, how do we make sure that that's respected? I believe that we can have density in historic communities. We should have density and security. Let's let more people live in these great communities. Let's just do it respectfully.
Yeah. It's interesting because actually your piece there around the property next door, so it actually will go deeper into the property, which this is where you actually get into relaxations. And I think often when folks are doing development, they often relax the heritage guidelines before they work on relaxations to things like the setbacks or where the building is positioned, these kinds of things, because it's seen as maybe that is more amenable, is like to relax the heritage sort of piece. But I think you actually bring up an interesting, it's that friction there between where do the relaxations take place? If we are trying to protect a tree, how do we relax that and still make that a possibility while, letting the development go forward and really sort of, as much as possible, land these buildings in a way that is contextually sensitive. Yeah. Thank you for your presentation.
Thank you.
I believe that concludes this panel. So thank you so much to the members of the public for being here with us. Yeah, I'll begin to call names again until we have 5 folks for our next panel. Do we have Autumn Malsbury-Bogue? Noel Leemberg? Thank you. Come on down, Noel. Brianne Reed? Doug McFadden? Sue Parker? Kimberly Coots? Jason Quenville? Thanks. Come on down, Jason. Pat Guillemot? Come on down, Pat. Arlene Kierholt? Rose Crowley-Campbell? Dana Bochter? Thanks. Come on, Dana. Diana Potter? Jason Quinville? Thanks. Sorry, I'm just trying to call names for 5, but I see 5 people have approached. I may have missed one of you. So I had Noel, Jason, Pat, and Donna. Who was the 5th that I missed? Rose? Okay, perfect. Yeah, I'll just, again, respectfully ask if I call your name, make sure to make eye contact and me a wave so I know that you're definitely here. Okay. All right, that is our list. We'll go with Noel, Jason, Pat, Donna, then Rose, and that'll be our 5. Deputy Mayor Kelly, would you mind taking the chair for just a moment here?
Good morning. Before you start my time, I'd just like to present a poster, and I don't know if I can put that on the screen. Oh, over here.
Yeah, our team will assist with that.
All right, well, good morning, Mayor who has just left the room. Good morning to you anyways, and members of council. My name is Noel Leemberg. I'm a born and raised Calgarian, one of the few, and I live in Upper Montgomery. Today I'm speaking not just for my family little emotional, but also for the many neighbors who couldn't be here today, those who are away working or who simply are not comfortable speaking in front of council, because let's be honest, speaking to other people or speaking up front is not always comfortable for many, but they're counting on you to hear their voices through mine. Today, I respectfully ask council to give full and careful consideration to removing the exemptions that would allow development permit DP 2026-01534, a mid-block family development, as well as DP 2026-01591 directly across the street from my home to proceed. I live at 3019 46th Street Northwest. Right across the street from me is the home 01591 in proposal that is at 4648 29th Ave. Across the street from that is the multifamily mid-block at 4647 29th Ave, also in progress. The magnitude of what is being proposed in an RC1 community is off the charts. That's what my husband would say. We chose to live in Upper Montgomery very intentionally. We bought in an RC1 neighborhood because we wanted the quietness, the peace, the comfort, and the magnitude of the 100-year-old trees that exist in Upper Montgomery. Also, my son goes to Haskayne, and we wanted him to be able to walk to school. The character of Montgomery has been vastly changed, and we welcome the change. We welcome the diversity of buildings in Lower Montgomery, which was never zoned as RC1. Montgomery has welcomed well over 400 new units, and we know that there is now an 88-unit building that is just about finished right along Bowness Road. But on April 28th, 12 of you voted to repeal the blanket rezoning because you concluded it was not the right planning policy for Calgary. You listened because placing higher density zoning in established low density neighborhood without thoughtful planning was not working. Then came the exemptions, a nasty surprise to Calgary, as you have heard from all of the members that have joined us over the last few days sharing their perspectives. And I'm asking you today to finish what you started, because the exemption criteria undermines the very planning principles you voted to restore. And they also undermine public confidence that planning decisions are based on good planning, not arbitrary dates. These current exemptions don't reward thoughtful planning, they reward timing. And developers, such as the developers who are proposing to build across the street from me, have taken advantage of that, and I get that this is their job. But we live in communities, and these communities are built by residents who pay taxes, and bloody high taxes, I will say, and I'm happy to pay those taxes to keep my trees. This isn't a long-term city building problem. This is a race against the calendar, and Calgary deserves better planning than by a deadline. This mid-block building that is being proposed, this is not a major roadway and not along a major corridor. It's in the middle of an established RC1 neighborhood. And at the same time, like I mentioned, if these two buildings come down, we could lose 8 magnificent fir trees, 50 feet tall or higher. And this is not going to be replaced by simple landscaping. They're gone, and that's part of the identity of Montgomery. But perhaps what has most disappointed our community and myself is the fact that there has been absolutely no meaningful engagement of the proposed developer. No effort to sit down with the neighbors. No effort to understand what these projects mean for the people who already live here. More than 50 neighbors have gathered repeatedly because of the worry, the frustration, and the heartbreak. And you heard from Archie and Jerry and Dawn yesterday in Montgomery.
Thank you, Miss. You're just at time, but perhaps a final sentence to
Yes.
conclude your thoughts.
Okay, this is no longer about one project. It's about the cumulative impact of multiple projects. And I ask the city, please, to not decide on what can be built, but decide what kind of Calgary will become and whether promises made to the communities still matter. Thank you.
Thank you so much. We'll go now to Jason, then Pat after that.
Good morning, Mayor Farkas and members of City Council. My name is Jason Kenville, and I live directly across the street from 3840 Brighton Drive Northwest. I'm requesting that you do 4 things. 1, fix the bylaws we talked about yesterday. 2, deny the exemption requested, proposed for that. 3, repeal blanket rezoning. And 4, fix planning and regulation. Pretty ambitious, so let's get started. This goes beyond my request and my written submission, and yesterday's events have led me to rethink my views and rewrite my speech entirely. So first, my neighbor Andrew Hayes raised an important procedural flaw with the current bylaw, among others, just given the confusion that we saw yesterday. So that should be fixed if nothing else. But the fix goes well beyond that. Let's just start with a thought experiment. Imagine a stylized world with homeowners, developers, and regulation and enforcement done only by the courts. Every unsuitable project would need to get challenged, but that would put homeowners at a disadvantage to developers who have more resources and concentrated interests. Rational homeowners, if the stakes were high enough, would conclude that they have a collective action problem and create a cooperative mechanism to challenge unsuitable projects. Such a mechanism would have specialists, planners, lawyers, and the like. This, of course, would be difficult to inexpensive to govern. Ultimately, through a number of iterations, people would decide to form a government to handle regulation for them. I just propose the very same thing. Let's have a government do this for us. Okay, this is a stylized example and a lighthearted one. But it raises a critical issue that surfaced in yesterday's council session, just given all that we heard and the uncertainty in the bylaws. I mean, Calgary urgently needs a robust and thoughtful framework for development. I mean, just, I guess, obvious. And I just hasten to add, because all this has forced me to be pretty negative. And I could at least cite University District, which I put in one of my responses for 3840 as what I thought an example of good planning. So I'll just cite that as an example. It also needs a regulatory framework that ensures substantive, not nominal, procedural fairness. Those words were asserted more than once yesterday, and nearly every case study we heard raised important questions about substantive procedural fairness and regulation in the public interest. These, of course, require an impartial arbiter. And the city, as a body that benefits from upzoning, is necessarily conflicted as an arbiter in upzoning cases that increase revenues. My own experience with the city's process in DP 2026-01358 demonstrate a lack of substantive procedural fairness. The city made consequential and irreversible decision in that case and has offered no justification other than approved. That's an opinion, not an argument. And regulation in the public interest demands transparency about consequential decisions. It's why regulatory bodies typically publish their decisions. Calgary should adopt such practices. It could be the case that the city's scope of review is insufficiently broad to deliver robust regulation in the public interest. I mean, I'll concede that, I mean, there are rules people have to follow. That's something the city should be transparent about or fix. So what I'm asking, fix yesterday's bylaw. There was enough confusion, and I mean, there were questions about the communications process. Going further, like, deny virtually all the exemptions and actually repeal blanket rezoning. And I mean, if they're meritorious projects, help them along to reapply. I'll now quickly turn to the matter of my written submission, undue city protection for high-risk investment decisions. First, we heard the word certainty yesterday. Investment is actually in the domain of uncertainty, not certainty. Government bonds are considered certain risk-free investments and deliver low returns. Investors earn returns above risk-free returns by appropriately dealing with uncertainty. Development projects are high-risk projects with commensurately higher returns than government bonds. Projects undertaken after the municipal election, which introduced regulatory uncertainty, were higher risk still. Building RCG beyond a duplex was yet higher risk. It's debatable whether Calgary should have protected development applicants for making such high-risk investment decisions. It did by granting RCG status to projects filed through April 8, 2026. Extending the protection already provided to investors through exemptions both protects investors from taking the incremental high-risk gamble of building beyond a duplex or renders investment protection perpetual. Both of these approaches are inappropriate. Please revert all properties that have sought to build beyond a duplex to RC1. Thank you.
Thank you so much. We'll go now to Pat, then Donna after that.
Good morning to Mayor and Councillors. My name is Pat Gilmore, and I'm the Chair of the Civic Affairs Committee at Westgate Community. We support the decision of Council to repeal blanket zoning. The grandfathering transition does not have clear rules or dependable guidelines. We were told that the 31st of March was the application cutoff during the last public hearing in March. And that application would have to complete the planning process by the 4th of August. By submitting an application, it's a proposal from the developer to apply for approval to build. By no means does it mean that the development has been approved. Developments that have completed the full process should be protected, but not retain RCG on all properties where the application is still under review. That's an unfair advantage. Westgate has 3 properties listed on the exemption list. One of them, 143 West Catno Crescent. We were advised by the file manager that it has been approved. The other one at 145 West Catno is still under review. Both these are considered row homes when in reality they're 3-story apartment buildings. 275 Westminster Drive, this was a subdivision and is still in advertising as the developer advised us he was putting a 2-story duplex there. We do have concerns as it is a very steep slope. However, our big dilemma is, whilst we don't support them, we feel we cannot request these 3 properties to be returned to RC1 as we have met with the developers and expressed concerns of the adjoining residents. SDEB cannot carry the planning burden created by the transition. When applications are approved without adequate revisions or contextual review, residents are left to identify the issues and decide if they can afford SDEB. SDEB appeals have increased from 2024 to 182 in 2025. Costs for appeals are anywhere from $2,500 to $7,700 for representation, and considerably much higher if anyone goes to the Alberta Court of Appeal. We all deserve a fair process and not special treatment for unresolved applications. Residents are entitled to clear rules, reliable deadlines, and a planning process applied to everyone. However, repeal of blanket rezoning is not our only concern. We have another peril. That's the Westbrook Local Area Plan. We feel the LAP must be reopened for true community engagement. Our opinion is that the LAP was predetermined. Many locations slated for density are not appropriate. Currently, we have an LOC with the developer clearly saying that he filed late, asking to revert the property back to HGO from RCG. It was changed to RCG with blanket zoning. This location is not safe for HGO or for density. It would have limited parking. Across the street are 2 schools, busing schools. Up the street is another school with its busing, 3 daycares, and is access to our community. To put density here with no parking is absolutely ridiculous. We ask that that the LAP become a local plan that reflects the makeup of our community. Thank you for your opportunity to speak.
Thank you so much. We'll go to Donna and then Rose after that.
Good morning, Mayor and Councillors. My name is Dana Bochter. I am the owner of a property immediately adjacent to an approved 8-unit development at 2302 6th Avenue Northwest, one of the projects affected by the exemptions. I respectfully ask Council to reconsider the scope of the exemptions that have been discussed here. The decision to repeal blanket rezoning reflects Council's recognition that the previous policy warranted reconsideration. There are approximately 250 exempt properties. These exemptions would enable many developments to proceed under the previous framework even after the repeal of blanket rezoning reversal takes effect, thereby reducing the intended impact of Council's decision. While I appreciate the desire to provide certainty for the development applicants, That consideration must be balanced against the long-term consequences these developments have for neighboring communities. Because the decisions today will shape our neighborhoods for decades. I believe the balance has been tipped too far in favor of the pending developments relative to the interests of neighboring communities. I respectfully ask Council to limit exemptions to projects that are already under construction or substantially underway, rather than extending them to projects that have not yet physically commenced. In my view, this would provide a more appropriate balance between certainty for applicants and fairness to neighboring communities. If the Council has decided to repeal the blanket rezoning, the exemption should not substantially undermine that decision. The broader the exemption, the less meaningful the repeal becomes. Thank you for your time and the opportunity to speak, and thank you for your consideration.
Thank you so much. We'll go to Rose, please, as the final panelist.
Good morning. I'm here on behalf of my family and also several other families on Gissing Drive Southwest in Glamorgan. I'd like to speak to you first about number 24 Gissing Drive Southwest, and then about the loopholes created by the blanket rezoning repeal exemption criteria. I did make a written submission that addresses both 27P and 28P, but I received additional information after that submission deadline, so I'm going to talk about those new items that I have in my presentation today. So first, it appears that number 24 Gissing Drive Southwest was added to the repeal exemption list in error. According to the citywide zoning change map, 24 Gissing Drive will be rezoned back to RC1. I actually checked it yesterday. So I was really surprised when I received a notice of public hearing that listed 24 Gissing Drive as exempt. I checked with the city file manager, who confirmed that a development permit application for that property was received on, not before, April 8th. This is also shown in the spreadsheet of proposed exemptions. So on, not before. Therefore, number 24 Gissing Drive does not meet the exemption criteria, and I ask that the city please remove number 24 Gissing Drive Southwest from the exemption list. Now I'd actually like to address the loophole created by the wording in the exemption criteria. The criteria that states that the development application was, if it was submitted before April 8th, that qualifies for an exemption. But what happens if an application is submitted before the deadline, but is then later denied by the city, or it's approved by the city and then it's overturned by the appeal board? That's not actually addressed in the language at the moment, and that's where the confusion comes in. Is that property still exempt from zoning repeal? Would the developer be rewarded with a permanent RCG zoning in a neighborhood that is otherwise RC1? And can the developer come back at any time in the future and apply again under the RCG rules? At the moment, it sounds like the answer is yes. Developers could obtain permanent RCG zoning just by throwing in an application as a placeholder without the need to make sure that that proposed development is compliant with RCG rules. This is actually the scenario that Councillor Pantazopoulos mentioned yesterday. The student trying to just throw something in to hit a deadline, just throw it in. So if the application for number 24 Gissing Drive had been submitted on time, which it was not, it would have exemplified this problem. That application does not meet the RCG zoning rules because, among other things, it's just too tall. It's taller than the maximum allowed. The file manager gave the developer the opportunity to correct their proposal, but they missed that deadline as well. And when they finally did submit a revised proposal, it still does not conform to RCG rules. So frankly, this does not appear to be a good faith development application. It's just a placeholder. But with the loophole, if that developer had not missed the deadline, they could have received an exemption and been rewarded even though their application was non-compliant. The situation I've described is unfair for communities who reasonably expect blanket rezoning repeal will end uncertainty in their neighborhoods. It's actually also unfair to other developers who did submit things on time and made sure that they were compliant with RCG rules. So I asked the city to review and revise the wording of the exemption criteria to close those loopholes and explain what happens if something is later denied, okay, by the city or by the appeal board. Okay. I'd also like just to take my last moment to address council's concern about reputational risk that was brought up yesterday. Making an error in the original criteria wording is one thing, but recognizing that mistake and letting it stand is quite another. The risk to your reputation is in not fixing the problem. Okay? That is what would do serious damage to this council's reputation. Thank you.
Thank you so much. That concludes the panel. Councillor Panizopoulos, please.
Thank you so much to the panelists. Ms. Lemberg, thank you so much for that presentation and your words. One thing that stuck out was you were quite adamant at the surprise at exemptions or surprise at exempting properties. And I just pulled up the vote that we did, and I fully supported on the repeal on December 15th. And it clearly said that we would exempt properties that had a development permit, a building permit, and there's, I think, a subdivision as well. So it was very clear in December, the language. The date wasn't, but it did say at the meeting in March, so we go there. Maybe just speak to us how we could have done that better. We met in December, we spoke to it, the dates are very clear, but obviously it was missed from Calgarians. So what was missed? What could have been a better result that would have helped address your concerns? Because I am, when you said surprise, that was, it spoke to me, but when the document's there, what would you have suggested been a better approach?
Well, I think two-part. First of all, as a member of the community, I could do my part to be more involved and be prepared with the information by reading more. The proposed development, the Tricor 3-story development that has been proposed to build across the street from me, was not put into proposal stage until March 20th, just 18 days before the cutoff. So I think that even if I had read that exemption, I would have been in such shock that this 3-story building across the street was proposed that I may not have been a part of that. So yeah, I will own that. Thank you.
Yeah, it's definitely not an ownership. It really goes that, you know, there were some other Calgarians that talked about engagement and getting the message out. So it's just important to hear that, yeah, this was certainly not saying, because obviously a lot of folks may not have seen that December. But thank you so much for that presentation.
You're very welcome. Thank you.
Gilmont, thank you so much for presenting and always your service to Westgate and the community. You know, when I was looking at the 3 that are in Westgate, 2, the development permit has been approved prior to today's meeting. So those are the difficult ones. It's approved. They're going to start working. The ones that haven't, your thoughts on, we've heard from a lot of people saying, hey, there's an arbitrary date. If there was an amendment that was brought forward that said, we understand that while it's in flight, if the development permit was pulled back, if it was rejected, if something happened where, for whatever reason, whether it's community-driven or administration or the applicant, and then it would revert back to its original classification of land, would that address your concerns? The reason I ask, it gives the applicant a fair chance. They did meet the criteria that we set out as council, and if it takes 3 weeks or 3 months, but it gives community that if they're successful in the appeal or whatever it looks like and it's rejected or pulled, it would revert back, but still gives them that. How do you feel? Would that address your concern on that particular, the last
one? The one at 839 45th Street?
Just generally, just your years of planning.
The one at 839 45th Street, it's right on the corner there.
Yeah.
And it was HGO, which could go up to 4 stories. Yeah. And I understand with HGO, there's very limited parking. And as you're aware, that corner is a nightmare.
Yeah.
It's got the 4-way stop, it's got the schools, they're all busing schools. And plus we've got the baseball on the, you know, Ross Carrick and Westgate. Like it's not where we should have density on that corner. And I appreciate the LAP says every corner, but we had no say in that. We were told, and I spent 3 years on the LAP, and we were told every corner is going to have density. and there was no leeway on any corner. And it's just like the building right behind me. We're on our 4th amended plan since last September. That is a bend in the road, but LAP considers it a corner. They're not the right places to put density. There's other places in the community, yes, we can have density, and we have lots of it, and we have lots of affordable housing. You know, so somehow there has to be a happy medium of creating the density, but making it in the appropriate location.
Wonderful. Thank you so much for that. And then maybe finally, Ms. Campbell, thank you so much, Pat.
Yeah.
Thank you so much. 24 Gissing Drive. Yeah, I did note April 8th. So I've
Yes.
asked for clarification from administration, because that's a fair point, on or before, and those are important details.
Yes,
so
prepositions matter.
Don't have an answer yet, but we'll work on that. And thank you for pointing that out. And we'll definitely take that away. But I just wanted to ask the same question just asked your neighbor. You know, that uncertainty, it seems unfair. There's an arbitrary date. If there was an amendment that allowed the extension, if something changed, it would revert back. Does that address your concerns? It gives both the applicant a fair shot at their right to develop, but it also gives community their right to appeal and if they're not satisfied with the development. What's your thoughts on that?
That's exactly my thought on it. I do understand that there has to be an arbitrary date.
Yes.
Right? Because the law was one thing, and then as of April 8th, the law changed to something else, right? So that's fine. There has to be a date. Before that date, one thing. After that date, another. That's fine. So after that date, they should revert, right? But before that date, it does make sense. If somebody actually put in an application before that date, they were following the rules. But we do need to know exactly what happens afterwards. So what you've suggested is exactly what I'm looking for, that there should be clearly laid out if they made before the deadline and their application makes it through the review process, the application is approved, the application withstands whatever appeals happen, then it can stay. But if it does not get approved, or if it gets overturned by the review board, then those properties should revert to the previous zoning. And that should also be true of the ones that are in that before that August 6th deadline as well, right? Everything, if it didn't make it through, if it got rejected or it got overturned, they should revert back to the previous zoning. And I think that actually has to be really clearly stated in the exemption criteria so that we all know exactly what's going to happen in every situation and that it's fair in every situation.
No, thank you so much for that perspective. You clearly articulated it, and I really appreciate you coming and all the speakers for presenting. Thank you so much, Mr. Mayor.
Thank you. It's 11:31, so we have the ability to accommodate one more panel before the lunch break. Thank you so much for the public presenters. Run through some names quick. Do we have Autumn Malsbury-Bogue? Brianne Reed? Doug McFadden? Sue Parker?
Yes, I'm here.
Thanks, Sue. Please stand by. Arlene Kierholt?
Yes, I'm here.
Thanks, Arlene. Please stand by. Diana Potter? Thanks. Diana. Jennifer Hule Famakende? Frank Stewart? Karen Arndt? Thanks. Come on down, Karen. Evgeny Zaromsky? Doris Yasku? Thanks. Come on down, Doris. So this will be the final panel before the lunch break. Sue, Arlene, Dana, Karen, Doris. Sue, take us away.
Okay, awesome. Thank you so much. Good morning, Mayor Farkas and members of council. My name is Sue Parker, and I'm a resident of Altadore. Thank you for the opportunity to speak. I spent the last year participating in Calgary's development appeal process for proposed development currently with an RCG designation at 4928 21st Street Southwest in Altadore. It's DP 2024-06989. The property is currently on the exemption list as it was approved and is now under appeal. The appeal will be heard July 30th and a decision rendered sometime within the following days, either before or after August 4th. Determining applicable bylaws and potential zoning outcomes has been anything but certain. I'm hopeful that this hearing will quickly clarify our situation, and I also strongly believe that this property should revert back to RC2 and not be on the exemption list moving forward. I appreciate that you've identified a need for an additional bylaw for situations such as ours that are under appeal and may or may not have a decision rendered before August 4th. I've seen firsthand how lengthy and complicated this process is for residents. I want to speak specifically about the proposed exemption provisions. Council has made a significant planning decision by replacing the blanket rezoning framework with a new approach for residential development. My comments are about ensuring that whatever transition Council adopts reflects its intended purpose. Our neighborhood has been involved in an appeal of a 7-unit and 7 secondary suite row house development on a single bungalow lot. In our case, the appeal process was delayed for several months. During that delay, the blanket rezoning was repealed. The applicant subsequently decided to modify their plans. Rather than submitting for a new development permit under the new rules, the applicant produced revised plans in the midst of the SDAB appeal process. This creates a situation where changes can be considered without the project returning to the normal development permit review that every new application would receive. The applicant will argue that the board should consider these revised plans rather than the original plans under appeal. I'm not asking Council to comment on my appeal, nor am I asking you to decide whether those revisions are significant enough to require a new development permit. That is not my purpose today. Rather, my experience has highlighted what I believe is an important policy question. Did Council intend the exemption to attach to the filing date of an application or to the actual proposal? The city's transition provisions are based on applications received before a deadline. As those applications move through approvals and appeals over many months or even years, it is natural that applicants may revise or refine their proposals. However, without clear limits, the transition provisions could allow projects submitted under one planning framework to continue evolving under that framework long after Council has chosen a different one. I question whether that was Council's intent, and I believe it deserves clarification. This leads to a central question I hope Council will consider today. If the proposal before the decision maker is no longer the same proposal that originally qualified for the exemption, should it continue to benefit from the exemption? This is not about one development. It is about ensuring that the transition provisions operate the way Council intended. If revised proposals can continue to rely indefinitely on repealed zoning simply because the earlier version of the application met the filing deadline, then the new planning framework may not take effect as Council expected. I respectfully ask Council to consider whether the current transition language should distinguish between the application that qualified for the exemption and the later revised proposals that emerge during lengthy approval or appeal processes. My request today is not to determine where that line should be. Rather, it is to ensure that the transition provisions clearly reflect Council's intent so applicants, communities, administration, and the appeal board all have greater certainty moving forward. I would leave Council with these 3 questions. What exactly did Council intend to exempt? Should exemptions continue when the proposal before the decision maker is no longer the same proposal that originally qualified for that status? And does the current transition language fully reflect Council's intent? Council spent many months considering how Calgary's residential planning framework should evolve. I simply ask that the transition provisions ensure grandfathering reflects the proposal that earned that status, not every future version of it. Thank you for your time.
Thank you so much. We'll go to Arlene, then Dan after that.
This is Arlene.
Thank you, Arlene. Please go ahead. You have 5 minutes.
Good morning, Mayor and members of Council. My name is Arlene Kierholtz, and I'm an owner of a residential property immediately adjacent to a proposed development in Ward 11. I oppose the passing of the bylaw 27P 2026 to the extent that it permits exceptions that fall short of a fully approved and final development approval. To pass the proposed bylaw 27P 2026 with an exception for either an approval that is not yet final, or worse still, the mere filing of initial application by April 8th, 2026, is contrary to the principle of repealing blanket rezoning and is grossly unfair to taxpayers who have the misfortune of being captured by these exemptions. After attending yesterday's public hearings, I still have to ask what rationale exists for the proposed exemptions. Administration had said yesterday that they prepared them as direction from council, and while that explains how we've come here today, it's not an explanation as to why these exemptions are merited. The exemptions capture 247 developments, but the negative impacts affect hundreds more property owners and the communities in which they live. If the proposed developments are not exempted, they are not defeated nor rejected. Rather, they would follow procedures and processes that all developers must follow. These processes are designed to protect the legitimate interests of the property owners and communities in which they choose to build. Consultation and review of each development is not a burden. Rather, it is a balancing of rights and interests. In terms of the proposed development for which I am an adjacent landowner, the original development application was submitted in September 2025 and comprised 3 buildings totaling 20 units with 10 carports straddling 2 existing residential lots in which 2 detached houses currently exist. Over 100 letters of objection were submitted to the development office. In February 2026, the development application was split into 2 applications but remained fundamentally unchanged. Amendments to each were filed on May 5th and June 11th. Development Permit 2026-00738 received preliminary approval on July 9th, but is still subject to appeal process. There's no determination whatsoever regarding Development Permit 2025-05362. These development applications are incomplete and do not merit special treatment. In closing, there is no compelling reason or justification why these exemption clauses should be employed. Fairness, consistency, and respect for taxpayers and community require council to reject these special exemptions. I thank you very much for your time.
Thank you so much. We'll go to Diana, then Karen after that.
Good morning, Jeremy Farkas and council members. I'm Diana Potter, representing 11 Forest Lawn neighbors of Street 40th and 41st Street Southeast. Please note that 11 of my fellow neighbors have signed in opposition of the rezoning of the property of 2626 40th Street Southeast, Plan 1301HK, Block 10, Lot 12, 10E, Bylaw 27P2026, and for the following reasons. Some background on the house. It was built in 1958, property tax assessed at about $400,822.500. Sold for approximately $525, and that's a difference of $42,500. There's height setbacks for the neighbor's privacy and light. Parking is limited now with 3 adjacent schools, 2 youth centers, numerous school buses, and a bump out in front of the house of 2626 40th Street Southeast. The noise level will increase in our area. Limited access to the alleyway because of the green bins, the blue bins, the black bins. it's going to be hard on the infrastructure. The infrastructure is 70 years old, and demand for sewer pipes, water pressure is already decreasing in our area, and the drainage on a multiplex corner is also a concern. Numerous 4, 6, and 8 plexes are still sitting empty in the Forest Lawn area and are not low income prices. For a fourplex starts at $350,000 and up, and they're high-end rentals. The area is congested, as I said, with 3 schools containing 1,491 students. That does not include the support staff for these students or parents picking and dropping them off. There are 2 youth centers, one behind the house and one across the street, 8 school buses, 2 times a day, parking and dropping off students. A fatality is extremely possible for pedestrians and cyclists on 26th Avenue and 40th Street. The City of Calgary study 26th Avenue has a traffic calming speed bump and curb bump outs, yet the area still remains a high traffic volume area. I'd like to say that it's got character, Forest Lawn. It impacts the neighborhood. Forest Lawn was incorporated as a village in 1934, a town in 1953. The city annexed it in December 61, making it part of Calgary's heritage and character. The 50s bungalows help keep the area alive. Please reconsider the rezoning of 26 40th Street for the height setbacks, parking noise, limited access, infrastructure area, and congestion. And for the character and the heritage reasons. Thank you for letting me speak and listen to me.
Thank you so much for being here with us. We'll go to Karen, then Doris after that. Do you need assistance with the overhead?
Oh, there it goes now. Should I do it the other way? Is that better for you? There we go. Thank you.
Good morning, Mayor and members of Council. My name is Karen Arndt, and I'm here today to speak on behalf of the Haysboro Community Association as Planning Director. I would like to first speak to item 7.3.1, the proposed bylaw 27P2026 and 28P2026. Haysboro urges Council to vote no to 27P2026 and end the grandfathering loophole. The entire process has been unfair to residents, and it is time for a clear ending to blanket rezoning. Grandfathering for RCG should only apply to developments that have completed the full planning and appeal process immediately. Properties with unresolved applications should not be included, and their zoning should revert back to RC1 and RC2. It only seems logical that if you have not completed a process completely, you do not get grandfathered RCG status. While we understand you cannot deal with each application in question in Haysboro here today, I would like to provide some context as to what the consequences our communities are experiencing. Currently, our community of Haysboro has observed an application receive approval without the comprehensive revisions and amendments typically expected during a thorough review process that seeks to uphold RCG rules. DP 2026-01810 for 79 Hillary Crescent Southwest is a clear example of what happens when the planning process is rushed. The plans for this application were inadequately reviewed from the outset. The approximately 200 letters of opposition were clearly not reviewed, nor were our questions addressed. As a result, the community association and residents are now compelled to scrutinize the plans and prepare for an appeal and rely on the SDAB to address issues that planning should have resolved during the process. As the planning director of Haysboro Community and having reviewed numerous applications over the past few years, I have never witnessed an application of this caliber proceed so rapidly without any amendments. Due to what I perceive as a lapse in planning ethics, the city is permitting a row house development that is inconsistent with the existing built form of the immediate area. The proposed development is situated at the end of an RC1 quiet crescent, and resembles a low-cost motel with 31 windows and a combination of 31 windows and doors facing the east property, which with no road in between, like there's a house right there, and 27 facing the west properties, which are all single home properties. This location is in the heart of our community. It is approximately 1,800 meters from the nearest LRT station. It is not on a major corridor, a transit-oriented node, a commercial street, or a mixed-use area, where places of larger developments are typically accepted, and Haysboro has accepted. We have 1,600 units coming into our community, no problem, in the appropriate area. This situation here reflects a failure to follow proper planning procedures, which is fundamentally unfair, and it is just one of the 247 cases that require attention in our city. By voting no to this bylaw would not prevent development. Applicants with unresolved proposals could still pursue their projects through the standard land use redesignation process, ensuring proper public process and that zoning is appropriate for the property. We also suggest to vote yes to the proposed bylaw 28P2026 to correct properties that were exempted in error or affected by the SDAB decisions. Thank you for your time.
Thank you so much for being with us. We'll go to Doris as our final panelist for the final panel before our lunch break.
Good morning, Mayor Farkas and members of council. My name is Doris Yaskew, and I'm here to ask you to revisit the zoning process, or as it was suggested yesterday, let's table it. Yesterday, on July 21st, 2026, I noticed how differently administration interpreted the message from council compared to what it was its original intent. I was under the assumption that by voting no to bylaw 27P 2026, 79 Hillary Crescent will be reverted to RC1 status. But now the path forward seems entirely unclear. It's my hope that we will have the opportunity to reverse the approval of DP 2026-018110 and stop a 6-unit row house that is completely out of place in our crescent. 79 Hillary Crescent is not your typical corner lot. It's surrounded by small bungalows, and the massive size of the proposed sixplex will cast a shadow over one of the most beautiful gardens in Haysboro, and entirely strip the neighbor to the east of their privacy. Beyond the immediate neighborhood, in fact, the submitted drawings are unacceptable. Furthermore, community members did not even have the opportunity to see if our submitted comments were incorporated before the project was approved. To summarize, I am asking that all properties assigned to RCG status under the Blanket Rezoning Initiative revert back to their original designation without exception and be re-examined carefully on a case-by-case basis. Taking this step will prevent overloading the SDAB with the wave of appeals that will inevitably follow if this bylaw passes. Finally, I want to highlight an issue of procedural fairness. A local renovator's website explicitly advertises to its clients, in quotes, "We handle the pre-application meeting with Calgary Planning Service on your behalf and return to you with a clear approval path and realistic timeline," end of quote. I wish every Calgarian had the same opportunity to hold pre-application meetings with the Calgary Planning, but we do not. We barely have enough time to read the proposals and submit our comments. You now have a critical opportunity to keep your campaign promises to the citizens of Calgary. I urge you to vote no on 27P 2026, vote yes on 28P 2026, and reverse the approval of DP 2026-01810. Thank you for your time and your consideration.
Thank you. We'll go to Councillor Clark for the panel, please.
Yeah, thank you. May I speak with Ms. Potter, please? Hello there.
Hi.
Thank you for coming. I just wanted to take a quick moment. I think it was likely described yesterday a number of times that, of course, regardless of the vote today, some of these projects will proceed because they've been approved. But so I just wanted to make sure that that was said again, sadly. But I wanted to also just acknowledge you. I know that you were here all day yesterday. You spent the whole day with us. And you've waited patiently for your chance to speak. And I just want to acknowledge, thank you for coming from your community and doing that on behalf of your neighbors. There's a number of communities here that are very well represented, and some of our communities are less represented overall in conversations like this. So I just really appreciate that. And of course, my office is open to you and your neighbors. I'm here for you.
Thank you.
Thank you very much.
For having me.
Thank you. That concludes the panel. Colleagues, let's come back at 1:50. Welcome back to Calgary City Council. Madam Clerk, please call the roll.
Thank you, Mayor. On the roll, Councillor Ward. Councillor Wyness. Councillor Ewell.
Here.
Councillor Atkinson. Councillor Chabot.
Present.
Councillor Clark. Present. Councillor Dollywall. Councillor Jameson.
Present.
Councillor Johnston.
Here.
Councillor Kelly.
Present.
Councillor McLean.
Here.
Councillor Pantazopoulos. Councillor Schmidt. Councillor Tyers. Here. And Mayor Farkas.
Here.
Thank you, Mayor.
All right, we are continuing our public hearing for 27P 2026. I'm going to start from 0 on the registered speakers list. Do we have Christina Provencher with us? Darcy Dean? Zhejiang? Autumn Malsbury-Boag? Brianne Reed? Doug McFadden? Kimberly Coots?
Hi, Autumn Malsbury is here.
Autumn, is that you?
Yes, Autumn Malsbury-Boag, sorry.
Thanks, Autumn, please stand by. Do we have Jennifer Huol-Famakinde? Frank Stewart? It sounds like somebody on the line is not muted. Please double check that your devices are muted. Do we have Elizabeth Burke? Come on down, Elizabeth. Do we have Sally Haggis? Come on down, Sally. Joni? Jennifer Baldwin? Les Burton? Les, come on down. Great, so that'll be Autumn, then Elizabeth, then Sally, then Joni, then Les. Autumn, please go ahead. You have 5 minutes with us.
Okay, thank you. I wish I could be there in person to speak today, but for those of us who are not directly involved in the development industry or employed by the city, it's pretty impossible to time a guesstimated timing to speak at a hearing with our busy lives. It's incredibly confusing and misleading, and if councillors don't understand the need to appeal before this deadline, then how is the public expected to understand? How are neighbors even aware there has been an application for a zoning exemption that would impact them that they might want to appeal? I assume this grace period applied to builds that were already in progress, not to secure for future use. As a homeowner in Lake Bonavista, I was incredibly upset to only hear at the last second to submit comments to this hearing. I didn't even know about this hearing actually, but found out about an improved subdivision application and a requested exemption from the repeal. It is completely unacceptable that none of this has shown up on the DMAP. The file manager claims it was circulated to the councillor's office and community association on March 19th. However, none of this info made its way to the community, and it occurred during the repeal hearing, so it would be easy to go unnoticed. Without notification, this has given neighbors in the community no time to find out the details of the subdivision application or plan development to assess and provide appropriate feedback or raise concerns. In fact, we aren't even able to access the details of the subdivision application. I'm told it can only be provided to the applicant and government bodies. 311 has told people this info is on the DMAP, and it is not, despite the drop-down boxes existing for subdivision applications, which would make you feel safe if nothing shows up there, right? Development and planning told me it's at the discretion of the file manager, but the file manager told me these never go on the DMAP. There are a lot of issues with our 1970s water and sewer systems here. Has the increased demand placed by these multiple units on this age system been appropriately studied? Has parking and traffic been assessed? How about shading of the neighbors' properties? No, it hasn't, because a DP hasn't even been submitted yet. But rumors have it at 16 to 20 units over 2 side-by-side lots. And these 2 lots show nothing on the DMAP. How is it even possible to secure a zoning exemption to RCG, HGO, whatever it might be, with no DP submitted? And why does the list of 247 properties list these properties as approved on their permit status? This is 1223 Lake Bonavista Drive and 1227 Lake Bonavista Drive I'm specifically referring to. not right. These developments will be severely out of context with the neighborhood and surrounding properties and not what residents and owners want here. We voted for a mayor and councillor who promised to repeal blanket upzoning and return Lake Bonavista to RC1 zoning status. They both won, yet somehow there are exemptions being offered that completely negate this repeal. I know the owners of these properties have worked and are possibly still working in the City of Calgary planning offices. One of them was a major proponent of the blanket upzoning before the public had even heard of it, and I guess this is why. They know the systems and people involved and how to avoid having the neighborhood find out about this until it's too late. This is a major conflict of interest and unfair advantage to the owners and developers versus the community. I request that council denies the exemption for the properties and that these properties immediately revert back to RC1 zoning in accordance with the bylaw. I would also like the approval of the subdivision to be reconsidered given the lack of notice and information to the community, as there was no chance for neighbors to file an appeal to the SDAB. Additionally, I would request that council review the process and requirements for notification of subdivision applications and votes no on 27P2026 and yes on 28P2026. And a final question, why is reputational risk or procedural fairness to developers a bigger concern than reputational risk and procedural fairness to all citizens of Calgary who vote for and pay the salaries of council and city administration? Thank you.
Thank you so much. We'll go now to Elizabeth, then Sally after that.
Good afternoon, Mayor Farkas and councillors. It's nice to see you again. I was here yesterday for 11 hours off and on through the council chambers to present for 5 minutes today. What am I, crazy? Well, yes, I am crazy, and in a very good way. I'm actually kind and considerate, but crazy about my neighborhood, passionate about my neighborhood. Our community is Haysboro, as I said. I haven't said, yes I did. It is a community I am proud of. It's got the baby boom era, and we have a strong council. You've heard from my friend Karen, who's on our planning. I'm here again because it's time for the citizens of Calgary to take back our community from horrendous developers who create environmental hotspots in the community with no grass or trees with these developments. With the last council, we were all deceived that blanket rezoning was the answer to affordable housing. It is not affordable housing. They charge as much as a single family home for one little unit. But it sure makes the developers wealthy and changes the look of our traditional communities, which I am not happy about. I am here to ask Council to vote no to proposed bylaw 27P2026 and vote yes to proposed bylaw 28P2026. Applicants knew that blanket rezoning was under review and submitted their applications before April 8th while Council was considering repeal. Some applications were submitted after the first reading entered the process while Council had already voted to end blanket rezoning. Developers routinely assume the risk that planning rules may change. The risk should not be converted into a public obligation to preserve the former zoning for incomplete applications. Regarding 27P, Council should vote no. Properties supported only by unresolved applications should not be included and should have had their zoning revert back to RC1 and RC2. Administration has already acknowledged errors requiring correction through bylaw 28P 2026. Approximately 41 properties were previously exempted, even though the required council-approved land use redesignation had not occurred, and other properties must be corrected because development approvals were overturned by SDAB. Council should vote yes to bylaw 28P 2026, but these acknowledged errors are also a reason not to approve another board exemption list without complete information. Residents should not have to correct planning problems one appeal at a time. SDAB cannot consistently recreate the full review that should have occurred during the development permit process. Council should correct the underlying policy rather than transfer the financial and technical burden of quality control onto neighboring residents. The public deserves a fair process, not special treatment for unresolved application. Residents were entitled to clear rules, reliable deadlines, and planning process applied consistently to everyone. Instead, the grandfathering terms kept changing while unresolved applications were given additional opportunities to preserve RCG zoning. Applicants who have not completed the full permit process do not have established rights that require council to vote on their behalf. The public should not carry the consequences of unclear transition simply so those applications can keep moving forward under the former rules. Council should protect completed permits while requiring unresolved applications to follow the same updated land use that applies to everyone. Another concern I have is that we have neighbors in Haysboro who have been paying their taxes. One is on Hillary Crescent, directly across from 79. She is 97 years old and would like to die in her house, and she doesn't want to look at that piece of equipment across the street that they want to build. She's paid her taxes for 50 years. The developer has paid for 4 or 5 months since they purchased the property. At what point is the ownership of these homes, the neighbors, the communities, more important than a developer? Thank you for your time.
Thank you so much for being here with us. We'll go now to Sally, then Joni after that.
Good afternoon, Mayor Farkas and members of council. My name is Sally Haggis. I live at 1012 89th Avenue, which is right next door to 1008 89th, which is one of the properties on the exemption list. This is in Ward 12. So I live 3 doors in from Elbow Drive. 89th Avenue is the only set of lights on Elbow Drive between Heritage and Southland Drives and functions as a major entrance and exit for West Haysboro. Our Community Association building, Haysboro Elementary School, and a major playground are also on 89th Avenue and is a traffic route for school buses from 2 other schools from 96th Avenue. I'm here today because I feel like the city has targeted our community, our street, and our house directly with this blanket rezoning, and even though it's been repealed, we're left to suffer some of the decisions that have been made. But that said, really the reason I'm here is mostly concern for safety, and that's why I put up the map to show you that intersection of Elbow Drive and 89th Avenue. I call this the City of Calgary triple whammy, and I thought I might be unique in this triple whammy, but Mr. Urban this morning had the same thing, where he had these multi-family buildings put up on all 3 sides of him. First of all, there's a daycare that was approved back in 2020 on Elbow Drive, right on the corner. And it was approved for 32 children, and then somehow that crept up to 52 children, and now it's up to 72 children. This application was put in the year 2020, and it still has not opened. So we have no idea what kind of effect this will have on our little neighborhood there in that intersection, but it's bound to have some effect for sure. Second of all, at 1007, 89th Avenue, which is directly across from 1008. The house there has been demolished. It was approved for an HGO and 10 units. And so we are concerned with the parking issues that's going to create, even though there's 5 parking stalls. We also think that the cars will stack up on Hollyburn Road and along 89th Avenue as well. And I fear for the pedestrians. There's a lot of families that live in Hayes Farm that use that intersection to walk their kids to school. And then thirdly, the 1009 or 1008, which is right next door to us. It's been approved for 2 buildings, 9 units. So that's 19 units, right in my neck of the woods, which could generate up to 32 cars, and that doesn't even include the daycare and the amount of traffic that's going to create. I understand the need for affordable housing. I understand the urgency to get it built, but I just think these projects need to be thought through better. I understand that's why many of you were elected, but I wish that there was sort of a gentler density transition where we go to fourplexes or duplexes. I also have some concerns for the planning department and city administration, and I say this with all due respect, but I think we've heard many, many times over the last 2 days, people who were not informed properly about things. There seems to be a communication problem, and the rules keep changing, and we're not sure who we should be talking to or who we should call. As you could tell from the people in the audience today, Haysborough's pretty lucky to have a group of very devoted volunteers that look at the DMAP every day and keep us abreast of what's happening in Haysborough. I don't know how other communities manage. We're very fortunate. There's also, I also have concerns about quality control when these development permits are sent out, that there's errors and omissions, which takes up a lot of time. And then, I don't know, I've heard this from other people over the last couple of days as well, that we need interpreters or bylaw translators to help us out. Density is good, but this is just too much. Thank you for your time today.
Thank you so much for being here with us. We'll go to Joni now and then Les after that.
Okay. Good afternoon, Mayor and Council. Did you read the email that I sent you all last weekend? Yesterday, I was very surprised to find out that Councillor Chabot noted that his amendment for exemptions appeared to be misinterpreted by administration. Then we heard how administration appears to like to send out notices that Calgarians would consider very important at inconvenient times, like just before long weekends and the Calgary Stampede. There appears to be a lack of integrity here. Let's make sure that doesn't happen again. And speaking of administration, why aren't they here today? Council needs to vote no.
I'm gonna just jump in and say that as a regular course of our meeting as a city council, administration is present.
Okay.
So I try not to interject on a factual basis, but I want to make it very clear to you as a member of the public as well as folks watching. It's not just the elected officials here.
Okay, thank you. Council needs to vote no to proposed bylaw 27P2/2026. It must correct a serious procedural breakdown created by a transition process that has neither a clear application entry deadline nor a clear application completion deadline. Council intended to create an orderly transition away from blanket rezoning. What happened instead was a race to preserve it for applications already in the system. Planners were given a substantial queue, a fixed deadline, and a process in which the permanent zoning treatment of a property depended upon obtaining an approval. Communities are now seeing applications approved without the usual revisions and amendments that come from proper reviews. This allows the consequences of blanket rezoning even though council voted to repeal it. End the grandfathering process of blanket rezoning, vote no to 27P/2026. As for bylaw 28P/2026, administration has already acknowledged errors requiring correction. Approximately 41 properties were previously exempted despite not having received a required council-approved land use redesignation. In addition, other properties must be corrected because their development approvals were overturned by the SDAB. Therefore, vote yes to proposed bylaw 28P/2026 to correct the acknowledged errors in properties affected by SDAB decisions. So, reputational problems. It becomes a reputational risk if we listen to the truth and neglect to do something to correct the problems that we now have. And we have them. We talk about 247 properties. Well, they affect people. Let's not forget, you don't have a city without people. People do matter. And it doesn't matter what you do, whether you're an administration or whether you're a politician or just a worker or a guard out there working for City Hall. This is all about people. I don't personally, and my neighbors don't personally, have these problems. I live in Edgemont. None of my neighbors, I don't have these problems that people have talked about these last 1.5 days. But I totally and empathetically understand the pain and the frustration and the anger that they feel. I don't have to be in their position. So please do the right thing, and your reputation will be restored. Thank you very much for listening.
Thank you so much. We'll go to Les as our final panelist.
Good afternoon. Les Burton from Albert Park, Radisson Heights. I am on the board, but I'm not here as a board member. I'm here as a resident. My grandmother and grandfather had 10 kids raised on 9th Avenue in Albert Park, and they farmed in Albert Park many, many years ago. Now, Albert Park is changing big time. Not for the better. The low-income housing and the affordable housing isn't affordable. After I've listened to so many people talk, everyone seems to say the same thing. It's not affordable. It's not better for the community. We've got a 4-inch sewer line, but you want to put residents and more big builds with 8 units on top of one another. My neighbor was talking earlier about 2542 10th Avenue Southeast. This house, when it's built, the garage is going to be back on the 0 property line with 8 units. Where are the cars going to park? Heaven forbid if we have a snow ban, because that won't, the back alleys aren't big enough or wide enough to put all the cars. On 11th Avenue, there's a unit that houses 22 units. Where do you put the cars for that? With the basement suites renting for $1,500, that's not affordable. And the sad thing is that the city's changing. Most people, I would suspect that they could understand if you take a 50-foot lot and make a side-by-side and maybe a garage on top or a unit on top of a garage, they could handle that. But putting 8 units on one 50-foot lot, where do the kids play in the backyard? There is no backyard. You have 8 people, possibly 8 dogs. Where do the dogs go to the washroom? So I ask that you do repeal and say no to 27P. Everyone here has spent hours to talk in front of you. And it's like we're not being heard. We've gone to the engagements that the city has. I haven't had a developer come to the community and say, hey, we want to build a 4-plex or an 8-plex in your neighborhood. There's no engagement with the community. That's with Albert Park. So I ask you to do the right thing. Thank you.
Thank you so much for being here with us. Over to Councillor Schmidt, please.
Thank you. Ms. Bork, I just wanted to clarify, you mentioned go back to traditional communities, I think. What is a traditional community? You used the word traditional at some point.
What I'd like to point out is the communities were designed in the 50s. Hayesboro is 1958-59. It was designed with a plan. It was a community plan. And traditional for that was 58, 59 was single-family homes, grassy areas for kids to play on, your gardens, your yards, school grounds, everything. Traditional is back to the way it was in the time that it was developed. A community in the city of Calgary that I really enjoy, which is a community by Jamin, is Mahogany. It was designed that way. They have apartments across the street from the homes. They've got townhouses lined up on this massive green belt. You don't have to have a backyard when you back onto that or you're just the next home over. That's a traditional look for that era. Traditional is the time that it was first planned.
So, I mean, at which point should we, when we're thinking about this, because, I mean, I think back to, you know, there's a great exhibit at Heritage Park about the sod houses that we had here, first in Calgary, and then sandstone houses. So as policymakers, how do you suggest we make a decision about when to sort of freeze a neighborhood in time?
I think in Haysboro, we're not fighting densification, we're fighting the kind of densification that's coming in. If this builder on 79 Hillary Crescent decided to do a duplex, which Haysboro has no duplexes at this time, we would be fully in where, but we'd like it to have the sort of same lines as the roofs that we have, not flat roofs like the this thing here is just straight across the top, flat. And we're looking for just something to keep the character of the community. It can even be a fourplex. If you drive down Elbow Drive just before the Kingsland Shopping Center by Henry Wisewood High School, there's a fourplex. It is stunning, just stunning. Front yard, rock in the area, front fence, and 4 units. Stunning, same. It fits right into the neighborhood. That's what I'm talking about, traditional. My dad was a carpenter from Holland, and he said, there's a reason why we design homes with angles on them, to get the water away from the home, to get it away from the foundation. So when you do these flat roof things, good luck. With our Chinooks that melt the snow, and with the rain we had this past June, yeah, where's the water? Is it inside? Is it in your basement? It's somewhere, because it's not flowing away from that property. That's traditional.
Duplexes and fourplexes, traditional roofs, that's a good way for us to go citywide.
Yes, so it looks like it was part of the neighborhood. We don't have a problem with that. But these flat roofs and 8 or 6 units on Hillary, I'm sorry. Where do you put all the 18 bins that are recycle and garbage? Where did they go?
So, I mean, if you look at the historical map of Calgary as well, downtown at one point was single-family homes.
Yep.
So, was that the wrong decision for
Not
us
at
to
the
create
time,
the Beltline?
but if you look at Mission and Cliff Bungalow, they kept the traditional look of some of the homes, and now they're tearing them down for apartments, some of them. Like, my son is on 21st Street. He's in a 5-story apartment building right next door, 4 rows in a house, 4 homes in a row on his 21st Street, and they're stunning. They're beautiful. But that is downtown now. We're still not downtown. Haysboro's not downtown.
Okay, thank you. Ms. Liu, you just mentioned there being a lack of integrity here.
Mm-hmm.
Where are we missing the integrity?
Well, I mean, I heard several people talking about the fact that notices are sent out. I mean, one instance was when it was sent out just before the May long weekend, or just as Stampede was happening. And these are busy times. People are planning their lives to have a good time. They don't really want to be dealing with things that are of a serious matter. So I'm saying that timing should be very important to administration, because you just can't help but feel that you're being manipulated.
So I just want to be clear for just the sake of what happened was this was council direction for us to be here and for this process to be undertaken today, not administrative direction. Just so you understand sort of how we got to this point, this was advertised and part of what we voted on during the rezoning hearing, and that was part of the council-directed motion that was put forward. So.
Okay, then could you do things in a more timely manner than that?
We can't in this case because of the restrictions in the Municipal Government Act for advertising periods for bylaws. So, I mean,
the fact is they were supposed to return in July with a report, and that's been delayed to December. So who's responsible for that?
That is a separate
yeah, it will be a separate thing
from where we are here today. So just to be clear that this was all advertised and based on council direction.
How long ago?
During the original rezoning hearing.
How long ago?
would have been in March, April. But I appreciate that clarity, that helps. So thank you. And then Mr. Burton, you mentioned that one thing that you saw as a solution was backyard suites, building on top of a garage.
Yes.
So do you know, the final item we have on this hearing is to make those, to restrict some of the red tape, or to eliminate some of the red tape in building those. So is that something, it's not what's before us right now, but you raised it just because it's on today's hearing. So do you think eliminating red tape for backyard suites is an elegant solution for us?
It's a part of the solution. Talking about 2542, that they want to do that as well, it's overpopulated. The setback on 2542 is 3 meters. So now, in the middle of the 10th Avenue, this new build is going to stick out in front of all the other houses. So right now, on my front grass, when the stampede's going on, I can enjoy the fireworks. You allow that to happen, I'm not going to be able to enjoy that. And so it wrecks the view. It wrecks the view of the whole street. And that's not just on my street. It's on probably all of these other people's street too. You go to 11th Avenue and there's 22 units there. They're doing the same thing on the list on 9th Avenue. So even if those 22 people or 22 units have one car, but you allow for 6 parking stalls, right? And furthermore, and this isn't on this agenda, but Franklin LRT, the parking lot's closing.
But getting us back to backyard suites, good
Correct. Solution. Correct. Yes.
Yeah, I'll chalk that up.
If you have a backyard suite on top of a garage, and no basement suites, sure.
So, I mean, I would perhaps suggest I'll chalk that up as a message of support for item 7.3.3 later in this hearing, but there's an opportunity to speak in favor of that today, or at some point in this hearing as well. So I appreciate that. Thank you. Those are my questions.
I'm going to just make a request of council members. I think it's fair enough if the members of the public want to deviate a little bit away from which specific item we're on, but perhaps we can exercise some restraint and not ask them to do so. Okay. All right, Councillor Clark, please.
Mr. Burton, would you join us again? Come on, you're Mike Ward. I got to say hello.
Hello.
I just wanted to clarify, if you could, you came to speak to a particular item, right? Like a particular address?
Yeah.
Do you mind repeating that for me so I can write it down?
2542 10th Avenue. It's on the list. 9th Avenue. There's five addresses on our list. The ones on 9th Avenue, once again, they want to put 22 units.
Yeah.
How is that good for the community? Right? You guys are in power of creating new communities. Do the high densification in the new communities. Extend the LRT, right? Hey. But you know this as my counselor about how sore I am about the Franklin LRT station. And I know it has nothing to do with this, but really it does. Because we've lost 2 schools to development, right?
Right.
And now we've got 376 new units coming in. We've got Onward Homes. That's 376. We've got Attainable Homes. That's 200 units plus basement suites, plus the Albert Park Station. Where do we put the kids in the schools? And when I asked the planner of the city of Calgary, David, that, he said, that's not a city issue. That's not a planning issue.
Yeah.
But yesterday it was. So where's the disconnect?
Can I ask you, you'd opened your preamble or your initial 5 minutes with like the story of your family in the neighborhood. So you've spent your whole life there, hey?
Pretty close, yeah.
Can I just ask, and I won't try to get too far off topic here, but so did this all start with blanket rezoning? Like the pressures, the concerns, the lack of trust, the lack of engagement, the lack of understanding? Did it start then, or like, can you just give me you have the experience to deliver sort of a good sense of...
engagement after engagement, city engagement. We've all come to the community and put our Post-it notes up on the boards. If we're in favor, if we're not in favor. This place should be packed, but people are tired. Right? People are tired because they spent 11 hours yesterday that they weren't heard, right? They spent their whole day. They didn't get paid for it. And it's frustrating because when you go to the engagements and you volunteer in your community and you're not being heard, right? We're one of Calgary's oldest communities. We've got a 4-inch sewer line and you want to put all this new development. 7 o'clock, everyone has a shower, goes to the washroom. What's that going to do to our system? Our sewer system went down on 10th Avenue last year, and the blacktop still hasn't been done.
One of the undertones of what I think I'm hearing you say is that, you know, it almost feels like it comes at the expense of the existing community.
Sure it does.
These kinds of developments. Very good. Thank you for your time.
Thank you.
Okay, that concludes this panel. So we will work on building the next panel. Do we have Saeed Bashi with us? Christina Provencher? Darcy Dean? Zhi Zhang?
Hello, I'm on the line.
Sorry, who is speaking just now?
This is Shelley.
Sorry, Shelley, I haven't called your name yet. We're just going in the order of registered speakers, so if you're...
Sure, I'm happy to speak if there's an available spot. Thank you.
Okay. Do we have Brianne Reed with us? Doug McFadden? Kimberly Coots? Jennifer Huol-Famakinde? Frank Stewart? Jennifer Baldwin? Christopher Davis? You're up. Leslie Farrar?
Sorry, who is speaking just now?
Patricia Morton?
Sorry, Shelley, I haven't called your name yet.
Everyone please mute on the line because the phone bridge is quite delayed, or rather a phone bridge is current, whereas the online webcast is delayed. Do we have Patricia Morton with us? Cindy Robinson? Jamie Walduber?
Yes, I'm here.
Is that you, Jamie?
Yes,
Okay, please stand by.
this is Jamie.
Do we have Henry Engelking?
Yes, online.
Thank you, Henry. Please stand by.
Leslie Farrar?
Do we have Deborah Teitelbaum?
Patricia Morton?
Anne Livesley Huzak?
Everyone please mute on the line because the...
Owen Reader?
Anne is here.
Sorry, Anne, was that you?
Yes, that is.
Okay, Anne, please stand by. Or it's critical for everybody who is on the line, please make sure that you're muted. We're getting some feedback here in the chamber. We need absolutely everybody muted. Okay, so our next panel is Christopher, then Leslie, then Jamie, then Henry, then Anne. Christopher, would you like to start us off?
Just give me a moment, Your Worship. Good afternoon, Your Worship, members of council. It's always a pleasure to be here again. And council's going through this public hearing process again. So where are we? How do we get here? December 15th, 2 months after the election, a pretty new council was asked to take this on. And you set out 3 parameters for exceptions. One where it was approved prior to the effective date of the amending bylaw, which we eventually found out was going to be August 4th. where a matter was submitted prior to first reading of the amending bylaw, and then finally where subject to an approved applicant-initiated land use redesignation after August 6, 2024. Gosh, wouldn't it have been easier if we just repealed and been done with it? But here we are, and I don't know that we can fix those decisions because frankly, they were made by this council subsequent on April 8th with bylaw, I think it was 9P 2026, and that's led us to today. I was surprised when we were here in April, administration in attachment 7 said, we're coming back. We're going to have more changes. So let's be clear. What's before you today is that we've already got the repeal, and 247 owners are saying, please let us be accepted out of what you've already done. So to be quick, it's not great. It's the summer. I do have some prepared remarks. I'm part of the Calgarians for Thoughtful Growth. Most of them are thoughtfully not here, and some of them will be coming later. We've submitted material previously. We do have, I'm a lawyer. I'm not here giving you a legal opinion or legal advice. I'm here to say, as a citizen, what's the process? How do we get here? And what's fair? And we've got 3 items, 5 bylaws. I'd like to touch on all of them because the mayor has said there's some deviation, but I'm here today, right now, to just talk about the first item, 7.3.1. And we're here to reflect on the fact that there's no entitlement to zoning. The same way that council upzoned 2 years ago, council can downzone today. And I appreciate that there will be some people who've made decisions based on what they think council was going to do, but there's no entitlements. And frankly, those are business decisions that come with risk. At the end of the day, the Alberta Court of King's Bench and the Lahode and Calgary decisions said it's entirely lawful to do what Calgary did when they did the upzoning. Conversely, it's entirely lawful to go the other route backwards. And yes, I think as Guy Buchanan might have said yesterday, it's possible that somebody might threaten a lawsuit, but I frankly don't think it's going to be successful. The case law doesn't seem to go that way. So I encourage council to think about asking questions today. I can tell you about my lived experience at the SDAB and what you're currently seeing now at the SDAB in terms of results, because 2 years ago, council said, don't worry, you'll have your day in court or at the SDAB on these discretionary applications. And I can tell you that only about 10%, maybe, are being overturned. And they're great decisions, they're well thought out. They've been challenged. In one case on July 3rd, the Court of Appeal said, no, you're going to have to be a little more specific, SDAB, on your rationale. You can't just say this was not contextually respectful. That's how detailed it's getting in dealing with these intrusions. And I can tell you, as a non-affected individual representing community members who are going in with their bungalows trying to deal with a solid wall of 2 to 3 stories right next to them, cutting out the sunlight, blocking views, and putting them in shadow, and the SDAB still saying, it's okay. It's discretionary. We looked at it all, and cumulatively, we're okay. Maybe just put a couple of columnar trees in here, and that might help. Maybe frost the window over here. I don't think it's good enough, and I think council, if you think that this is being solved at the appeal board level, it's not. So back to you. I'm available for questions when and if it's appropriate. I can answer questions about process, about perhaps how it could have been done better, and also about lack of engagement on the entire question of 75 units per hectare to 60, communities, no involvement. FCC, maybe, but the industry was involved, the communities were not. And yet, here we are today with administration saying, we don't recommend this. Why? Because it's uneconomic. So happy to talk about that too. I think my time is up. It says here in red. Thank you, council. Always tough decisions, and pleased to be here.
Thank you. We'll go to Leslie, then Jamie after that.
mask going to drop? Good afternoon, Mayor Farkas and members of council. My name is Leslie Farrar, and I'm speaking on behalf of the Palliser Bayview Pump Hill Community Association. Our community association is opposed to blanket grandfathering provisions in principle. Our concern is that this bylaw will automatically extend grandfathering protections to applications where significant questions remain regarding process, transparency, and public confidence. One such application is DP 2026-00947, 9427 Palliser Place, Southwest. This application has generated significant community concern. Residents have identified unresolved issues relating to traffic, school safety, lane and utility access, sightlines, parking, drainage, excessive site coverage, shadowing, neighborhood compatibility, and massing. Those planning concerns remain unresolved. However, today we want to focus on something even more fundamental, the integrity of the planning process. The owner of this property is a city administration employee, an active realtor, and a private developer with multiple development applications in Calgary. We are not asking council to determine whether a formal conflict of interest exists. We are asking you to recognize that this situation creates a legitimate appearance of conflict of interest that demands the highest standards of transparency and procedural fairness. Public confidence depends not only on the absence of wrongdoing, but on the absence of circumstances that reasonably call impartiality into question. Unfortunately, that standard was not met. Despite extensive communication between administration and the application regarding the exemption process, the Community Association received no notice that this application was being considered for grandfathering. We learned about it from a neighboring resident. Many residents who had previously submitted comments on the development permit also received no notification that council would be considering legislation that could materially affect this application. Residents participated in good faith. The Community Association participated in good faith. Yet when the rules changed, those most affected were effectively excluded from the process. That is not meaningful public engagement. There is another concern that extends beyond this single application. As council considers grandfathering dozens of development applications, you are not told how many public objections each application received. You are not told whether the Community Association supported or opposed the application. You are not told whether significant planning issues remain unresolved. You are not told whether concerns regarding procedural fairness or the conflict of interest have been raised. Those concerns become invisible at this stage in the process. Every application appears as just another file. DP 2026-00947 is not just another file. It has generated extensive public concern, significant planning objections, and serious questions regarding transparency and procedural fairness. Yet none of that is visible to council as you consider granting it additional statutory protection. Grandfathering provisions are intended to provide fairness during legislative transition. They should not be used to shield controversial applications from further scrutiny or to protect applications where affected stakeholders were denied a fair opportunity to participate. Accordingly, the Palliser Bayview Pump Hill Community Association requests that council remove DP 2026 from the grandfathering provisions bylaw at stake here. If council is unwilling to do so, we ask that this application receive an individual review before any transitional protection is granted. We also ask council to require administration to disclose for every application proposed for grandfathering the level of participation, the community association positions, and any outstanding procedural fairness concerns so that council can make fully informed decisions. Mayor and councillors, this request is not about preventing development. It's about ensuring that transparency, accountability, and public confidence remain at the heart of Calgary's planning process. I would appreciate a question on community involvement. Thank you.
Thank you. We'll go next to Jamie, please.
Yes. Hi. Hello, Mayor and Council. My name is Jamie, and I have proudly called Haysboro Ward 11 home for many years. I appreciate the opportunity to speak with you today. I am here because I believe the people who live in our neighborhoods deserve to have confidence that growth happens through a process that is fair, transparent, and respects the voices of the people who call these communities home. Many of us have spent countless hours trying to understand planning policies, attending meetings, reading reports, and participating in public engagement because we care deeply about our community. What has been most disappointing isn't the possibility of new development. Growth is a part of every city, but growth should be properly planned, thoughtfully considered, and designed to fit the character and context of the neighborhoods where it occurs. Good planning should always serve the long-term interests of the community, not just today's development applications. Instead, many residents feel the rules keep changing, decisions are being rushed, and it is becoming increasingly difficult to understand how those decisions are being made. One property in Haysboro, 79 Hillary Crescent, has received a great deal of attention, but this is not about one address. There are several developments across our community, and this issue extends beyond Haysboro to neighborhoods throughout Calgary. This is about the process. I don't believe council should be asked to approve hundreds of properties all at once without having the opportunity to properly review each one individually. One of the things I've struggled with most throughout this process is the feeling that developers seem to have greater access to administration than the residents who will actually live beside these developments. Residents attend open houses, submit letters, volunteer their time, and participate because we care about our communities. We simply want to know that our voices matter too. Blanket rezoning already removed many opportunities for residents to participate in decisions that directly affect their neighborhoods. As council considers these policy changes, I respectfully ask that public participation not continue to be diminished. The policies that govern our communities should ultimately reflect the people who elected you, not simply the recommendations of administration. Council was elected to represent Calgarians and to ensure development is carried out responsibly, transparently, and in a way that benefits communities for generations to come. I respectfully ask that you vote no on bylaw 27P2026 and require administration to return with a transparent parcel-by-parcel review, and yes to 28P2026 with correct acknowledged errors in current exemption list. Residents should never feel that they have to become planning experts or spend thousands of dollars appealing a development just to ensure the rules are followed. Good planning isn't just about what gets built. It's about building the right projects in the right places through a process that public can trust. It's about creating development that complements existing neighborhoods, respects the people who already live there, and serves the long-term interests of Calgary. Please choose transparency. Please choose fairness. Please choose a planning process that earns the confidence of people you're elected to serve. Thank you for your time and for listening.
Thank you. We'll now go to Henry, then Ann after that.
Good afternoon, Mayor Farkas and councillors. I think I've been listening for 2 days now, and the longer I listen, the more I need to update this talk I'm about to give you, but bear with me. I'm speaking on behalf of myself and my wife, Leslie. We are owners at 39 Hillary Crescent.
Can I speak to your grandma?
I'm here. Some folks are trying to talk over you, Henry. So let's make sure everybody. We need an amazing grandma to mute.
Okay, I'm here today to strongly object to the proposed development 79 Hillary Crescent, which is located across the alley from 39 Hillary Crescent, our home. The proposed development is a 6-unit, 3-story, 10-meter or 36 feet tall rectangular block on a crescent of bungalows. After listening to the long list of objections from the homeowners on Tuesday and today, it is apparent that there are a large percentage of Calgary homeowners that have strong objections to the proposed approved developments. There are several common objections which I share, which including excessively large, tall buildings compared to the existing homes, no common architectural features with the neighborhood's significant increase in parked cars and traffic shadowing of existing homes, demand on existing infrastructure, and safety concerns. I also heard from the city planners that no approvals were rushed, no corners were cut, and everything has been approved only after thorough review. Given the testimonies above on Tuesday and today from the numerous homeowners with major objections to the developments, I have to ask, why is there such an obvious gap between the homeowners and the city planning group? How could these gaps exist if the developments were thoroughly reviewed, and in the case of 79 Hillary Crescent, not a single revision or amendment to the application? The development permit has been approved for 79 Hillary Crescent, and it is included in the exemption. The discussion and statements from the city's planners yesterday led me to understand that once a permit is approved, there is nothing that can be done to stop the approved development from proceeding. However, there was no discussion of the other options available to residents of Hillary Crescent to have a development permit voided, which is, I understand, includes the appealing process through the SDBA, and should the appeal process fail, legal action. I just heard that doesn't have great results, but I believe, are these not legitimate options? Another concern raised was that the reputation of the City of Calgary would be diminished should Council decide to take action to address the legitimate concerns raised by residents in these meetings. What about the diminished reputation of Calgary? Should these developments be allowed to proceed? Should the focus be correcting the more significant error of allowing blanket rezoning in the first place, which affects thousands of residents, rather than the limited impact to the correction of the inappropriate approval of development permits? My wife and I support properly planned development that increase the density to address the housing need. However, it must be fair to existing residents. Frankly, approving the developments described in these meetings is hard to understand and will lead to long-term repercussions to the City of Calgary. In summary, I believe that you have heard very thoroughly, and I don't know what more can be said, how the residents of Calgary feel about these developments. So I hope you guys do the right thing and vote no to proposed bylaw 27P and vote yes to bylaw 28P. And over.
Thank you so much. We'll go now to Anne.
Good afternoon, Mayor Farkas and members of City Council. First off, I'd like to mention that my neighbor, Deborah Teitelbaum, was called and somehow there was a disconnect and she was not able to get on, but she's also here.
We'll be continuing to call the names of folks missed from the start for each panel.
Okay, thank you so much. So again, my name is Anne Livesey-Husak. I'm an owner at 9411 Palliser Place Southwest. I'm speaking on behalf of myself and my husband, Merv, regarding our objection to the proposed exemption under bylaw 27P 2026, 2427 Palliser Place Southwest, as spoken to yesterday also by my neighbor, Louis Gittleman. Council recently made the significant policy decision to repeal citywide blanket rezoning. We understand that bylaw 27P 2026 establishes the limited circumstances under which certain properties may be exempted from that repeal. Council's decision to repeal blanket rezoning reflected a clear desire to restore greater public confidence, transparency, and context-sensitive planning to Calgary's development process. The Palliser community should enjoy the benefit of Council's thoughtful decision to repeal the blanket rezoning and not be subject to past poor judgment with respect to zoning. This development proposal in Palliser is a good example of why blanket rezoning does not and did not work. We especially object to the inclusion of 2427 Palliser Place Southwest within the list of properties proposed to retain their post-2024 land use designation under bylaw 27P 2026, and submit that 2427 Palliser Place should not receive the exemption. This development application has become a source of considerable concern for our community and resulted in over 260 submissions from residents to City Council opposing the development, detailing issues relating to neighborhood context, environmental impacts, safety, transportation, and most significantly, and as I've heard for the last 2 days, lack of community engagement. These concerns include the proposed development intensity on a single residential parcel of a 4-unit row house plus 4 secondary suites, resulting in up to 8 dwelling units. And this does not fit with the design and character of any of the single-family homes on our cul-de-sac or on neighboring streets. Palliser Place is a small cul-de-sac that currently consists of 14 houses, including 6 two-stories, 4 split levels, and 4 bungalows, on lots ranging from 6,485 square meters to 12,880 square meters.
We're going to pause here for a moment, and let's make sure everybody's muted, although it looks like we may have been put on hold by somebody who is on the stream.
Anne is here. I am not on hold.
Yeah.
Hello? Hello?
We can hear you, Anne. Continue.
Okay, I can't hear you. That's fine. Thank you. I was mentioning that the lot that this proposed 8-plex is to be on is actually the smallest lot on the cul-de-sac, 25% smaller than the average lot size. The estimated mass and volume of the proposed development is roughly 60% greater than the average mass existing on the existing homes on the cul-de-sac. Pedestrian, vehicular, and other traffic safety within the Nellie McClung school zone is a grave concern, as sightlines from Palliser Place would be significantly diminished due to the building mass and the proposed limited setback on the east side of the property. There are significant numbers of unescorted children who cross at this corner on a daily basis. Also, there is insufficient street parking for a potential additional 8 to 16 vehicles, nor space in the adjacent alley for parking. This is a corner lot across from a school, playground, and softball diamonds, with a fire hydrant on the east side, a playground zone, a bike route, a snow route with attendant provisional parking ban, and a bus stop across the street. This is a very busy corner. In addition, the property owner has asked for a relaxation of the criteria for setback from the street on the east side in violation of the minimum setback requirement. This should not be permitted, as the proposed development already overshadows all the other single houses on the cul-de-sac and significantly impacts the aforementioned sightlines. If anything, we would recommend that there be an increase in the minimum setback in this instance. Finally, city-mandated community engagement has not occurred to date. We were essentially blindsided. We only became aware of the proposed development when the city put up a small sign on the boulevard on March 10th or 11th of this year. I took a photograph of the sign March 11th, and this was the first we knew of the proposed development. There was no prior engagement. The only engagement that has occurred has been a property owner or a family member who came door to door on the cul-de-sac with a letter in favor of the proposed development, stating all conditions had been met, including the setback, which to date has not been changed.
Thank you, Anne. You're just at time, but perhaps a final sentence to conclude your thoughts.
Okay, thank you. Just wanted to state that there was an architecture firm toward the end of the hearings, the last set of hearings, who spoke very much about developing things contextually and in consultation with their neighbors.
Thank you very much,
They were amazing. Anne. Thank you so much for that. All right, take care.
All right, so we have some folks in the queue for this panel, I believe starting with Councillor Jamieson, please.
Thank you, Mayor. Mr. Davis, please. Well, first of all, thanks for coming and being engaged here. So when we think about the exemption, we're told, this is how I'm interpreting it, that we're told that we must do the exemptions to restore the 247 parcels to RCG districting, and that's in bylaw 27P 2026, because it's this is what I've heard, the fair and right thing to do. Not doing so exposes the city to potential reputational risks, potential legal risks. I'm not asking your legal opinion, but just your opinion, how would you respond to that statement?
Through the chair, through the chair to Councillor Jameson, we submitted a legal opinion from Janice Agrios back in December, and it's on our website, Calgarians for Thoughtful Growth. I think we've resubmitted it for this hearing. Janice is a very capable municipal and development lawyer who's had I've done lots of Court of Appeal decisions. She's done 10 times more. Janice provided an opinion on the whole repeal process and honestly landed on an outcome that would have suggested just repeal, don't create confusion by a series of entitlements, then come back with, after engagement, with the necessary amendments. So council elected not to go that way, but what Janice did say in her legal opinion after examining the Lahode decision was as follows. She said, in terms of pending applications, it's important to keep in mind that an application does not create any vested rights. If there is a bylaw change while an application is pending, then the application must be evaluated under the new bylaw. She went on to say there is always a risk with any property that the zoning may change. That's what happens here in public hearings. Because submitting an application does not create any vested rights, an owner or developer with a pending application does not have a basis for claiming damages against the city as a result of the zoning change adopted in good faith for legitimate planning reasons. So as long as we followed the right processes, we advertised, we invited people to engage, the inner city builders will speak, I'm sure. They've got an interest in some of these items. You're, again, exposing this matter to public scrutiny and input. And the conclusion and the answer is it appears that council has a lot of sway, and ultimately it's one of your superpowers that you can actually make these decisions and say, yes, I know we said this, but you're asking us for an exception. We got to go through a public hearing. And frankly, when you ran this election last year and more than half of council said, we're going to revisit this, and you made a decision in December to bring it forward, the industry's known all along what it's facing. There is no surprises here to anybody, either the public, the industry, or otherwise, and all of us are subject to your ultimate decision.
Yeah, I think that's interesting. Yeah, like there's no surprises, and that's kind of, there's a fairness argument that, well, it's not fair for, say a developer or somebody that they got their application in, but I always wonder, fairness is always a two-way thing, right? So, one thing is fair to somebody, but, is it, for example, in this case, is it fair to the person that has been a homeowner for 30 years? And in that particular case, is it fair to them? And I think when we talk about fairness here, and it's kind of referred to my first question before is, we need to make it fair. And I'm like, well, fair has to be both sides, and there has to be some kind of middle. And like, what do you think about that? How do you reconcile that?
This, through the chair, this public hearing is the middle. Right. This is where everyone gets a shot, and hopefully in a respectful manner, we all get an opportunity to bring forward our views and ideas. And I always fall back to Section 617 of the Municipal Government Act, and that's the one that says that planning is all about trying to make timely decisions in a manner that both recognizes individual rights and the overall community good. And you may, at the end of the public hearing, say, we think the overall community good supports giving 247 properties a pass on the repeal and let them keep the RCG. But you may also look at it and say, no, based on what we've heard, the individual rights have been so significantly affected by this exception that we're not prepared to do that. So that's going to be your decision at the end, and that's why you've all got an open mind and you're prepared to listen to what everybody's got to say.
Yeah, that's true. You also mentioned about the SDBA. So I just took some notes here. You had mentioned that you do a fair amount of SDBA appeal work on behalf of, I guess, the neighbors and communities. What I want to know is, what are you actually seeing in the last 2 years with respects to townhouses, row houses development? Because there's this idea that if you don't like something, or you don't like how, if an appeal is approved, or if a development gets approved and you can appeal it, and there's this idea that you can, if you don't like it, just appeal it. But you had mentioned in your line of, in your 5 minutes there, that only, you said, and this is your numbers, 10% approximately are overturned. So that means 90% of all the appeals go through anyways. So can you, I guess, reconcile that with your experience over the last 2 years and how that process is actually working for people that don't agree with a particular development?
Through the chair, to Councillor Jameson, you've asked a very broad question. And administration and council 2 years ago said, we don't want to keep doing these land use amendments when only 10% of them successfully are unsuccessful or successfully stop the approach. That's been essentially downloaded to the SDAB. We're seeing similar numbers. But at the end of the day, the public is frustrated because people feel like they should have an opportunity to respond and to question certain kinds of development. And all row houses and all townhouses are not the same. But I think it's worth reflecting in the trenches where I'm presently living. I've got an appeal tomorrow afternoon starting at 1 o'clock on a matter that's a very significant one in the Varsity community. And by the way, Joanne Atkins is here from Varsity, and she's got some very compelling information about how their community is facing applications which, frankly, I would say are flat out gaming this entire process. So you'll hear more about that. But at the Development Appeal Board level, yeah, the chances of being successful in appealing an approval are very low. If you make a decision on these matters to allow for applications which were filed by April 8th or which were completed by August 4th to continue, it will be complicated. And the planning department is already providing the SDAB with a table that says how you'll look at this appeal under the current rules, because some of these are going to get heard before August 4th. And then here's what's going to happen after August 4th. And it doesn't mean that these matters will be tossed. It means that the DAB now, if the rules change and you amend RCG, they're going to have to apply the new rules because those will take effect August 4th. Some of them already. Some of them you're being asked to defer to December 15th. We don't encourage that. But what will happen is the DAB will have to start looking at variances to say, if I've reduced the height from 11 meters to 10, but it was approved at 10.5, well, now I've got to deal with it as a variance. It's supposed to be a higher test. That might result in itself in being overturned, but I don't know the answer, and it's the SDAB's outcome. All I can say in conclusion about the appeal process is it's there. Glad that it is. Council 2 years ago took row houses out of permitted use where there's no appeal and said, here, it's discretionary, you have the right to appeal. So at least communities have that much of an opportunity to express their concerns and their voice, and at least 10% of the decisions to approve are being overturned. So it's something. There's a story called the Starfish story. I'll tell you another day. But for these individuals who win those 10%, it's huge. And it means a lot. And I can say that these are outcomes that are very emotional for the people that are involved. And that's why a lot of people are still here wanting to present on this very matter.
I appreciate your answers. I think you are a very good speaker. So to summarize, would it be fair to characterize you as opposing the 27P 2026?
Through the chair, yes. I think that we haven't got the detail. If we saw more detail about how the 247 had been reviewed, I heard some of the staff say yesterday that they found very few concerns, but maybe there's 10%, maybe 25 of those. There was an error, but we don't know because we don't have that data before us. You don't have the data before you. So maybe this is something that continues to be in play. And believe me, I believe that much like in 28P 2026, where you're allowing more matters, maybe it's 25 to be removed, had the RCG removed because of SDAB decisions, please don't stop. Like, it's not something that's going to continue in perpetuity. You're going to make a decision August 4th. It will be notified. There's 21 days to appeal. We'll know by early September how many of these matters are being appealed, and they'll play out over the next 4 to 6 months. And then you should get a report back, and please take those SDAB decisions and consider also taking away the exceptions from those properties if there's a decision that overturns an approval granted by the Development Authority.
You've given us food for thought, so thank you.
Thanks for the questions.
Yeah, no more, thanks.
Thank you. Deputy Mayor Kelly, please. Or sorry, no, Councillor McLean. You were in the queue first, sorry.
As was stated, Chris, quick question, and I might need latitude because you brought up the 60 to 70. The administration's recommendations for 60 to 75 units per hectare. I know that's not before us, but you mentioned it. You might not be here, but I'm curious to whether you think that's profitable or not profitable. I mean, because again, if you won't mind me hearing it from the, even though it's not before us right now, but it's coming to us and you might not be here, but.
I'll Councillor McLean, I think in the previous public hearing, we looked at whether the economy or just the economical use of land was okay, but we couldn't go into actually the profit piece. So maybe an opportunity to rephrase your question.
It's still not that before us. You had mentioned it. Maybe just give me your thoughts then on it.
Through the chair, I will not elaborate on it, Your Worship, but I will say this. Administration's recommending refusal of Council's direction. Frankly, I'm kind of stunned that Council said this was something we want to see, go test it, and the test, not surprisingly, says, oh, it's uneconomic from the industry. But frankly, I believe that the 3-plex, 6-plex model is the one that's been adopted in Vancouver and Toronto. That's met the federal standards. Yet here, we went to an 8-plex, and repealing or rolling that back to 6 is uneconomic or perhaps doesn't meet federal requirements. I don't agree, but I'll leave it at that. I don't support what the recommendation is, and if I'm able to get back, I'll say it in a more fulsome way. Thank you.
Okay, thanks. Thanks for that input. That's good.
All right, Deputy Mayor Kelly, please.
Thanks. Mr. Davis, I'll start with you. I'll move on to someone else. But I wanted to get a little bit of clarity just from the answers to Councillor Jameson's questions there. The list of 247 properties is posted on calgary.ca/rezoning so that we can all take a look at it. In there, it does have the breakdown in terms of what exemption criteria does it fall under and where it's at in the process, if it's approved or if it's under review or if it's been revoked. In your letter that you sent to us dated March 15th, you had said at that time, you said the exemptions should be refined to ensure they do not apply where an approval of an or application has been revoked, canceled, withdrawn, successfully appealed, or otherwise disposed of. I agree with that. I just wanted to see, like, has anything changed from that? Is there any other criteria where you believe that these exemption criteria should not apply?
Well, that was the, through the chair to Councillor Kelly, thank you for the question. That was in the, I think the unique subset of SDAB decisions, and council responded to that, I think positively, and has, in I think bylaw 28, P 2026, said, yes, let's remove those exemptions for those 20-some decisions from the SDAB. I encourage you to approve that bylaw, but also to consider extending it, because the same variables, the same fairness and equity, I think, applies to any SDAB decision that will still be incorporating what we're dealing with on the blanket rezoning. As far as extending it further in your questions and elaborating on it, I feel like council's painted this into a corner. I wish that I could say that the two exceptions, being the application by April 8th and the completion by August 4th, were mutually connected, but they're not. So it almost, I won't say it doubled it, but it extended the exceptions, I think, beyond what council thought. I think some members of council thought, well, you had to get it in by the April 8th, and it had to be also completed by August 4th, but it's being interpreted as both being distinct. And I think that's expanded a lot of what is included in that list of 247, and thank you for that list, and I'll take a look at it. I appreciate the reference.
Yeah, absolutely. And then, so just to be clear then, is your argument a little bit different than what you did in that March 2015, and you're saying that now, for example, some of the applications that are currently under review, that have been submitted and that are currently under review, they should not be exempt? Is that, am I hearing you correctly?
Through the chair, there's going to be some cases that are very suspect. I know there's a case currently in Varsity where an application was made under HGO, development permit was submitted under HGO, but all of a sudden it's going to be under RCG, and that's, to me, is a new application, but it may be that administration's going to say, oh no, you had an application in. I don't think that's right. And I'm concerned that there are some elements of these exceptions that are being twisted. I personally would never have included subdivision or building permits, but they were. But people are filing a subdivision application without any immediate intention of proceeding on it, but that provided a placeholder so that exceptions could apply. And I'm not sure that that was council's intention.
Sir, I just, on that Varsity one, you're saying, sir, you're saying it was submitted under HGO, but it's now being considered under RCG?
That's what I understand, yes.
I mean, that would require a land use amendment that this council would need to pass, correct?
Well, it's already RCG because of the current zoning, and it's an exception because there was an application made. But now I'm told, this is just unfolding, I'm told that the developer is going to withdraw the HGO, which is in not before you yet.
Like a land use change
and
to
I'm going to go back to RCG, but to me, that's a new DP. That doesn't meet the requirements of the April 8th deadline. Now, if they can ram it through before August 4th, I'll be concerned, because that to me seems an abusive process, but that's what I understand.
Yeah, that one doesn't make any sense to me, because if it would have came in as a DP, but you're describing a land use change, which is an entirely separate process.
It's HGO application. We never used to allow this, but...
So it's zoned currently as HGO?
No, application, LOC for HGO, currently zoned RCG, DP for HGO, HGO abandoned, still a DP for an HGO. Oh, but we're going to convert that to an RCG. I need to take a look closely, but I'm just raising this as there are things going on that seem to be gaming the system. And I'm concerned about that, and council should be too.
Yeah, I'd recommend you take a look at that one, because that, two entirely separate processes there for sure. Okay, thank you. Wanted to move on to Ms., sorry, just right spot here. I wanted to, Ms. Farrer, am I pronouncing that correctly? You had, sorry, it seems like it's been like an hour since you presented. Apologies for the delay in asking you questions. You had mentioned something about a potential conflict of interest. I just wanted to dig into that a little bit to understand what the perceived conflict of interest is there, so I can ascertain how that might impact our decision before us.
Sure. I guess I would say, so the developer is a full-time employee within city administration.
I gotta jump in here. The reason I'm jumping in is under the procedure bylaw, there's an obligation for members of the public to refrain from disclosing personal information of third parties, other than those people you might be here representing. It's just out of protection for their privacy. We're here for the land use, but we can't really get into the personality or the specific individuals.
Yeah, and I certainly don't want to go there. That's kind of why I wanted to ask the question here, to get an idea in terms of, I didn't hear anything in your presentation that sounded like a conflict of interest, but you obviously had alluded that there was one on this particular property. So I do want to respect what the mayor's saying here, but
I feel like it's a really difficult question, because how can we not shine, there's statements of fact that he is 3 professions. And so it's not like he's an active real estate agent, a city employee, and a developer. I mean,
yeah, and I
we do
don't
need to shine lights on these things.
Yeah, and I don't think there's anything illegal about
I respect
any
and
of that,
appreciate that. Just as chair, I'm beholden to what the procedure bylaw states out. And again, I'm obligated to the rules, not as I wish they were, but as it's stated. And again, we have an obligation to, again, refrain from disclosing personal information of third parties. And that is a third party who's not here before us.
That's absolutely fair, yeah.
And again, the section that I'm going off of is 33C in the procedure bylaw.
Yeah, thanks. And I want, just because when I heard in the presentation, I didn't hear any conflict of interest potentially, like even those 3 roles that you said, like it's legal to hold all 3 of those. And certainly on our end, we would never have anybody making any decision on any property that they would be involved. We have pretty strict conflict of interest rules for that exact reason. This was the Palliser property that you were talking about, correct? Palliser Place. Just wanted to ask you just a little bit the timeline related to that. I know that we were talking about like procedural fairness has come up a lot in terms here. I note on that particular property, the application was submitted on February 22nd, which is like 5-6 weeks before we repealed the blanket rezoning. What, in your estimation, should we have potentially done differently there?
Well, I think at this point, that application should be dead. There was a deadline for him that he was supposed to have conducted community engagement, because there was 240 some odd objections to this property. And so he was to meet with the community association and with the community separately, with affected stakeholders separately. For the community association meeting, he did not attend. He sent his parents. And he did not do one with the community, the larger community at all. And for those reasons, we believe that the application failed. Those gate posts, those timelines that were set in the application were not met, and we thought that.
And so taking a look at the timeline that's before us right now, it appears on DMAP that it's still open for comment. And it does not look like there's been an application decision on this particular property yet.
Yeah, exactly. But I mean, that was my point, I guess, being that we were surprised that it even was included on a list of exemptions, because we thought the application would have failed just based on the timeline. The developer.
And it looks like they haven't rendered a decision on that one yet.
Okay.
Yeah, I just want to get clarity on the timeline, just because it does meet the exemption criteria that we've been talking about since December, and the fact that the application was in a month before. So I just wanted to see what I might have been missing in terms of why you think it shouldn't meet the exemption criteria that was laid out.
I guess just because we'd thought it failed. it hadn't met its timeline within the application processes set out by the file manager.
Okay, thank you. Appreciate it.
Thank you. I believe that concludes this panel. So we work to assemble our next 5 speakers. Do we have Christina Provencher with us? Darcy Dean? Ji Zhang? Brianne Reed? Doug McFadden? Jennifer Houle Famakinde? Frank Stewart? Jennifer Baldwin? Jennifer, you're up. Patricia Morden? Cindy Robinson? Deborah Teitelbaum?
I'm on the line.
So is that you, Deborah?
Yes, it is. It's Deborah.
Okay. So I see 2 people have approached in the chamber. Can I please have the other individual's name? Cindy? Okay. Do we have Owen Reeder? Tony Payne? Remedios Thompson? Dean Sorshan? Come on down, Dean. Dimitri Satoran? Puneet Sethi? Patty Peck?
I'm on the line.
Is that you, Patty?
That's me, Patty, yes.
So we have up for our next panel. This is the final panel before our afternoon break. It'll be Jennifer, Cindy, Deborah, Dean, then Patty. Jennifer, please go ahead.
I hope we can hear me okay. I'm supposed to be on vocal rest right now, so we'll see how my voice does. I'll try my best. Good afternoon, Mayor and members of Council. I'm going to be honest, this transition process is a mess. All of this should have been clear and well explained to the public before March's hearing, not now. Council should vote no to Bylaw 27P 2026 and yes to Bylaw 28P 2026. Bylaw 27P 2026 attempts to preserve the former RCG zoning for a broad list of properties, but that list is the product of a transition process that was never clear, stable, or properly examined by the public. Administration initially proposed the end of March as the cutoff for accepting applications for grandfathering. We had the hearing over the end of March and early April. Council then considered the repeal on April 8th. The public was told that applications would have to be submitted before April 8th, and that the planning process must be completed by August 4th to be grandfathered. These are not minor details. It told residents that August 4th was a completion deadline and not a deadline that could be satisfied by simply having submitted an application months earlier. And then the rules changed. The public later, post-vote, learned that a development permit approval could preserve the exemption. The appeal period did not have to be concluded, and the appending appeal did not have to be completed by August 4th. The interpretation was not explained during the repeal hearing and was never available for public scrutiny. Then to find out, internally, administration had been accepting applications till at least May 4th. Now, Bylaw 27P 2026 goes further. It proposes that a development permit, building permit, or subdivision application submitted before April 8th can be enough by itself to preserve the former zoning. The application does not need to have been completed through the planning process. Entry into the pipeline becomes the exemption, while the public is not privy to all the details. This is not an orderly transition, it's a moving target. Council intended to repeal blanket rezoning. Instead, the transition created a rush to preserve 247 applications. Applications were submitted quickly, planners were given a large queue and a fixed deadline, and communities are now seeing files approved without revisions and scrutiny they would ordinarily expect. Residents are then left to determine whether they must appeal. They are being asked to act as the quality control system for an expedited grandfathering process, often at the cost of thousands of dollars for professional representation. The 247 properties in the agenda package cannot be responsibly approved in one combined list. Council and the public have not been given the facts necessary to understand the status and history of each property. The list provided to Council is incomplete. The public does not know which applications were filed before the original proposed cutoff, which entered later, or which were received adequate review. And those differences matter. There are many properties on that list that say completed, while they have not completed their 21-day period and have not finished their appeals. It appears that the list of Development Authority approvals is hitting record time leading up to this hearing. An application is not the same thing as an established legal right. Applicants who entered the process while repeal was under consideration accepted regulatory risk. They knew it was a risk. That risk should not be converted into a public obligation to preserve the former zoning for every unresolved application. Voting no to Bylaw 27P 2026 does not cancel development. It restores the ordinary planning process. Applicants with unresolved proposals may continue pursuing development, but they should do so under the appropriate tests at land use, since this current process has been failing the public. Bylaw 28P is different. It corrects identified Development Authority approvals, errors, and should be approved. Vote yes to Bylaw 28P 2026. But just so people understand, I want to clearly explain why this is a loophole. Developers were able to enter their application in. Who knows when, because we don't have the specifics to each of those individual 24 parcels provided. We don't have the time now to verify them due to when the agenda was released. There's no clear deadline for acceptance. They were expedited through the planning process by the deadline that was initially created. Then they weren't given the full scrutiny of their applications during the DP phase. And now Council will be protecting that loophole if they vote yes. It's completely unfair to the public. So clean reset now. Vote no to Bylaw 27P 2026. Those that have been approved, they'll conform if they pass through their appeals process without issues. And this will correct those that are still in the queue. Thank you.
Thank you. We'll go to Cindy, then Deborah after that.
Well, hi there. She said everything. Really don't need to say anything. But I agree. This should not be grandfathered. We have a building on 1023 Reynard Crescent that should not be allowed to build, simply for the fact that it does not align with the rest of our houses along that block. The first time we seen the sign, it was up, then it was down. They kept laying it down. They'd move it, put vehicles in front of it, so there was no community treatment there. It encroaches if they are allowed to build this threeplex with 3 secondary suites. When I went to school, that's 6 suites. That's 12 vehicles, most likely. We already have issues with parking. And now you're going to take away the privacy of either side, the people in front, because there's balconies where I understand being fair to the builders, but where is the fairness to the rest of us that have been in that area for 20 years? Why do we have to give up our yards, our beautiful gardens? I myself have worked really hard to get that where I'm almost happy with it. So I don't understand why they're allowed to meet one portion of a criteria and be allowed to go forward. We had 150 signatures within 4 days to show that this is not wanted in our area. You're going to build a monstrosity in the middle of a block that is, it's just crazy. There should not be an exemption. There's 56 new builds in our area, over 700 doors. I know that's how you count the doors. In the middle of it is just not acceptable. It would be destroying mature trees, which you all know that that's how we get the air cleaned. So therefore, I believe this property should revert back to its original RC1 zoning so the rest of us can carry on as we have with our beautiful road the way it is. There's way too many complications. Albert Park has been bombarded with them. We watched a house take out a house on either side simply for the fact that the fire trucks had to re-situate themselves 3 times. This is what's going to happen if you build something that close to our houses, which is unacceptable to myself and the 150 other people that in 4 days we had those signatures. So I'm here asking you to please do not allow this to happen. Thank you.
Thank you. We'll go to Deborah now, and then Dean after that.
This is Deborah Teitelbaum. I'm a resident on Palliser Place in the Rob Ward's ward. I've lived here for the past 30 years. I am opposed to the proposed exemption under bylaw 27P 2026, and the address is on this little cul-de-sac, 9427 Palliser Place Southwest. We urge council to vote no to grandfathering in DPs that are not yet approved. Hello, Mayor Farkas and members of council. Thank you for this opportunity, and I care deeply about this community. I've been here for a very long time. I'm not able to be there in person as I'm babysitting my grandson, but I'm here online. This development proposal in Palliser is again a good example of why blanket rezoning does not work. The development permit DP 2026-00947 has generated significant concern within our community and has been the subject of a detailed submission from the PBP Community Association, and you just heard an association member speaking. And between about more than 250 submissions by community residents outlining numerous issues, including, and most importantly, contextual fit, non-existent, green space, and safety issues. It should not qualify for an exemption. Some concerns include, but are not limited to, the proposed intensity of development on a single residential parcel resulting in 8 units does not fit in with the design. It is incongruent in structure and does not fit in any, does not match any of the single-family houses on our little cul-de-sac or even the neighboring streets in our community. There is insufficient street parking for as many as 8 to 16 new cars for the proposed residents, nor is there space in the adjacent alley for parking. You've heard all of these stories already, but here they are again. The extra cars could result in pedestrian safety issues within the Nellie McClung school zone. On top of all of this, it does not meet the setback on this tiny parcel. He wants to put 8 units on this tiny parcel. It doesn't meet the setback, and he's asking for a relaxation of the criteria for lot clearance. Should not be allowed, as it is already overshadows all the other single-family houses on this cul-de-sac. Also, he plans to cut down an old-growth tree because it does not fit on his 8-plex design. While this hearing concerns the proposed exemption under bylaw 27P 2026 rather than the development permit itself, the hundreds of submissions in opposition to this development illustrates why this property is not an appropriate candidate for exemption and why your additional scrutiny remains warranted. We should not give an exemption to a development that council has already decided that blanket rezoning does not work, and it has not been approved yet. One-size strategy does not fit all situations, and I know you all agree with that. And in this case, of course, this one does not fit. It's just not me that says so. I have here signatures of all the residents living on Palliser Place. I've submitted it to council. They are all in opposition to this exemption. Not only that, we also canvassed several streets around this development, and every house said no to this development. There are at least 70 signatures on that petition, which you should see that because I've attached it. Again, on top of all of this, the city asked the developer to sit down and have an exchange with the community. They have not complied with this request. If you let them, they will build an 8-plex where only a duplex should fit. There is no good rationale to provide exemptions to developers when the DP has not yet been approved. The community is going to suffer forever with an 8-plex in the middle of this quiet, school-zoned street cul-de-sac. Please vote no to 27P 2026 for all applications not yet approved, and no exemption for DP 2026-00947. Developers
Thank you
can
so much.
reapply.
You're just at time. Perhaps a final sentence to conclude your thoughts?
I just want to say my last sentence. Developers can reapply with appropriate building plans that will fit this community. Thank you very much for listening.
Thank you so much. We'll go now to Dean, then Patty after that.
Good afternoon, Mayor Farkas and Council. I'm here on behalf of the development in my neighborhood in Highland Park. The development was DP 2025-01157. The issue I'm bringing up here is...
Sorry, I just misheard you. Could you say you're here on behalf of the development, or...
No, on behalf of my...
Okay.
Sorry. The development I'm concerned about is the property was demolished, and it just so happened to be an exact duplicate of my house. It was a post-war house. They've torn down. The property is 35 by 120 feet, which is approximately the size of the area you're working in right now. The developers put in a permit, and it got approved, from what I can understand, for 5 units plus a 3-car detached garage. The concerns here are is does not fit the neighborhood. From what I can understand is it was approved on November 12th and released on May 6th. The issues we've had in the neighborhood, some of my neighbors and myself have actually opposed this. We've never heard anything back about it, and just was steamrolled through, it seems, is what the feeling we're getting. The other issue we have here are the safety issues. The way this property is being developed is there's going to be a unit in the front with 2 basement suites, a middle unit with basement suites, and then the detached garage in the back alley. The issue here we have about safety is what happens if that middle unit catches fire. The local fire station is hall number 7, does not have a ladder truck. So there was an issue about that, and we were wondering if this permit could be changed. The other issue that we feel could be part of this was the infrastructure was built back in the late 40s, and now it's going from 1 house to 5. The neighbors neighbors that live on the west side of that property, there used to be two bungalows. There are now 5 single infills, and we're also concerned about there's been no upgrades to the utilities. The sewer lines, the water lines, and the electrical lines don't have the capacity for this, and so this property hasn't been developed, it hasn't been started yet, and we're wondering why this, if this permit could be pulled and have the developer develop something that's more in context with the neighborhood. Thank you.
Thank you so much. We'll go now to Patty, please.
Thank you very much. Sorry, I just got to scroll up on my notes. Just 1 minute. My name is Patty Peck, and I am a resident of Bowness. I oppose these amendments and specifically ask that applications submitted but not yet approved should not be given an exemption from the repeal. Before I get into the planning issues of the property that affects me the most, I would like to comment on a few points that were raised yesterday. First, it was suggested that the bylaw should pass to protect council's reputation. As a member of the public, I understood council recommended wording for exemptions that would be put before a public hearing. If council simply passes these amendments because they were responsible for thinking them up in the first place, then it renders the process of the public hearing moot. Second, we heard the quantification of how small the percentage is of properties included in the exemption. In the overall picture, it is a tiny percentage. But for each property, there are real and true planning concerns, and the effects are not tiny for those at the local level. All citizens deserve process, and their concerns shouldn't be brushed aside just because we're all ready to move on and it's less than 1% of affected properties. We also heard about the possibilities that landowners will sue the city, but I haven't heard much about the actual reality of this. I'm not sure that one can sue the city over policy decisions, and I'm pretty sure if landowners need to prove that actual damages were incurred that were not foreseeable. This isn't a clear likelihood that should be informing decisions. It rather seems like a pretty big uphill battle for landowners looking for compensation now that their business risks didn't turn out. Absent a legal right to grandfathering being created upon application, I believe the decision comes down to a balance of harm. What is the harm to the landowner of being removed from an exemption versus the harm that could be done if an inappropriate building is built? The landowner can always apply for a land use change, and if the building is appropriate, council can approve it. The movement for repealing or challenging the rezoning was present right from when it was passed, and landowners incurred expenses with the knowledge that there was a possibility of things changing. On the side of the community, you can't tear down an inappropriate building. In hindsight, the harm is permanent, it's big, and the negative effects of poor planning last indefinitely. My personal example of why local planning matters is at 6103 Bow Crescent, where there is a DP application currently in circulation and is a property on the list for exemptions. The parcel is along Bow Crescent, which is a very active bike and running route that is a special asset of the city that needs to be protected with thoughtful planning. It's in the flood fringe, and there are proposed basement secondary suites. It's in a very sensitive area for traffic and overdevelopment concerns, and the cumulative effects of so many projects nearby are accumulating very fast. The parcel is 100 feet wide, so the DP is for 16 dwellings with an open paved parking lot, which has much more of a commercial rental feel than the low-density residential vibe that's supported in the ARP. This is a classic example of a property that requires planning due to unique local context and is exactly why the blanket rezoning was appealed in the first place. Please remove as many exempted properties as legally possible to provide as many opportunities as possible for Calgary to be a well-planned city. Thank you for your time.
Thank you so much. That concludes this panel, but we have some questions. I'd like to jump in first for Ms. Baldwin, if I may.
Hello.
I really appreciated the nuance in your presentation, and I think the way that you laid it out, kind of that decision tree, like if we vote no to the exemptions, if this, then that, if this, then that, I think really got to the heart of it. I think you also recognize that, like for the permits that have been approved, have survived the appeal process and whatnot, you understand that those projects will go ahead?
Yeah,
even if the zoning in place doesn't match what was originally there?
Yeah, they do if they can match the other criteria that the SDAB is looking for. So, I mean, like, yeah, that's the hard part right now is we have to see how the SDAB manage things, especially with like your next agenda items too, and so it's quite convoluted. But I do understand that if they have their development authority approval and you're not successful at the SDAB or you don't file an appeal, it conforms and you're good to go.
Yeah, I think I don't want to put words in your mouth, but I think your idea was that if we vote against the 27P, the exemption bylaw, essentially everything kind of sorts itself out because
yes, exactly.
If in a, for example, for those with their DA approval, they'll conform now. Yes. Afterwards, those that are in the appeals process will be kind of dealt with at that point, and those who are relatively premature will have that separate process by which they could apply for the land use and so on.
Yeah, exactly. That's why I was hoping this would be an easy vote because it seems really, well, okay, it's not clear because it's been really messy to understand it all, but now I think it's pretty straightforward because they all do categorize themselves, yeah.
Yeah, this is such a complex topic, and I think it's good to have the support of the community in this, and in terms of how I'm personally looking at it, because I don't know if you see it the same way, but it's as if those who already have the approval in place and have survived the appeal period, they're sort of exempted no matter what.
Exactly, they get their exemption, yeah.
And then the question really just comes down to the fairness for those who are premature in the
Yeah, who had to really go through the chaotic process over the last few months, yeah.
Are you persuaded that, say, given the media profile of the election, the December decision, April and whatnot, is your sense industry and the community both had an idea that this decision was coming? And
Yes, yeah, because we know, because, well, one, October, election, who got in. December was a really big red flag for them, right? Because you guys brought forth a lot of direction to administration. And then, I mean, really by April, it was pretty clear what was coming. Yeah.
That's it for me. I'm going to go to Deputy Mayor Kelly, please.
Dean. Just apologies, I'd missed the address of the Highland Park property that you were.
Oh, sorry, that's my fault. It was 417 36th Avenue, Northwest.
417 36th. We're going to be taking a break here in a little bit. I'll happily pull that up and have a conversation with you offline, and we can walk through that one specifically. Okay, thanks.
Thanks.
Okay, I believe that exhausts the queue. Unless there's any objections, colleagues, I'm going to bang the gavel early and say we're back at 3:41. Okay, seeing none, see you in half an hour. All right, welcome back to Calgary City Council. Madam Clerk, please call the roll.
Thank you, Mayor. On the roll, Councillor Ewell, Councillor Atkinson, Councillor Chabot.
Here.
Councillor Clark.
Present.
Councillor Dhaliwal. Councillor Jameson.
Present.
Councillor Johnston.
Here.
Councillor Kelly.
Present.
Councillor McLean.
Present.
Councillor Pantazopoulos. Councillor Schmidt. Councillor Tyers. Thank you. Councillor Ward. Councillor Wyness. And
Here.
Mayor Farkas. Oh, Councillor Wyness, did I hear you?
Yes, you did.
Yes, thank you, Councillor Wyness and Mayor Farkas.
I'm here.
Thank you.
All right, let's assemble our next panel. Anyone on the line or in person on panels 1 through 15?
I don't know my panel number.
What's your name?
It's Shelley again.
Hi, Shelley. Not yet. You've not been called yet.
I haven't been given a panel number, so I don't know when to jump in.
We're going through the list of registered speakers, and then we'll be going, I believe, if you're Shelley Tulik, I believe that you're on panel 22.
Super, thank you.
Okay. I think we have a gentleman in person from panels 1 through 15.
From panel 14, Evgeny Zhiromsky from panel 14.
Okay, and what's your name, sir?
Evgeny Zhiromsky.
Evgeny? Okay, please come on up. Evgeny will be our first. I'm going to call for 4 more names, though. Do we have Patricia Morden? Owen Reeder? Tony Payne?
Yeah, Owen Reeder's here.
Okay, Owen, please stand by.
Thank you.
Remedios Thompson? Dimitri Sutoman? Puneet Sethi? Justin Worthy?
Yes, Justin Worthy's present.
Thanks, Justin. Please stand by.
Will be our first.
Joanne Atkins? Come on down, Joanne. Flora Gillespie? Tyler Wells? Carrie Nurmo?
Present.
Is that you, Carrie?
It is. Thank you.
Thanks. Please stand by. Our next panel here will be Evgeny, Owen, Justin, Joanne, then Carrie. Evgeny, please approach. You have 5 minutes.
Hello, Mayor and Council. My name is Evgeny Zhiromsky. I live in the community of Windsor Park in Ward 11. I'm speaking in opposition of proposed bylaw 27P 2026 about blanking rezoning exemptions. Allowing 247 RCG exemptions is a bad idea, and this bylaw proposal needs to be sent back and reworked. I'm relieved and encouraged by the response of Calgarians. The overwhelming majority are in opposition of this exemption proposal, and I urge you to listen to your constituents. I recently received a letter from the City of Calgary informing me that property adjacent to you was included in bylaw 9P 2026, but meets one of the exemption criteria. Slide 2, please. The only adjacent RCG property to me is 5431 6th Street Southwest. This is vacant land with a development permit DP 2023-07626. The development permit is for a 3-story, 9-unit row house on a single residential lot, which is formerly RC2 district lot. I have been appealing this development permit for the last 2 years, and I think it should not be exempt from the repeal. Slide 3, please. The council recommendation now is to change the zoning back to RC1, RC2 if the development permit was overturned by the SDAB between August 24 and August 26. Slide 4, please. So what about those cases where the development permit was not overturned by the SDAB, but the SDAB decision to uphold the development permit was later canceled by the Alberta Court of Appeal? Would such RCG property still be exempt? How is it fair and equitable to the adjacent homeowners who appealed it through courts? Slide 5, please. The interactive map says that the parcel was not part of the citywide rezoning for housing, which is correct then, the letter I received or the interactive map. Slide 6, please. The risk section of the Planning and Development Services report to Council states that not allowing exemptions would create applicant and landowner confusion, as it would result in an inconsistent approach to determining exemption status across parcels accurately. What about hundreds and hundreds of adjacent homeowners who are going to be harmed by these exemptions and incompatible RCG developments that will continue to pop up in their neighborhoods? Why does the risk section of the report say nothing about that? Slide 7, please. You propose to exempt 247 properties from the main repeal. This means there are several hundred adjacent households who will be adversely impacted by these incompatible RCG developments. Our homes will be devalued. The real estate market will never pay the same price for a single family home in a low-density neighborhood that has a multi-unit RCG structure next to it compared to the one that does not. What if the discount is 10%? What if the discount is 5%? The loss in home values will still be in the millions of dollars for 247 exemptions. How is that acceptable? Why has this not been studied and reported to the council? Is this not an economic impact of the proposed bylaw? This is a zero-sum game. RCG developers can only make above market profit at the expense of surrounding homeowners and their home values. The adjacent multi-unit RCG developments will impact the use and enjoyment of our homes. All the legitimate concerns about excessive density, unacceptable building mass, height and size, blocked sight lines, violation of privacy, overlooking, excessive noise, excessive traffic, insufficient parking, unmanageable garbage bin placement and quantity will continue to materialize and harm the affected homeowners as these 247 exempted projects continue to be developed. Why does the Planning and Development Services report not mention any of that? How is that fair? Why do we have to be singled out and continue to be victimized by the failed policy of the previous mayor and council? Thank you.
Thank you. We'll go now to Owen and then Justin after that.
Good afternoon, Mayor Farkas and Council. Thank you for hearing me. My name is Owen Reeder. I live at 3311 Lakeside Crescent, directly adjacent to a property 3408 66 Ave Southwest that is listed in Bylaw 27P 2026 for exemption from the repeal of the blanket rezoning. I'd like to mention that I've lived in this house for over 2 decades, and it's in this community that I've lived for 40 years now. So I'm raising that because I think it speaks to the roots of these communities to have influence in determining their future, and as we have a stake in how things develop where we live. I want to say that this council was elected on a clear mandate from the city to fix blanket rezoning. And that mandate was formalized on the 15th of December, confirmed again on April 8th. But when council passed this bylaw or when you passed the bylaw that directed the rest of the city back to low density zoning, it was the will of the city. It was what everybody in the city wanted. And what's before council today is this idea of exempting some of those 247 properties, including the one that's across the street from me. I would ask council to vote no on bylaw 27P 2026. The exemption criteria created a weird window between December and April where an application could still be filed under a policy that everybody in the city knew was on its way out. That window is exactly how this property ended up, which in a condition which I would say is seeking special treatment instead of falling in line with the rest of what the city has already accepted. The purpose of these exemptions, in administration's words, were to protect projects already in progress, not to reward applications that filed to beat the clock. And this file, which is DP 2026-01445, does not yet have a building permit, no construction, nothing physical underway. It's only an application that was submitted March 2026, just a month before council officially acted. It's still not approved, and it meets this, for some reason, weird criteria for exemption that I don't believe should exist. The file in itself has a lot of problems. Its design in the last couple months since it was first applied for has changed, which I think speaks to the fact that it's still a project in flux that wouldn't be disrupted, or it should be disrupted by the will of the city without material loss. On its merits, the file is terrible. It has real problems. It's a corner lot with the only usable on-street parking sitting across the street because of a bus lane and a bike path. It only has 4 garage stalls, 7. It's all the same complaints that everybody's already listed, so I won't get into that. But to make the ask clear, I am asking council to vote no on 27P to 2026, or to amend the bylaw to remove properties without an approved development permit from the exemption list, including 3408 66th Ave Southwest in Ward 11 under the development permit DP 2026-01445, so that they immediately revert back to low density zoning along with the rest of the city on August 4th. Thank you for hearing my thoughts.
Thank you so much. We will go to Justin, then Joanne.
Good afternoon, Your Worship and members of council. My name is Justin Worthy, and I'm one of the owners of 4604 and 4608 33rd Avenue Southwest. Thank you for the opportunity to speak today. I'm here today with one simple request, that our properties be included in the exemption process so our HGO project can move forward based on the rules that were in place when we initially made our investment. When my father and I had purchased these properties, we did so with a clear vision to build high quality, grade-oriented multifamily housing under the HGO land use district. Before making that investment, we carefully reviewed the city's published policies and exemption criteria. We relied on those policies when making a significant financial commitment to this project. Since then, we've invested considerable time, resources, and professional expertise into planning, design, and due diligence, because we believed we were moving forward under the framework that was initially established by the city. Our site is uniquely suited for this type of development. It's located on a prominent corner at the intersection of 33rd Avenue and 45th Street Southwest, which is a busy corridor with excellent access to transit, schools, parks, shopping, and existing infrastructure. We believe this is exactly the type of location where thoughtful, grade-oriented housing can add density responsibly while complementing the surrounding community. Our project is exactly the type of development the HGO district was created to encourage, and it delivers more homes in an established neighborhood, makes excellent, efficient use of existing infrastructure, and expands housing choice for Calgarians while supporting complete communities. We are not asking for special treatment. We are simply asking that projects which move forward in good faith based on city's published policies and exemption criteria receive the certainty those policies were intended to provide. Predictability has long been one of Calgary's greatest strengths. When people can rely on published policies, they invest with confidence. Those investments create housing, support local jobs, strengthen neighborhoods, and contribute to the long-term prosperity of our city. I respectfully ask council to support the inclusion of 4604 and 4608 33rd Avenue Southwest in the exemption process, so this project can proceed as originally intended. By supporting this request, council has an opportunity to reinforce that Calgary is a city where published policies can be relied upon, where investments made in good faith are treated fairly, and where responsible housing projects that align with the city's vision are given the opportunity to move forward. Thank you for your time, your consideration, and for the service to the people of Calgary.
Thank you so much. Well, make sure, please remain muted unless you're the current speaker. Please, everybody, make sure that you are muted if you're on the line. Okay. All right, we're going to go to Joanne and then Carrie after that.
Good afternoon, Mayor Farkas and members of council. My name is Joanne Atkins and I'm representing the Varsity Community Association. We support the assessment of Guy Buchanan and Jennifer Baldwin and others who believe that only approved development permit applications for row houses should retain RCG zoning after August 4th. My focus here is to speak about several properties in Varsity impacted by 27P and 28P 2026. There are properties in Varsity identified as exempt from reverting to their previous zoning that do not meet the exemption criteria. The details are addressed in our letter submitted the morning of July 21st. We believe RC2 should be added as a land use district for applications for semi-detached dwellings to prevent applicants from switching to a permitted row house development permit after August 4th. A change from semi-detached to row house should require a public hearing to rezone from RC2 to RCG. It is critically important these issues be remedied, as there will be a significant impact on affected neighbors. It is essential that properties that do not meet the exemption criteria revert to their previous rezoning. The reason for this is that row house under RCG after August 4th will be a permitted use instead of a discretionary use. This is a huge issue. Permitted uses preclude any input from affected residents. They don't allow for discretion on the part of file managers, as they must be approved if they meet the rules regardless of the context. Neighbors and community associations are not notified of applications. Row houses are not like garages. They can have a profound impact on nearby homes and communities. Permitted uses cannot be appealed to the Subdivision and Development Appeal Board. With a permitted use, there is no incentive for the developer to work with the neighbors or community to implement mitigation measures. This was the reason many councillors argued strongly during the blanket rezoning public hearing that row houses should be a discretionary use if blanket rezoning was approved. The key here is that a row house DP application after August 4th will no longer be a discretionary use. The appeal process is eliminated, and affected residents lose the ability to have any input into the zoning or into the development permit. By repealing blanket rezoning, Council acknowledged that citizens should have the ability to argue the merits of RCG zoning before Council on each parcel. If properties keep RCG zoning as the result of an error, this would be a serious injustice. We had expressed concern in our March 16th submission about the vague wording of the exemption criteria in the letter mailed to Calgarians. When I raised this issue with a representative from the city, I was advised that the intention was that only development permit applications for row houses or townhouses under RCG submitted prior to first reading would result in a property retaining the RCG zoning. With respect to applications for semi-detached dwelling, the implementation plan states that a semi-detached dwelling is a listed use in a number of districts, and parcels with active applications for a semi-detached dwelling will be exempt from redesignation where that dwelling is not a use. It makes sense that if a parcel was RC1 previously, it would not return to that zoning, but it does not make sense that it should stay RCG. The appropriate zoning is RC2, and this is very easy to accommodate on the land use maps. By allowing these parcels to retain RCG zoning, it enables a developer to cancel an application for a semi-detached dwelling and submit a new application for a row house. Since row houses will be permitted uses after August 4th, this circumvents the public hearing process for a rezoning in order to achieve RCG zoning, and it eliminates any appeal to SDAB. There is a substantial difference between a semi-detached dwelling and a row house. This amendment should be possible without re-advertising, as it is a lesser and included land use district within the RCG which was advertised. It is merely a technical map correction, which is something Council is permitted to do at the conclusion of the public hearing. If Council decides the bylaw cannot be amended without re-advertising, these parcels should be included in a future bylaw as RC2. Development permit applications for other uses such as backyard suites or home occupations should not result in a parcel retaining RCG zoning. These are not related to blanket rezoning. I want to specifically address parcel number 5 in my submission at 132 Varsity Estates Place. This is a very controversial development proposal that really needs to be reviewed by Council at a public hearing. The evidence is very strong that this site is not appropriate for a row house. It does not meet Council's exemption criteria, and it should be added to bylaw 28P 2026 to revert it back to RC1. If this parcel is allowed to keep RCG zoning, the result would be devastating to these neighbors, as it would allow a future permitted use application for a row house without a hearing or appeal. Retaining RCG zoning would allow the developer to exploit an error at the expense of affected neighbors and circumvent a fair process that ensures public input. The current development permit application on this site is linked to a land use application that will automatically be canceled if the land use redesignation fails.
Thank you, Joanne. You're just at time. Perhaps a final sentence to conclude your thoughts.
Basically, we're wanting to add 132 Varsity Estates Place and 4607 Valiant Drive to bylaw 28P26, as they do not meet the city's exemption criteria. We also would like to remove from 27P 2026 5018 and 4619, which are applications for semi-detached, and also 4805 Vandergrift Crescent. And I would just refer you to my evidence with respect to each one of those parcels individually, which was in our submission.
Thank you very much. All right, we'll go now to Carrie to wind up the panel. Wind down, rather.
Thank you, Your Worship and members of council. Thank you for letting me speak today. I am 2 doors down from a development permit that has already been approved and hotly contested by every neighbor on our small, quiet crescent. There are only 58 houses on our crescent, and it can be walked around in less than 700 steps. And this is the DP 2026-01810 at 79 Hillary Crescent Southwest. And you've heard from many, many of my neighbors and friends earlier, and we are all very passionate about having this exempted. Of the 247 grandfathered DP, ours has had more than 200 letters written by my neighbors and friends to prevent this development. As I said, there are 58 houses on our confined crescent. It enters and exits off of Elbow Drive. There are 25 inner houses and 33 outer houses on a crescent that is easy to walk around. And there are no corners. I'm reminded of just a speaker from before last who said that their development is on a prominent corner. This lot is not a prominent corner. Before August 2024, my street was zoned RC1. This building would not have been permitted. After August 4th of this year, it will again be RC1. And so in this 2-year period, short 2-year period, our whole neighborhood will be permanently changed. With more than 22 panels, more than 100 people, dozens more online, and even more looking to see, being informed of what's going on in council today. This shows the amount of passion and commitment that we have as Calgarians to make sure that our communities remain intact. Let's implement thoughtful development outside of the current draft and create a legacy worth the future of Calgary housing and development. I will say that even though I'm pretty passionate about this one because, like I said, I am 2 doors down. I have a budding little garden growing, and I certainly want it to flourish. There are better places to implement these high-density locations. I'd often thought one of the things we could do is build up on the transit stations and reinvigorate the retail that was there at the bottom. We could make coverage for the existing, for cars so that they wouldn't get hailed on. There's lots of different areas. So I just want to conclude with please vote no to bylaw 27P 2026 and yes to 28P 2026. There's more than just the environmental impact. There's the impact of thousands of people. Thank you.
Thank you so much. We'll go to questions for this panel. We have Councillor Tyers, please.
Oh, yes. Thank you, Ms. Atkins. You were just getting started on a very important parcel, the 132 Varsity Estates Place, just about circumventing the process. I believe other speakers talked about it previously, Mr. Davis. Just wanted, if you needed time to finish your presentation, but also explain to council about that.
So prior to first reading, there was no development permit for a row house under RCG. So it did not meet the exemption, any of the exemption criteria of the city. And I confirmed that through an email from the file manager, which is dated May 2026. He confirmed that the land use redesignation is linked to the development permit, The development permit ceases to exist if that land use rezoning is not granted, and then they would have to apply for a new development permit under RCG. So the email that I was going to quote just reads, the file manager states, an applicant can submit a development permit application at any point after a land use amendment has been submitted. In the case of 132 Varsity Estates Place, the development permit is linked to the land use redesignation and will be reviewed against HGO district rules. Please note this is done at the applicant's own risk because there is no guarantee that the land use redesignation will be approved, but it is the applicant's prerogative to do so. So we basically feel that it should be in bylaw 28P 2026 because it does not meet the exemption criteria and it should revert back to its previous zoning after August the 4th. And it doesn't preclude a row house from eventually being built here in the sense that they still go through the process, they still have their land use redesignation that they can follow through on, but it does not meet the exemption criteria. So it has to revert back to RC1 after August 4th. So that's our key point there, is that it should be in bylaw 28P 26 as it doesn't qualify. Same with 4607 Valiant Drive, and I've included all of the evidence for that. So 4607 was an HGO that was defeated by the previous council, which is saying something, and it also does not qualify for an exemption to retain RCG zoning. So because the development permit that was, there were two subsequent development permits, one for HGO, one for RCG. Both of those were withdrawn and canceled. So again, it's another property that should be added to 28P 2026 and should go back to its previous zoning, which was RC2 in that particular case.
And from your experience, like, you've never seen the process dealt with in this way before? Because normally you have to withdraw it, then you have to make a brand new application with the correct
well, normally, so normally the community association is, we're circulated if there's amended plans, we're circulated if there's withdrawals, that kind of thing. And I just found out this morning that they've withdrawn the land use redesignation, but I have no actual formal notification of that. So I'm basically proceeding as it doesn't really make any difference. If they withdraw their application for the land use rezoning, essentially that development permit is null and void. The developer had said that this development cannot be built under RCG rules, and it was linked to the land use. So basically the development permit is null and void, and they would have to now resubmit a new development permit under RCG for a row house, which they could have done before, because 4607 had two development permits at the same time, one under HGO, one under RCG. They both were withdrawn and canceled, but when I inquired about that, the planning department said that that was fine. They can apply for two different development permits concurrently. They allowed that. In this particular case, there was no development permit application under RCG for this site. So again, it doesn't meet the exemption criteria, so it shouldn't be exempt.
Yeah, you've given us a lot to think about, and definitely ask administration and make sure that we've got that process and those policies clarified.
On a go-forward basis, I mean, it will revert back to RC1 on a go-forward, and of course it is a very controversial project. They can still reapply to rezone from RC1 to RCG or HGO. It doesn't preclude them from applying for a new land use redesignation, and it also doesn't preclude them from applying for a development permit under RC1. Or if they decide they want a row house, they can go through the process, come before City Council. But the problem is that if you grandfather this one in, then after August 4th, it becomes a permitted use. We then are not consulted. So it's basically what it is it's a developer that's exploiting the process. And it's not a fair and just process. And like I say, none of the neighbors, the community association, we have not been notified that there's any change in status to this application at this point. So we have requested a meeting with them to discuss it.
Understood. Thank you so much.
Thanks.
Councillor Panasopoulos, please.
Thanks so much. Mr. Worth, are you still there? Justin? Justin, are you still on the line? That's okay, Mayor.
All right, Councillor Chabot.
Sorry, Ms. Atkins, Joanne, you talked very fast and I didn't quite catch all of those addresses. Would you mind relaying that information again so that I can write them all down? And
Was that?
I know administration probably caught them all, and it is part of your submission, but if you don't mind.
Yeah, Ms. Atkins, if you don't mind approaching again and just reading out the address.
I just didn't quite catch who he was asking. So,
It's Councillor Chabot.
yeah, the two addresses that we would like added to bylaw 28P 2026 are 132 Varsity Estates Place Northwest and 4607 Valiant Drive Northwest. Neither of those meet the city's exemption criteria.
Right.
Yeah,
and no, I did catch what you had to say. I just didn't catch the addresses. So 132 Varsity
Estates Place.
Estates.
Yeah, and 4607 Valiant Drive.
Okay, perfect.
And then we did want 3 properties removed from 27P 2026, 5019, oh shoot, hang on one sec here. 5019 Vienna Drive Northwest, so this is an application for a semi-detached. We don't want it to retain RCG zoning. The other one is 4619 Virginia Drive Northwest. Again, it's a semi-detached application. We have no issues with it becoming RC2. However, we do not want it to retain RCG zoning. For the one in particular on Virginia, we know it's a placeholder application.
So what was the other one? 4619?
Yeah, 4619 Virginia Drive Northwest.
Yeah.
And the third one we'd like removed from 27P is 4508 Vandergrift Crescent. So those are our requests to add 2 to bylaw 28P and remove 3 from 27P, unless council just decides to simply vote down 27P, which we're okay with as well.
Sorry, that last one, 4508
Vandergrift Crescent Northwest. There are others that we, obviously, they're under SDAB appeal. We have an appeal tomorrow. So we're hoping we win an appeal and that those will also revert back to their previous RC1 zoning. But I have not mentioned these here. The ones under SDAB appeal I have not brought up in my presentation, other than just to mention them.
SDAB ones haven't been concluded yet, have they?
Which one?
The other ones you didn't mention.
Yeah, they're under number 6 in our submission. And they were applications that, you know, were made prior to first reading, and they are all being appealed. And so I didn't include them in either 27P or 28P, but we are hoping that they will be contained in a future bylaw should we win at SDAB.
Yeah, well, we're going to have to address that issue as well.
Well, it's an extremely important issue. The SDAB process should be allowed to play out. We have heard there are developers who are deliberately slow walking their approvals and that have asked for their approvals to be made after August 4th. As long as there's no deadline for that appeal process to play out, everything should be fine. Council can easily bring a bylaw forward in Q1 of 2027 to revert those zonings back for any SDAB appeals that are overturned. Very easy to do.
Yeah, no, I agree. All right, thank you. Thanks for being here. No further questions for me. Thank you.
Thanks. That concludes the panel, but I just wanted to jump in as chair and state my understanding of the legislation is that as part of this public hearing, we're not able to add properties because those properties had not been advertised, but deletion from the list is possible, but my understanding is that to add a property would require a new public hearing to be conducted for that. Deputy Mayor Kelly, please.
Thank you, sir. I was slow there jumping in. Ms. Atkins, if you wouldn't mind.
Hi.
Because I think you raised something interesting here about duplexes. And so it's an interesting one here. I'm wondering if you can just to be really clear for us in terms of, I'm looking specifically, I believe it's the Valiant and the Vienna, if I remember correctly. If I remember correctly from taking a look at these previously, it's an RCG lot. Its previous zoning was an RC1. But what is proposed to be built under the RCG is a duplex.
Correct.
So technically what would normally be an RC2.
That's right.
And so what I'm hearing you ask here is, instead of canceling it or anything along those lines, you're asking us to rezone it to an RC2 to match what is on the property, what's being built on the property.
Yes, so it would be amending the bylaw to change that section map. So that property that is illustrated on that section map would, instead of be RCG, it would be RC2. And as I mentioned, that should be possible to do on the floor of council without re-advertising. And because basically it's a use that is allowed under both designations. The biggest thing we want to prevent is a subsequent application for a row house under RCG. We're okay with RC2 and we're okay with a semi-detached, but we're not okay with a row house.
So what you're concerned about here is that they've got their approval, or if it's...
Well, one is still under review and one has been approved.
Vienna has already been approved.
Yeah.
And let me just pull up it's Virginia, right?
Yeah, the other one is 4619 Virginia Drive. And so that particular one, it was submitted prior to the deadline, but what was interesting about it is there were so many relaxations, and the file manager has asked them to completely redo the plans and submit amended plans, and they haven't been submitted yet. So, I mean, it may not even be approved for a semi-detached, but the problem is after August 4th, they just withdraw that application, and there's been no attempt to amend it, even though they've had several weeks. So I think that it's a placeholder application where they actually want a row house. They're just waiting for August 4th. They will withdraw that application, and because they have RCG zoning grandfathered in, they will then submit a development permit for a row house. And we can't appeal that because it will now be a permitted use.
Thank you for the clarification on those, because I think that's important for us to hear that there are these ones. In your opinion, would some sort of amendment, if we were to make some sort of amendment here whereby if you withdraw your development permit application or your development permit application expires, and at that point you would be reverted to your previous land zoning, would that address what you're speaking about?
Yeah, that would be fine. Now on Vienna Drive, they've released that permit.
Correct.
But, you know, again, they don't have to build that permit. The permit may have been released.
But if they don't build what they said that they would build, i.e. the duplex.
Then we're fine to have it go back to RC1.
Okay, thank you.
But like I say, we don't have an objection to RC2.
Yeah, the RC2 one I think gets a little bit more complicated, but I may ask administration some questions on that one.
Yeah, we just want to prevent someone coming at a later date with a row house because it was a property that was intended to be included in the repeal.
Okay, thank you very much. I appreciate your time.
All right, that concludes the panel. We'll start building our next one.
Hi, Councillor. It's Justin.
Unfortunately, we've missed the opportunity to speak with you. We have a council member who was interested in speaking but wasn't able to catch you.
Okay, sorry about that.
No worries. Thank you for being with us. So now we'll assemble our next panel. Going to start from some names from panel 20 here. Ida Stanley, Craig Kolochuk, Kalem Heron, John Tatlow, Khalil Irani, Sami Ibrahim, Cheryl Sullinger, Alan Wolf, Shamir Gaydar. Okay, come on down, Shamir. Emil Kotari.
Here, online.
Thanks, Emil. Please stand by. Do we have Justin Similak? Claudia Hudspeth? Denis Robinson? Shelley Tuluk?
On the line?
Thanks, Shelley. Please stand by. Melanie Swales? Terry Wong? Anybody else who I have not called who wants to speak to this item?
Is Flora Gillespie's here on the line, Mayor Farkas?
Okay, Flora, we'll include you as well. Please stand by. We have one spot for one more person. Anybody else that I've not called that wishes to speak to this?
Hey, this is Justin.
Hello, my name is John Tatlow. I'm here on the line.
Is that you, John Tatlow?
Yes, it is.
Okay, so that will be our panel. We'll go with Shamir. We'll go to Shamir, then Emil.
Melanie Swales, I'm on the line.
Unfortunately, we've filled the panel, all the other speakers. I've assembled the 5, and then after this panel is concluded, we'll be building the next one.
I'm assuming Craig Kolichuk is on there, Mayor Farkas?
We've assembled the panel. I'm just going to state the names of the 5 people we're going to hear from over the next half an hour or so. Okay, so our panel that we're about to start will be Shamir, then Emil, then Shelley, then Flora, then John. So Shamir, why don't you start us off? And let's make sure everybody is muted unless you're actively
You missed Craig Kolichuk, so do I have to wait to the next panel?
Yes, unfortunately, we'll be calling more names after this panel, but we do 5 at a time, and we have to assemble amongst those who answer us.
Okay.
Okay, so everyone please make sure to hit mute. We're going to start us off with Shamir, please.
Good afternoon, Mayor Farkas and members of council. My name is Shamir Gator, and I'm here on behalf of the Calgary Inner-City Builders Association. I'm not here today to debate whether blanket rezoning should have been repealed. That decision has already been made. Blanket zoning has been repealed. We respect the decision of council that council has reached. What I'm here to speak about is the business confidence and the message Calgary sends to those investing in our city. When council made a decision to repeal blanket rezoning, it also recognized that builders, developers, homeowners, and investors had already committed millions of dollars based on the rules that existed. Council established clear exemption criteria and a clear time frame. Everyone knew where the finish line was. Whether people agreed with those times or not, there was certainty. And certainty is what allows people to make informed investment decisions. Today's report simply follows through the commitments council already made by identifying the projects that qualify for those exemptions. We've heard comments over the past days suggesting that targets have somehow been moved. From industry's perspective, they have not. The timelines and exemption criteria that council established have remained the same. People, investors, Calgarians relied on those rules when deciding whether to proceed with projects and invest significant amount of money and time. If council changed those rules now, after people relied on them, it creates uncertainty that extends far beyond the development industry. It sends a message that even when council establishes a process, defines the rules, and sets timelines, those rules can still change after people have invested significant time and money. That affects confidence not only for builders and homeowners, but for every industry considering investment in Calgary, whether that's technology, energy, manufacturing, life sciences, financial services. Investors want to know Calgary is a city where decisions are transparent, predictable, and reliable. We also encourage council to look at the data on application volumes. Since these changes began, applications for established area row housing have dropped significantly. That demonstrates that industry has already responded to council's direction and adjusted accordingly. Finally, once this process is complete, industry is eager to work with council and administration on developing a replacement framework. This is needed. one that takes into account communities, the city, and industry alike.
One more time for turning on. Wants an
Please,
RCG.
please mute yourself in order to be respectful for the current speaker.
A framework that identifies the right locations for additional housing provides certainty for everyone involved and ultimately will result in more attainable and affordable housing for Calgarians. We respectfully ask Council to support these bylaws, honor the commitments and timelines that were already established in the original repealing, and allow this process to move forward. Thank you.
Thank you. We'll go to Emile next, and then Flora after that.
Hi, can you hear me?
Yes, we can.
Okay, afternoon all. My name is Emile Kothari, and I'm a resident of the community of Varsity, representing my family today. I've lived in Calgary for 48 years and care deeply about the city. I appreciate the opportunity to speak to you today, and I wish I could have been there in person. Can the clerk bring up my attachment, figure 1? Let me know when you see that. My comments are regarding a property at 132 Varsity Estates Place, which I live 3 doors down from and has an unresolved development and rezoning application, and thus may retain its RCG zoning if it is exempt from blanket rezoning repeal. I am strongly opposed to the subject property retaining its current RCG zoning and ask that you revert it to its original RC1 in August. Not doing so keeps the door open to a 5+ unit row house to be developed, which is completely inappropriate for the area. My comments today will focus on why this is the case. This is a consistent position to what was presented by the Varsity Community Association a little while ago, item number 5, and I would say the greater Varsity community. There's been incredible community resistance to this specific development since it was proposed in the first half of 2025. This is evidenced by attendance of hundreds of residents opposing at multiple community meetings in the last couple of years. Many submissions have also been submitted into the city via the portal on the opposition to the permits associated. Do you guys see the attachment?
Yes, we do. We see
Okay,
figure
perfect.
1, Varsity Estates community map. Yeah.
Excellent. So regarding figure 1 there, if you start on the left side of the image, it shows the entirety of the Varsity Estates region contained within the pink border. This is a sub-region of the greater Varsity community. All dwellings here are single-family detached, with a few exceptions. There's a couple townhouse developments and 1 multi-level seniors home. Note that they have generous spacing away from the adjacent single-family detached homes. The image on the right is a zoomed-in version to the subject property, 132 Varsity Estates Place. Note that it's in a cul-de-sac without any back lanes and sits about less than 100 meters from a major egress point out of the community. The row house a row house on this location is completely inappropriate for the following rationale. It represents a radical densification change, single units to 5 units, material negative impact to parking and congestion. There's no back lanes and there's a low curb perimeter within a cul-de-sac. Safety, this row house building height and reduced setbacks block views for passing cyclists, pedestrians, and vehicles at the cul-de-sac and main drive intersection. And that creates, a much greater probability of collisions and injuries. If you could flip to the second page, figure 2, please. And I wanted to comment on, a very inappropriate architectural context. It's mainly mid-century modern 1975 homes in the area. On figure 2, you see proposed design iteration from the developer, and you can kind of see the views from the north to south, and then within the cul-de-sac from the east. You can see nearly the proposed development is a wall of buildings nearly double the height of the adjacent 2 stories, which have much smaller setbacks to the curb and adjacent properties. This would permanently damage the character and architectural integrity of the community. So in closing, I believe we do need to continue to densify within Calgary to accommodate population growth, and it needs to be supported by all communities. But I think in a way that considers and respects each community's unique situation and needs. And a lot of people have talked about that today. Blanket rezoning was far too blunt an instrument to achieve this without significant collateral damage for neighboring residents. And I applaud you guys for acknowledging that and making changes. 132 Varsity Estates Place retaining an RCG zoning is an unintended consequence of that flawed blanket rezoning approach. And I want to make sure that this one doesn't fall through the legislative cracks. A 5+ unit row house on this parcel is completely inappropriate for this region of Varsity, and I urge you to revert this property to RC1 in August and correct this technical error. Thank you for your consideration and time.
Thank you so much. Please, everybody, mute. Please hit mute unless you're the current speaker. Thank you very much. We'll go now to Flora and then John after that. Please go ahead, Flora.
Thank you. Mayor and Council, here we are again. We expect government to provide us stability, security, order, structure, in other words, rules and laws. And in return, we give up some freedoms to live under these laws. There is, however, an expectation that these rules or bylaws be fair in the way they are enacted and applied. If a community senses their voice is not heard or a particular group is being given special consideration, then citizens will question their government. It's clear that Calgarians wanted to repeal blanket rezoning. It was the main issue of the mayoralty race. Implicit to that repeal is that the original zoning on all unbuilt parcels be reinstated. But this is yet to happen. Meanwhile, development applications have poured into planning departments as developers took advantage of the delay. And today, rather than finally laying out the rules for reinstatement, Calgarians are here to discuss exemptions and further amendments. I kind of feel citizens have been misled. Our beloved Calgary neighborhoods could use council support before this autocratic administration rams through yet another density without Calgarians being even made aware of them. But where there's willingness, there's a way. And in order to put the toothpaste back in the tube, may I offer some suggestions for a motion arising? Number one, RCG development applications currently in the queue should be reviewed, be allowed to proceed if and only if they meet all the RCG requirements without exemption. Two, already approved RCG lots that remain unbuilt until the time the DP expires should revert back to the original zoning, at which time they will have to make an application for a land use change or whatever they want to do. I also wish to specifically, and I'm not going to come back for 733, object to the proposed amendment 733, which allows for secondary suites and garage suites to become permitted use. We all know that the repeal of blanket rezoning brought our voices back to council chambers. But this amendment once again eliminates our voices and takes away our right to appeal individual decisions. This amendment has been made in the absence of the adequate and wholesome consultation with communities and their residents. In closing, I urge council to reinstate thoughtful, balanced planning processes and commit to meaningful reform within the planning department. And sorry, just one other thing if I have a minute. And with some respect to my fellow citizen Shamir, who spoke before me, I remind council, forget the market-driven, investor-fueled supply policy of the last 30 years. It has not made housing affordable. And number two, don't bail out developers or office tower owners. Thank you for your time.
Thank you so much for being with us.
To speak after Amir, I'm available.
Please stand by. We have a committed group, or rather we have a committed panel here that we're going through.
And I'm in that panel, Mayor. I was supposed to speak after Emil.
Yep, please go ahead. Oh, sorry.
Can I speak?
Just one moment, please. I'm just calling folks in a proper order. It's John Tatlow, and then it's going to be Shelley Tulick after that.
Good afternoon, Mayor Farkas and members of council. My name is John Tatlow, and my address is 2406 Bayview Place, Southwest in Calgary. 27P 2026 has not affected my property directly. However, I have listened carefully to the citizen presenters over the past 2 days and truly empathize with the challenges and grief that they face. In any event, please let the record show that I vote a solid no, N-O, to 27P 2026, the grandfathering issue. This entire process has been unfair to residents, and it is time for a clear end to blanket rezoning for all the reasons stated by the prior citizen presenters. Thank you.
Thank you so much. We'll go now to Shelley Tulick.
Thank you. Good afternoon, Council. Let's talk about illegal spot zoning. Carving out a custom list of properties to retain high-density privileges creates a discriminatory multi-tiered zoning system that violates the Alberta MGA's requirement for uniform land use regulations. Building permits are the legal threshold. A development permit only approves land use, as we've been discussing, not construction. Legally vested building rights are only secured once a building permit is issued and physical construction begins. Vulnerability to active SDAB appeals. Any issued development permit is legally unstable, and cannot be exempted if it is currently being challenged within its mandatory 21-day SDA appeal window. No good faith reliance. Developers rushed applications through knowing blanket rezoning was highly contested and facing repeal. They cannot claim innocent financial reliance on an unstable and temporary policy. Automatic expiration of stale permits. Council has no obligation to exempt projects that have not broken ground. Any unexercised development permit should be allowed to die its natural death here in August. Illegal spot zoning. Under Part 17 of the MGA, a municipality's land use bylaw must divide the city into clear and uniform districts with consistent regulations. Carving out a specific list of individual, random, one-off properties to retain unique high-density zoning configurations creates an unconstitutional multi-tiered regulatory system that violates the statutory requirement for uniform public interest planning. Building permits are the legal threshold. Municipal and construction laws dictate that a development permit only verifies that a project conceptually aligns with local planning bylaws. According to the City of Calgary Planning and Development Guidelines, a separate building permit is required to authorize the actual onset of construction. Legally vested rights to build are not secured until a building permit is granted and physical work begins on the site. Vulnerability to active SDA appeals. Under Section 6861B of the MGA, any affected community member or association has a mandatory 21-day window from the date of development approval is advertised. Some of them don't sound like they were advertised, so that's a pretty big glitch. For appeal, per the SDAB board, a permit is legally unstable and cannot be safely grandfathered while an active appeal is pending. No good faith reliance. In Canadian administrative law, a developer claiming damages for sudden zoning changes must establish that they incurred severe financial loss in innocent reliance on a stable municipal framework. Because the blanket rezoning policy faced highly publicized community backlash, council friction, and formal legal challenge since inception, developers rushed mid-flight applications through did so under a visibly volatile framework, compromising their claim to innocent good faith reliance. Automatic expiration of stale permits. Under standard municipal land use guidelines issued, DPs carry strict statutory commencement timelines. If a developer fails to activate beginning construction within the city's prescribed timeframe, the permit automatically lapses and becomes completely void. Council is under no obligation to extend or exempt projects that have failed to execute their permissions. Incorrectly grandfathering exemptions creates unlawful, unequal, and highly vulnerable contravention of MGA, spot zoning, and a violating of core MGA and city policies. My comments rely on 3 pillars. First, applicants have foreknowledge, and that therefore negates good faith reliance. Everyone knows, including Mr. Schmier, thank you, that the August repeal was coming, and the assumed business risk, knowing blanket rezoning policy was and when was being terminated. Mid-flood protection is therefore nullified. 2, violating principle of uniform application under MGA. 200 random spot zoning is, or 200-ish, is discriminatory zoning, while 306,000 others immediately revert back and their neighbors. Unequal rights unequal rights for equal parcels side-by-side lots must have the same rights. Overriding the SDAB authority is interfering with the independence of a quasi-judicial board. 3, ungrounded liability claims or vested rights principle. Zoning changes were known, therefore damage claims are without merit. DP is concept. BP is when fully vested rights kick in and shovels hitting ground. Exemptions would be...
Thank you, Shelley. You're just at time, but perhaps a final sentence to conclude your thoughts?
Sure, one sentence, and then I just have like 1 page if anyone wants to ask me any questions. Exemptions would be the city coddling normal, expected, and well-known public business risk at the expense of Calgarians.
Thank you so much for that. All right, this concludes this panel. I'm going to go to questions from council members. Councillor Yule, please.
Yeah, my question's for Shamir. So we've been here a while, and a lot of this public hearing has been about individual parcels. It's kind of turned into like a public hearing on steroids when we're just trying to figure out everybody's little issue on every little parcel. One of the suggestions we've been given is, you know, voting no on the exemptions. The approved ones would go through as non-compliant legal in their form. But the rest that have not hit the approval stage yet would just revert back to their original zoning. Maybe from your perspective, when it comes to industry, like when we're looking at those particular, there's about 100 of them that are not to the approval stage. They've been submitted, or they're in pending appeal, pending decision, under review. How much is an individual spending on that side of the approval when it comes to the investment side?
Well, thank you for the question. The first thing is, when you're developing a property, it doesn't happen overnight. It's a long process. So dates are dates, but you'll purchase the land, you'll go through a designer, you'll go through, read the bylaws. So it's not as if you can purchase a property and have it in tomorrow. So there's a lot of timelines that were planned before even some of that was done. I know people who've purchased, homeowners and developers who've purchased properties a year before and said, okay, I'm going to go through the whole process. So the planning didn't start when there was an announcement that we're looking at repeal rezoning. So some of those people started well before that. Now, when you purchase that piece of property, you're purchasing it and you have to, you know, own it in that sense. And then you go through the planning and development process. Going through getting the designs, going through getting the surveys done, going through hiring consultants. You can look at $100,000 just on pre-development costs before you even put a shovel in the ground. So then from there, there's additional costs. So those are really in there. Now, the average lot you're looking at right now in Calgary for some of these redevelopments are $900,000. So you're well into $1 million in that. And it's not only developers, but there's homeowners. I know several homeowners that are on this list that have purchased and just want to build it for their family generational wealth and everything there too. So there's a lot of investment, a lot of time, a lot of uncertainty that goes into that.
And maybe just your opinion on, like, if we do vote no and we have these ones that are approved that go in as non-conforming legal, what's the industry's view on that? Like, how do you feel about that?
Well, if they go in as non-conforming legal, yes, there are options, but now you're putting some of these properties into, there might be some financial jeopardies that are going to come in there. So you might have people who can't get their refinancing because of non-conforming that. Banks are very specific, financial institutions are very specific on what can go. So there can be some really big hardships that can be unintended consequences from that. Just with, repealing without some of the replacements, as I mentioned earlier, that has created unintended consequences in industry right now. So those we will never truly know, but if we're carving out and putting some here, some here, some here, that can actually be a big problem for everyone. The key behind it is when council did in Article 7 in the actual repeal back in March, there were clear rules of what council expected. And industry, like it or not, some of those rules were not enjoyed by industry, but they were rules that this council set forth.
Okay, thank you. Appreciate it.
Thank you. Councillor Panazopoulos, please.
Thanks so much. Thanks so much for the presentation. Oh, Samir, go on. Sorry, come on down. Apologies, yeah. I think it's important to chat with you because, unfortunately, last panel there was one landowner that actually spoke, the first one. The rest were impacted. 1 door down, 3 doors down, 6 doors down. But you're actually the builder, the owner, your colleagues and your clients and your members. Reputation, we've heard a lot of people sort of dismiss it. Maybe just speak that from the business perspective, the reputation risk of the City of Calgary, that on December 15th we said one thing, on Appendix 7 we said another thing. We came to the hearing very clear. Just talk through that, how important that is for business confidence from your developer group, your business owners, who are also the landowners, the homeowners of the impacted parcels.
You know what, there's decisions this council has made, and there's this council will make that people like and people don't like. That's given. That is your job, and we respect that, and know that's where it goes. But certainty is so important for everyone. And investment dollars are very, very mobile. Like right now, the blanket rezoning has been repealed, and we've seen, just from our members, that I'm talking to a lot of our members, applications really drop. I have members of ours that were processing just pre-applications on their own, not through the city, but just talking to purchasers, developers and that. They were going through 10 a week. Now, they 1 every 2 weeks. And out of 10, they were saying, okay, this might be a good one, this might not be. Now, their answer is no. So we're seeing those investment dollars already going. But people knew the rules. You set the rules. All of you set the rules here, and that was there. Like it or not, everyone had to respect that from industry. But if those rules change, all we're telling people is, doesn't matter what the rules are, we're going to change the goalposts. The key is those rules were set and followed, and people relied on that. And some of these people have put their life savings into some of these developments. They're not huge, large developers. We have members that are build 1 home a year and members that build 100 homes a year. So that confidence is really important, and my fear is it trickling down, business down 8th Avenue or whatever, saying, what confidence do we have?
You said uncertainty far beyond this item, and I might have got the last part wrong.
Yeah.
Can you expand on that?
Uncertainty, right now we're talking about rezoning. We're talking about rezoning of RCG. Tomorrow it might be, it might be something else that has nothing to do with development. But people who are not in development are still watching this hearing. They're still listening to what council has to say. Knowing that when council says this, this is where it sticks, this is where they went, that is really important. So that uncertainty beyond the development industry is really important as well. Because it doesn't matter what it is, houses are built by our membership, but people living in those houses have jobs here. They rely on what the city, what direction they're going. So there's multiple things that have come up in the news over the last few months where certainty has just shown how important it is to every Calgarian, every investor.
I appreciate that. You said the data you have, volumes are down. There's a narrative, a lot of Calgarians are fearful that there was a mad dash up to and including April 8th to get your DP, in the record or in the system. Can you speak to that? Was it an actual mad dash end of March, April, or was it pretty stable?
A mad dash would have been bunch of properties being purchased like crazy and, let's go in, you would have seen a huge uptick in the MLS data, which if you saw that huge uptick in MLS data, that would have been reported on the news all around, which there wasn't. So that's kind of where that aspect comes from. But when it was announced that there will be repealing of rezoning and the rules were clearly defined, what happened is if people were sitting on the fence saying, well, maybe I won't develop it this year, maybe I'll develop it next year, they had to make a decision either to go ahead or not to go ahead. So council essentially forced their hand in making that decision. So when you're talking about a dash, it wasn't a dash, it was just some of the decisions were forced ahead of time and some were delayed and said, we're not going to do that.
Amendments. There's some conversations about the August 8th date. And a few amendments would be if you're at SDAB, let it sort of figure out. At the end of the day, if you lose, the lands would revert back potentially to its prior classification. The same for development permits, whether your members pull the DP or it gets rejected. Can you speak from an industry perspective how palatable that is? That potentially, if that amendment was through, it's RCG today, your DP fails, it reverts back to R1.
I'm going to go back to the same thing because I've heard multiple different views on where people are standing on that, different ways of amending it. But again, I go back to the same thing. The rules were set. Article 7, we all read them. We all relied on them. And that was the most important thing. I think changing that can cause issues on both ends.
What about the change? I guess it's do you support the thought process that you're absolutely correct? We gave an industry the right to enter that DP up till April 8th, and that would hold your RCG, or whatever the classification, there's HGO as well, so it holds at higher level classification. But had you done nothing, that property would have reverted back to its lower classification. So therefore, you think it should be the privilege or the right that the fact that I had a DP during that period, I should be able to hold that higher classification in perpetuity? Or do you think you could accept a lower classification in the event the DP was rejected or pulled by one of your members?
Well, the application said if you applied before April the 8th, the first reading, you would hold the zoning that was there prior to. So RCG would remain. That there gave clear, defined rules on where that would go. So people who applied for that were, of course, expecting that. Now, I'll tell you, there are people who didn't apply for that, who did not want to apply for RCG and own the property. They clearly knew where that was going. But the rules were set of, if you apply, this is where you're going to go. You're going to retain your rezoning. And if you don't apply, you're going to go into the rezoning map and your rezoning will change to RC2, RC1, whichever way. But there were a lot of decisions made upon that. So knowing that April 8th was the date, people had to make a decision if they were going to go through, put those investment dollars. And as Councillor Ewell mentioned or asked me earlier, that's a lot of money people have invested into that property, knowing where that's going to go.
And maybe I'll just end on that. You threw a $100,000 pre-development cost, and I was going to ask that. And I want to, and it also takes a long time. You know, you have plans and things. So I think the real conversation are those properties that are sort of in the queue. Would you suggest that the majority of these 247, assuming they were there for redevelopment, it would be closer to that $100,000, or just given the passage of time to get to, maybe I'd ask another way, to get to a DP, is it generally that $100,000? Is that a good rule of thumb? Are we thinking, was that $25 million? $25 million of capital is exposed?
And I would say, yes, that's exactly where the number is. Now, 100,000, depending on which properties are, some are higher, some are lower, so I'm using an average.
Yeah, okay, so when we start thinking about that, that's $100,000. And if it was to be taken away, would that value go to zero? Because you have to come back and go to council and then reapply for a higher use in 6-12 months and so on and so forth. Does that value completely disappear?
Well, in a way it does, in a way it doesn't. Because you can retain certain things, like you did a development permit survey. That survey would still be valid because that works. But on the opposite end, you're adding more time. And as I mentioned earlier speaking in council, $500 a day. So that time will add more cost in doing that. Now, if it gets appealed and it's, and the decision gets overturned, yes, you're going to have those. But going through and going back to that will end up losing that cost, yes.
I think in closing, I really appreciate you sort of said, you know, the recognition from industry, blanket rezoning is dead. This is not a rehashing of blanket rezoning. This council is very clear, Calgarians are clear, it's gone, it's over. It's the echo that we're sort of dealing with, and you're looking for certainty on that. This isn't some ask to reinstate a failed policy. This is truly to say a promise made by council in December to hold it through so that the 247, is that a fair assessment of?
That is exactly a fair assessment. I was talking to someone earlier today, and like when you're driving a car, when you hit the brakes, the car does not stop immediately. It takes a few seconds to stop. It takes a little bit to stop. These are those last little ones that are in there. But again, they were defined.
Thank you so much. Thank you so much for presenting. Thank you, Mr.
All right, Councillor Schmidt, please.
Mr. Goddard, you as well, just given that you offered a perspective that we haven't heard yet, so and we might not hear it again. How often in your time working with development permits and land use have you experienced a retroactive change to something once you've applied for a development permit?
Never. I've never seen a retroactive change where we're going in, you get approved, and now it's coming back and saying, well, or you applied, and that being taken back. The certainty of knowing what the zoning was very important.
And what about situations where you have built on a non-conforming land use?
That have never done that either. Never built on a non-conforming land use. So I don't know what the ramifications are from a financial perspective or from a legal perspective.
So just, you know, from your experience in this world, if those two things occurred, what would you see as potential outcomes for us building homes in Calgary?
Well, I'll tell you, the confidence will really, really go down in industry. We're already seeing it right now, where confidence has significantly changed from industry members. We're seeing some of the investment dollars already flee because they don't know where certainty is. So that already has made it more difficult, which is there. And again, the numbers, don't trust me, trust the development numbers you will be getting from your administration very soon, because again, we're still looking at last quarter's numbers. The new quarter's numbers will show a lot more on where the development permits have gone. But that uncertainty and knowing that the rules can change mid-flight when they were clearly defined is a big issue for industry as a whole. And not only in established areas, but in greenfield too. It's for all those investment dollars.
And what about, you know, let's say somebody decides to build on a non-conforming land use because they have a DP that says they can. So the DP gives you property rights, essentially, to do that. How much uncertainty would that create for not only the builder, but the surrounding community and everybody as well, if we set a precedent of having situations where you can often build, or where you have a lot of properties being built at one time on non-conforming land uses?
I think that uncertainty is going to it's going to echo for years after this in Calgary. So if we go ahead and we start building non-conforming buildings, where does that take us? What does that say about what our land use policy is? What does it say about what council is determined and what we're building? So those non-conforming are opening up a whole different set of problems that I don't think anyone here can anticipate truly yet.
And another comment we've heard is that, because you touched on it a bit, where the idea that developers were rushing to send in development permits knowing this was happening, but also that those permits were being expedited to reach a certain date. So have you seen through your travels that this expediting has been happening, or that the process or the rules have changed for people applying in this way? We heard from our administration that that's not happening, but we're hearing other things from other public speakers as well. So have you experienced that, or have people you know experienced that?
Well, I will say certain processes have changed. The scrutiny has been a lot higher. Administration has been looking over these files, making sure, double checking, making sure they are conforming. So it's actually worked the opposite way, where there's been more of a magnifying glass on some of these developments to make sure that they do fit where they need to belong. Because there might have been a worry, but it was checked to make sure there wasn't.
Okay, thank you.
Yeah.
All right, I believe that concludes this panel. We're going to start from zero and look to assemble our next panel of 5 speakers. So, as I
experience that,
make sure, please mute. Please mute.
I will say certain processes have changed.
If you're not called upon, please stay muted on the line because we can hear you in the chamber. All right. Saeed Bashi, Christina Provencher, Darcy Dean, Ji Zhang. That was me.
It's Craig Kolichuk. You missed me on the last panel. Do you mind if I speak this time?
I'm going to start from the beginning, just to be fair. That's the practice we established. So please stand by until your name is called. Brianne Reed, Doug McFadden, Jennifer Huol-Femakinde, Frank Stewart, Patricia Morden, Tony Payne, Remedios Thompson, Dimitri Suterman, Puneet Sethi, Tyler Wells, Ida Stanley. Is that you, Ida? Okay, come on down, please. You'll be our first presenter. I need to call for 4 more names, though. Craig Kolichuk.
Here.
Thanks,
Thank
Craig.
you.
Please stand by. Kayla Heron. Khalil Irani. Sami Ibrahim. Cheryl Sullinger. Alan Wolf. Justin Similuk.
Hey, I'm here.
Thanks, Justin. Please stand by. Claudia Hudspeth.
Hi, Mayor Farkas. I'm here online.
Thanks, Claudia. Please stand by. Denis Robinson. Was that you, Denis?
Yeah, I'm here.
Okay. So that'll be our next panel. It'll be Ida, Craig, Justin, Claudia, then Denis. Please go ahead, Ida. You have 5 minutes.
Thank you. My name is Ida Stanley. I've been living in Albert Park for nearly 40 years. And I've been on the council or the community committees for almost all those years. I want to address 2742 10th Avenue. This is a beautiful brick home that had a beautiful yard, and it was sold 2 years ago. And as of that time, there has been no maintenance of that yard. And apparently the other 2 people have addressed that home. But I am really cheesed at how these developers will purchase properties and then abandon them. There's one on the end of 10th Avenue and 26th Street that has been abandoned since before COVID, and they stripped it of all these beautiful, beautiful 40-year-old ornamental trees and dug holes right up to the sidewalk, and now it's being used as an encampment, and there's weeds taller than me, and it's just, the snow isn't cleared. That is just really disrespectful to these people who have paid hundreds of thousands of dollars for their homes and have renovated them and kept them up and their yards. On the 2802 and 2810 on 9th Avenue, that is replacing, I believe, 2 homes, and it's just massive. It's on the north side of 9th Avenue, And I knocked on all the doors on down 9th Avenue. Nobody knew that this was happening. Nothing was posted. When I phoned bylaw and complained about how the fencing was not closed off, there's a pile of dirt that must be 15 feet high that children are very tempted to climb. There are deep window wells. They're 5 feet deep. I couldn't possibly get out of them if there was a fire and I was living down below. The bylaw officer laughed at their posting. It said who to call in case of emergency, and it was 911. I would also like to touch on the Franklin train station. That has really caused a lot of concern in my community. I read the Bill of Canadian Rights and Freedoms, and Article 2 says that we have the right to pursue the gaining of a livelihood, and in Article 7 it says everyone has a right to live in liberty and security of person, and that cannot be deprived except in accordance with principles of justice. There are 400 cars that park there every day, and the people in engagements just basically called me a liar. No, you're wrong. Well, I've talked to a bus driver that has driven into that lot several times a day for the past 6 years, and he says it is absolutely full, as is the north parking lot at Franklin train station. Their DP, which is 2026-03241, was submitted to council on May 22nd. We, as a CA, were notified on June 20th. I phoned our liaison people and asked, what is the template for a petition? And the answer was, well, we can't tell you that because we would be choosing a side of this debate. And I just couldn't believe it. Their sign was finally put up on July 7th, and that sign has a contact name of Paul Shannon, who represents Nor's Construction. What is a City of Calgary sign doing advertising the developer's information? I find that troublesome. We were given a new date. Originally, the date was July 9th. Then Julius, our person at the city, said we could have up until the 14th for feedback, and now we have till the 30th. And now, on July 20th, the sign went up at the outside of the parking lot. This parking lot will be closed the end of August. And we haven't even given our feedback. And I just think that's morally reprehensible.
Thank you, Miss. You're just at time. Perhaps a final sentence to conclude your thoughts.
Well, I have collected 1,000 signatures in 2 weeks of people knocking on doors and people who use a transit that are desperate to keep that parking lot. It is not just a parking lot. It is the way people make living. It is how parents deliver their kids to daycare schools and then try to save on money and save the environment. We've been encouraged to take that C train. We've spent millions on extending it.
Thank you so much for being here with us.
Thank you. I appreciate the opportunity.
Thank you for being here. We'll go now to Craig and then Justin after that.
Good day, Mayor Farkas and City Council. Thank you for the opportunity to speak. My name is Craig Kolachuk. I'm in strong support of exempting these rezoning applications. I live at 1320 23rd Street Northwest. I have 5 lots on this block that are affected by this rezoning exemption. The applications are DP 2026-01676 and DP 2026-01674. I'm not a typical developer. This is actually my first one, and I live in the community. I put these lots together over the last 25 years, and I'm building a home for my family. I've witnessed the area density change over the years, and my objective wasn't to jam in as many units as possible on these parcels. I deeply care about being a good neighbor and building something that fits well in the community. So I've been very proactive with community engagement to gather feedback, which included door-to-door visits with my neighbors and hosting a town hall meeting. My proposed plan is to construct 2 semi-detached units per lot, which is a reasonable, responsible, and sensitive densification for our community. We are less than 1 kilometer from the Lions Park C train, and this type of project is supported by the Community Association. I kicked off the design and business plan last fall under an RCG zoning and have spent a ton of time and resources getting to this stage. For perspective, as a question came up on the last panel, I've spent over $150,000 to date, which includes permitting fees, engineering reports, surveying, and architectural plans. Currently, I've completed my 3rd round of detailed review, and I should have an approval very soon. All residents received a notice in the mail in February this year informing Calgarians about a public hearing on March 23rd to contemplate reversing the rezoning. This letter specifically indicated that all submitted DPs before first reading of Council's decision on a proposed bylaw change would be exempt. I received some further feedback in writing directly from the planning department to confirm the same. In good faith and relying off published city policy, my development applications were submitted on Friday, March 20th, before the initial hearing began. There was no gaming the system. The logic, timelines, and process was very clear to me. I respectfully ask that this written policy from Council is upheld and allows all these applications to be exempt. You must accommodate old applications that were caught in the interim period. Financial decisions were made. You can't make everyone happy, and this is only fair and the right thing to do. Unfortunately, there are consequences from the changes that old City Council put in place, and this is beyond your control. I'd also like to add any further changes to current rules would adversely affect our city planning department, who are inundated with questions already under a heavy workload. The reputational risk, which has been mentioned a few times for the city, is significant if they don't follow through with the promises that were provided in writing. Never mind the significant legal exposure that the city would face. The potential fight from these 247 applications would be very costly to taxpayers. And let's please put in perspective that this is a fraction of 1% of the 300 plus residents in Calgary. Business and real estate investment in the city is dependent on confidence and clarity in the defined rules of business and process. Please realize that there are huge financial consequences for us that are caught in this crossfire. To change direction and disallow this exemption would set a dangerous precedence. I got to be honest, I thought this specific council meeting and approval of this zoning exemption was more of a formality, an administrative exercise, you could say. This appears to me to be a repeat of the March hearing, where most feedback so far is expressing concerns about specific applications, process, etc. I will conclude saying that the last zoning change needed some amendments. I applaud Council for making this a priority for Calgarians. We should not allow an 8-plex with 4 suites and only 4 garages, for example. It doesn't make sense to me. We need to find a healthy balance for communities and builders that makes our city unique, investable, and allows for affordable housing and smart densification in the inner city. That's all I have. Thank you very much.
Thank you so much. We will now go to Justin, and then Claudia after that.
Hi, Mayor. Is it okay if I just kind of do some comments about the next 3 items instead of phoning in each time on every one of them?
Yeah, it's all good, man. You got 5 minutes?
Cool. So, hello, Mayor and Council. I'm Justin Similuk, and I'm just kind of incredibly confused about what we're doing here today. I know I'm normally out here trying to crack jokes, get some yucks from the crowd, maybe make some golfing references, but this time I'm going to be a little bit different. It seems like we're trying to take things back further than what we had before, which isn't what we discussed during election campaigns or nuances about zoning. RCG has been around for a lot longer than the rezoning of Calgary, and now we're trying to scale it back to more than what it was before. If we go on to get some history involved, Calgary's historically been blanket downzoned over the course of its time as a city. Something that a lot of you say is like a blanket approach doesn't really work. Generationally, we've been making it more difficult to fund and finance the city we're building and have to have our developments occur and preventing our developments from occurring organically. There are absolutely fingers on the scale of fairness when it comes to redevelopment in the inner city. You know, there's a lot of guys out here that proclaim to be data people, maybe fiscal conservatives, maybe small government type, and I totally believe you. I 100% can get up behind a lot of these things too. It might surprise the mayor, but he and I probably agree on a lot of things. But for some reason, when it comes to housing and development, you know, we kind of throw all our values and beliefs out the window and just kind of fall back on these emotional responses that have put us in these precarious situations. It's difficult. Change is difficult. But we're at a breaking point of a city where if we don't change, we're going to have very big problems. Those problems are starting to rear their ugly heads, and it's not going to be good. Moving forward, there won't be another council to blame for failures that are going to happen now. The buck stops here. I opened the Calgary Herald today, figuratively, because like nobody actually gets newspapers anymore, but this headline really jumped out at me. Multi-billion-dollar funding gap leaves city infrastructure at risk. I walked around the city a lot during Stampede, and I can attest that we are failing at running this city right now. I totally agree with a lot of the views on this council that you guys share, where we need to get back to core services. What I saw on my walks were crumbling sidewalks, terrible roads, garbage, bad transit frequencies, and delays. But if we think that these problems are going to be fixed by continuing our status quo development and pretending that nodes and corridors will save us, I got bad news for you. You know, another Olympic bid had been brought up, and I remember when World Cup games were being announced, there were questions about why Calgary didn't get a game. And I actually believe that we wouldn't be able to put on a global event like those and be able to put Calgary in a good light that shows it off to the world. And that kind of makes me really sad. This council is not the ones who steered the ship towards this funding gap and these development problems. But now it's time to find out who wants to lead the city in the right direction. Campaigning's easy, but being a leader is far more difficult. We need our leaders to step up and make difficult decisions that will put Calgary on the right path to success. And those decisions aren't necessarily always the most popular ones with constituents. Please consider the larger impact that neutering inner city development has on the future of this city and our finances. Row houses are fine. Thanks.
Thank you, Justin. We'll go now to Claudia, then Denis after that. Please go ahead, Claudia.
Thank you, Mayor Farkas, and thank you to the City Council. I know that these hearings are long, as they have been for the blanket rezoning repeal, so I really appreciate all the time. I'm going to speak to bylaw 28P 2026, specifically to a property on that list, the very first property, 8919 48th Avenue Northwest in Bowness. So I just want to say that we launched an appeal in early 2025, and I say we as a community, so I'm a community member in Bowness, and I worked with our neighbors to launch an appeal on a development on that piece of land, which was proposed to go from a single typical Bowness bungalow to a double duplex with secondary suites that would have converted that small bungalow to 8 units with 20 separate bedrooms on a very busy street right in front of the park. We won our appeal at SDAB on several grounds. One was critical massing that's out of context and wouldn't maintain the community character, improper setbacks, and then shadowing and privacy concerns for our immediate neighbors. That appeal process took 8 months of time. It involved mobilizing 18 neighbors to speak on multiple appeals process hearings, hundreds of hours of time and thousands of dollars that cost us as Calgarian citizens for planning and legal support. So when the map came out for the exclusions from the repeal of the blanket rezoning, as a community, we were really shocked that despite winning our appeal and overturning the development plan on this property, that property was excluded from the downzoning. And we just felt that at that time we contacted our city councillor, Councillor Tyers, who was very supportive of trying to get this particular property and other properties obviously removed from the exemption list. So basically leaving this property as an RCG leaves us as a community facing potential multiple future appeals, hours of volunteer time and cost. So I know in this discussion we've heard a lot from developers, but as a community member, the burden has been on us as a community to fight these appeals and fight these developers with massive information imbalances and massive funding imbalances. Like, we don't have the funds as a community to fight what the developers have been able to fight and hire high-priced lawyers and others to fight and who already know the system. So I'm in support of removing of bylaw 28P 2026, and I'm in support of removing the parcels from the exemption list for this property in Bowness and other properties that won their appeals against unsuitable development, and ask that it be downzoned back to RC1 and not be kept as an RCG. And just to say, I find it really surprising and sad that when I look at that list of bylaw 28P 2026, there's only 9 properties citywide on that list that won their appeal. And I think our appeal in Bowness was the only single appeal that was overturned by SDAB and that remained overturned. Other appeals that were won were taken back and reappealed. And I really think that speaks volumes about the imbalance between developers and private citizens to fight some of these really unsuitable developments. So thank you very much to the council and to Mayor Farkas for your time.
Thank you. We'll go to our final panelist, Denis. Please go ahead.
Hi. Thank you, Mayor and Council. So my name's Denis Robinson. I live in Banff Trail in Ward 7. I'm not near one of the affected properties, nor am I a proponent of any of the affected properties. I speak here today to speak to the broader citywide impacts of some of these policy choices. So I think that you should accept this amendment, accept these exemptions, and continue to allow the various development permits or the various projects that are kind of already in the process to proceed under the rules that the exemption rules that were laid out earlier. There have been a number of objections to this. Some of them have been substantive and some of them have been procedural. So really this is a procedural question, but because so much of the discussion has been in the sort of substantive merit of the developments, I'll speak to some of that briefly. Many of these lots are in areas in Ward 7 and 8. Notably, Wards 2, 5, and 12 have 0 developments, and Wards 3, 13, 14, and I believe 10 have under 5 developments. So you can count on fingers of one hand how many developments are, or how many lots are impacted by this exemption. So what we're talking about here is a series of RCG developments, of townhouse developments, or in some cases duplexes or HCO developments being contemplated in the core of the city, near places like the University of Calgary, the Foothills Medical Center, the C Train, SAIT, or the downtown business district. These are all areas that have good jobs, have seen considerable investment of taxpayer money, both in the city and the provincial end, from residents in Ward 2, 12, 13, 14, and elsewhere in the city, as well as outside of the city in the case of provincial investments like the University of Calgary or the Foothills Medical Center. These locations, which offer opportunities for jobs, education, good transit, are not the sort of sole domain of the people who happen to buy a bungalow in them some time ago. We also have an obligation, and I say this as somebody who owns and lives in a bungalow in these areas, to allow more densification so that these critical core city economic areas and services that are paid for by the taxpayers can be used by more people, in particular, young people who, in my view, have the right to the same opportunity that I and most members in this council had to attend university while living in a reasonably priced house or living arrangement. On the procedural front, I had some comments prepared, but I won't get into them. The representative from the Inner City Builders Association was quite clear. If you send a signal to industry that you're going to run things a certain way, you have an obligation to run things that way. Finally, it's been noted repeatedly that some of these projects haven't really begun because there aren't shovels in the ground. But we know from listening to many of the submissions on this and other hearings that a considerable portion of the cost of developing a house is what gets referred to as the paper house. The regulatory submissions, the carrying cost of the property, the architectural and design plans, the cost of hiring a firm to do the engagement that many folks have spoken so stridently in favor of. These costs are just as expensive as pouring concrete, digging the hole, setting the frame. And just because a project hasn't broken ground yet doesn't mean that tens of thousands, if not hundreds of thousands of dollars haven't been already invested. So as a matter of fairness and of city building, and also of respecting the business environment in our city, I encourage you to support all or the considerable majority of these exemptions. Thank you.
Thank you so much. That concludes this panel. I believe we have Councillor Clark is in the queue.
Yeah, may I speak with Ida, please? No need to rush. You're good. Thank you. Hi.
Hello.
I just wanted to thank you very much for coming. I just wanted to touch base about a couple of things. You'd commented a bit about that parking lot and with the Franklin Station, which isn't entirely on topic today, but I can appreciate the context that you're building around it because, colleagues, there's 22 items of the 247 in Ward 9, and 10 of them are in Radisson. So you folks have been definitely hard hit by this. Just a couple of details that I'd like to clarify for you. The application, as we understand it, so the signs went up, I guess, yesterday or today. And so we've been chasing that down today as well. So I can confirm that the signage around the parking lot have to do with some updates to the transit circle and to the Franklin TOD. There's it's a separate project that's occurring what feels like simultaneously, and I can appreciate that. So I just wanted to clarify that for you. I also want you to know that the application for that project that you're speaking of completed on June 18th. The first detailed review came out July 16th, so just recently, and that expected amended plans sometime in September. And I just wanted to share that with you, and we'll of course share that in a number of other ways with you by email as well in writing, because I know what community has been looking for in this particular project and through a number of the projects that we've also talked about today is clear, concise, and enough time to engage properly on these things. So I just want you to know that we're chasing that down in real time. We are committed to delivering that support for you on the projects that we're speaking of today at public hearing, but certainly the one also that you've brought up about Franklin Station.
I appreciate that. I just really want to emphasize that, that's 400 parking spaces that are not going to be available. And it is a serious impact. When I talk to the people, there are carloads of people that come from various parts of the city. And there are people that during tourist season, they told me they land at the airport, they rent a car, and then they drive down to this parking space. because they don't want to drive in the city. And some of them come from a culture of where they're trying to limit their driving. And there were people from all over the world, but all over Calgary that use that parking lot. And I know I used it for 30 years when I was working and trying to be a single mom and delivering my kids everywhere, getting home on time so they could participate in sports. It's an incredibly important part for seniors as well, because they don't feel comfortable driving in main part of Calgary, and so they drive within their community to the parking lot and then, you know, go to their medical appointments, do their shopping and such. And we have suggested so many other places for this low-cost housing. And why destroy the lives of all these people? And when we have other alternatives, like the Sunridge parking lot is virtually empty, and Marlborough has options on both sides of the street, one where the Ford dealership was, and on the north side of Marlborough Mall, and then right in our own community, the Swiss Chalet on the north side. We have alternatives. I don't know why we have an either-or attitude.
Right.
Yeah, I appreciate you.
Thank you. Thank you very much for coming.
Thank you.
Thank you. That concludes this panel. Our scheduled break is for 6 o'clock, so I'm going to compose a panel of 4 speakers. We'll start from the beginning. Were there any registered speakers on panels 1 through 10? How about panels 11 through 20? I'll count up from 21 again. Do we have Sammy Ibrahim? Cheryl Sellinger? Alan Wolf? Melanie Swales?
I'm on the line.
Thanks, Melanie. Please stand by.
Thank you.
We've got Terry Wong. Okay, I think we're caught up. Mike Borcrystal. Okay, our 2 panelists are Melanie and Terry. Do we have anyone else who is on the line that has not yet spoken?
Hi, my name is Tyler Wells. I'm on the line.
Sorry, could you repeat your name?
Tyler Wells.
Tyler? Okay. Is there anybody else on the line that we haven't heard from? Besides Melanie, Terry, and Tyler? Anybody here in person wanting to speak to it and hasn't had the chance? All right, so we'll proceed with our panel of 3. It'll be Melanie, Terry, then Tyler. Melanie, please go ahead. You have 5 minutes.
I do have 2 slides, so could you please let me know when they are up?
Yep, they're up there.
Perfect. Okay. Mayor Farkas and City Councillors. My name is Melanie Swales, and I'm here on behalf of the Brentwood Community Association in opposition to granting exemptions to some DPs in our community. I'm going to keeping them, yeah. I'm going to keep this very short and let all of you go for supper. In Brentwood, we also received a flurry of applications just prior to the blanket rezoning repeal hearings, seemed to be a rush to get permits submitted, and instead of gentle densification, we received a bulldozer approach. There was an incredible amount of opposition to those RCGs, and you've heard from many of our Brentwood residents already today. Many speakers expressed their emotions against what they felt are buildings which are overpowering, massive in scale and form, and completely non-contextual in their neighborhoods. We agree, and I won't go into it any further. So I'm going to ask for the next slide to come up, please. There's one specific request that we do have regarding a property at 5032 Barron Drive, and we ask that it be removed from 27P 2026. The intent is to allow for a duplex, not a future RCG. This application was for a duplex, 2 units with 2 suites submitted in February. Under RCG, it was a permitted contextual use complying with the land use bylaw, so the community or the neighbors were not circulated, and we had no opportunity to comment. This application has now been approved for 126 days, but has not been released because apparently the conditions of approval have not been met. Because we were not circulated, we're not able to access any further information. We're not aware of any reason for the delay. The appropriate land use district should be RC1 or RC2, but not RCG. If this land stays as RCG, the developer can withdraw this current application and apply for a row house or townhouse, which we permitted under this district until August 4th. This would not conform to Council's intention to repeal blanket rezoning on this lot. The neighbors deserve the certainty of knowing only a semi-detached dwelling can be built on this property. This could be best resolved by ensuring that when the current DP expires, changes, or is canceled in any way, the rezoning reverts back to RC1 or that an RC2 is applied for. That's all I have. Thank you for your consideration of this request.
Thank you so much. We'll go now to Terry, please.
If you may, I have a document for your official records that you've taken. I've emailed it to the council clerks as well as emailed to members of council, but if you'd like a hard copy, here's a hard copy as well.
Thank you.
Thank you. Your Worship, members of council, my name is Terry Wong, former city councilor in Ward 7, also a member of the Hounslow Heights Briar Hill Community Association. I'm here to speak on a couple of things, and one of which is a history that I have in dealing with the blanket rezoning, and secondly, a history I have with respect to the exemption and a particular development permit application. As many of you know, first off, I'll declare right up front, item 731, bylaw 27P 2026, I am in favor of it for various different reasons. However, one of the things that when I thought about coming here, I thought about the response I would get by colleagues as well as public that I'm a bit of a hypocrite. I'm a hypocrite in the sense that I fought against blanket rezoning. I fought against RCGs, I fought against density, I fought against a whole bunch of things. But one of the things you may remember during my 4 years on council and when I spoke last March in council about RCGs and blanket rezoning, it's not that townhouses and row houses are not the right thing to do. It's the engagement. It's ensuring the contextual aspect of RCGs in neighborhoods. It's about preserving history, culture, and heritage. It's about ensuring starting here, ensuring that parking is available for people. It's ensuring at the same time, though, that we have the right type of housing for the right type of situations that people need. And we all know affordability is a challenge. Housing supply is a challenge. You know, we can't forget that we have a housing strategy that needs to be adopted. Having said that, though, you know, I am an applicant for a development permit, my own house, my own property. And many of you know, during the 4 years, colleagues that were with me in the council previous, when I left council, I created a new vision for myself and my family. And that was to be able to build housing that, you know, that we could, you know, live and support on. But also living on a housing that I don't have to provide a mortgage for them. Housing I can provide for them beyond my life. And that was being to build a, 4-unit, 3 secondary suite housing, where I can, incorporate that family into one of those units and also be able to, take care of myself, my life, and their lives going forward. So we started the conversation and journey back in November by talking to planners, by talking to consultants, by talking to realtors, by talking to members of city council, city administration. I tracked everything you did from December through to March, through to onwards, and I followed every single step along the way to get there. The exemption, my property application as an exemption is in accordance to what you allowed us to do. The 247 applicants that are out there, follow the same process. You gave them the right to get to where they wanted to get to. Most of them have a reason similar to myself. It's a reason of personal need, personal responsibility to the community, be able to provide housing, not just for myself and my extended family, but also be able to provide housing for others. We have an obligation as member of council to be able to, to build a future. And again, I'll let you read my written submission. But one thing I will say is I respect the speakers that have been up before me. I respect that they are concerned about the communities. I respect that they're concerned about density and the impact of the neighborhood and parking. I respect all of that. But that is today. And talking about tomorrow, yes, some of us will be around tomorrow. 10 years from now, I may not be, but my kids and my family will be. I'm going to close on one final comment. The closing comment is that I just spent a week in China, in Beijing, Dajing, Calgary sister city, Harbin, Edmonton sister city, Heilongjiang province, Alberta sister province. And I was enlightened by many different things that Calgary can be that we are not. Imagine driving the city of 30 million people in an autonomous vehicle, no drivers. 30 minutes driving through, a city where there's cars, bicycles, pedestrians all over the place. But not once in that 8 days I was there did I witness an accident. Not once did I witness homelessness. Not once did I witness, drug abuse or anything else and such. And I asked myself the question, how? 30 million people, we were 1.6. How is that the case? The answer was the community came together. We came together to support each other's need from a social, recreational, health perspective. Yes, we all have individual concerns and issues, but the society that we have now needs to go forward and be able to support each other. 247 properties out of 300,000 is less than 1%. The 247 properties that are moving forward today, some of them are doing what I'm doing, which is taking care of my family. Now, I realize my time's up. So with that, I'm open for questions. Thank you.
Thank you. We'll go to Tyler as the final panelist. Please go ahead, Tyler.
Thank you, Mayor and Council, for your time. And I understand that it's almost dinner time and I won't hold you very long. So many other people have spoke so eloquently to many of the issues that I'm hoping to speak about today. I live in the community of Haysboro, and I'm specifically speaking about the development at 79 Hillary Crescent. And so many people have spoken about, things like the impracticality of size, parking space, cart space, etc. But I've heard many people talk about showing up for their community and showing up for their spouse or for themselves. But I'm here for my kids because we bought our house about a year and a half ago, and we bought it because it was really private and because, we didn't want to be in a denser part of the city. So this was something that worked for us and we thought was a safe and comfortable place for my family. So going forward, I think there's like three things that will negatively happen if this development, if the issuance is delivered for this development. I think it'll likely cost myself and most of my neighbors thousands of dollars as we seek to support an appeal. I think it will affect the happiness of our neighborhood. I don't think it's an overstatement to say that my neighbors hate this. And there's over 40 of us in a backyard recently talking about how we were going to try and show up at this hearing and do what we can to, at the very least, have this development scaled back, if not stopped. And then I think for me, the privacy cost is enormous. This will completely change a space that my family enjoys the most. We've spent tens of thousands of our own dollars on arborists, landscapers, plumbers, all sorts of contractors and different services in the city to change our backyard into a place that we can really enjoy. And with the size of this and the amount of people that are going to be able to look into our backyard directly, it's going to completely change this space and it will change our neighborhood. And so I think I just wanted to bring forward a few things that I haven't heard quite as much. The financial cost to my neighbors. I think we're all going to pledge hundreds, if not thousands of dollars to get legal support. The general happiness, people are using words like, we have lawn signs in our community. The general word I've heard the most is this is atrocious. And then the privacy cost is undeniable. There are parts of Haysboro where people have talked about, having a density closer to the C train station. And I specifically didn't want to buy a house on the side that's closer to C train because there's buildings like London that can see into people's backyards. And I feel like this building is now literally coming in. It's on the other side of the lane for me. I actually live on Hanover. But it's going to see directly into my backyard. So I wanted to talk about that impact. And again, thank you for your time and I appreciate the respect you've given all of us.
Thank you so much. Really appreciate you participating. All right, that concludes this panel. I don't believe we have any questions for this panel. Is there anyone else? We probably can speak with maybe one or two more people. Is there anyone in the audience who has not spoken yet and wants to speak to this public hearing? Sorry, I know, unfortunately, we don't have the opportunity to hear from the same individual twice, but if there's materials you'd like to provide to us, we can do that separately. Yeah. Is there anybody else on the line who wants to speak as part of this public hearing? Going once, going twice, last call. All right, I will close the public hearing for proposed bylaw 27P 2026. And at this time, I'll open the public hearing for 28P 2026. Is there anyone who wishes to speak to 28P 2026? Okay, come on down.
Because I don't really understand the difference. I mean,
to explain once more,
just difference between the two.
The 27.8P 2026 is the bylaw with the list of exemptions. So to allow them to keep their RCG. 28P, this public hearing, is to add a bunch of properties that would have stayed RCG to now be downzoned. So the list that is in for this public hearing is the properties that will go back to what they were before the blanket rezoning.
Okay. What I wanted to say is that, and I think this refers to maybe both 27.
And if you don't mind just identifying yourself.
Oh, I'm sorry, excuse me. Lois Cutts. This is relating, I think, to both 27 and 28. But while you're considering the cost to developers, and a number of 25 million was mentioned, and number doesn't matter specifically, I would like you to consider the cost to homeowners as well. A home that's going to be sitting beside one of these maxed out 8plexes with insufficient parking and reduced setbacks will definitely lose value and will be much harder to sell. Not to mention all the other issues which are very important, happiness, et cetera. I think developers in some respects have brought this lack of trust and fear of change upon themselves by being greedy and trying to put unreasonably large buildings on lots because they can. The gentleman who called earlier hoping to be able to continue with his duplex developments, I don't think he'll have to worry about his $150,000 investment. I think that's safe because what he's doing is working with his community, building something that's appropriate, a duplex sitting beside single-family homes, something people can live with and enjoy. What the problem is are developers who decided they're going to come in and try to make $1 kabillion on ruining the neighborhood for everybody else. So, thank you for listening.
Thank you so much for being here. Is there anyone else who wanted to speak to 28P 2026? Okay, come on down.
Your Worship, Terry Wong speaking again on 28P 2026. One of the things that I think is important and incumbent upon council to look at in terms of, again, the 247 and 27, as well as the number on this one, is to ensure that there's a proper adjudicated review one by one, as opposed to blanket adding them in or blanket removing them. When we talked about blanket rezoning previously, that the concern of constituents has always been a sweep of a pen, make it all happen, as opposed to, the unintended consequences of some that you sweep in and some that you sweep out. I would ask council to consider that when you debate, 27 and 28P 2026, possible motion arising that allows administration to bring back to you a more adjudicated look at the 247 on the one, and I can't remember the number on the second one, a more adjudicated look at it to say there may be some unintended consequences of adding or removing some of the equation. Because again, whether it's investments, whether it's lifestyle, whether it's whatever, A blanket approach is what we fought against in 2024, March of this year, and what we're doing again is a blanket, and that this is exactly what Calgarians don't want. They want you to do the job and do it properly, and they want your direct administration to bring back the right recommendations, not a quick fix this way, a quick fix that way, but a true, fair, adjudicated look at each of the applications, because there are merit in some of those. Thank you.
Thank you. I think, Madam Clerk, it comes to mind that it may provide some governance challenges if we have two different public hearings and not every member of council was present for the entirety of both public hearings. So what I mean is that my hope is that I can bang the gavel right now and we can come back with all 15 members of council here, continue the public hearing, and that will allow for every member of council to have been present for at least a portion of the public hearing, which will allow all 15 of us to be able to vote on both of the items. So my instinct is that this public hearing is about to end. We kind of ran out of people, but I'm going to say we're going to keep the public hearing open. I'm going to bang the gavel now. We're going to come back at 7:15 p.m. And please, let's have all 15 of us here at the start on the continuation of this public hearing. So see you back at 7:15. Welcome back to Calgary City Council. Madam Clerk, please call the roll.
Thank you, Mayor. On the roll, Councillor Jameson. Present. Councillor Johnston.
Here.
Councillor Kelly.
Present.
Councillor McLean.
Here.
Councillor Pantazopoulos. Councillor Schmidt. Councillor Tyers.
Here.
Councillor Ward. Councillor Wyness.
Here.
Councillor Ewell. Councillor Atkinson. Councillor Chabot.
Present.
Councillor Clark. Present. Councillor Dollywall.
Here.
And Mayor Farkas.
Here.
Thank you, Mayor.
Thank you, Madam Clerk. Prior to our recess, we opened the public hearing for 28P 2026. Is there anyone who in the chamber would like to speak to 28P 2026? Mr. Borkrystal, I think you expressed an interest. Come on down.
Hello, Mayor, members of council, blanket rezoning, I'm back. As mentioned earlier by the Calgary Inter-City Builders Association, which I am a member of, the industry needs certainty, and it's its biggest concern. Without certainty, investors are reluctant to spend money. Prior to blanket rezoning, our firm would do between 8 to 12 development permits a month. We were one of the leading firms. We would go in front of council at that time and we would get an 85% approval rating for land rezone where the public had the opportunity to come to a public hearing. Then came blanket rezoning. We jumped slightly to about 14 DPs a month, not a huge change, but it eliminated the land use process, which took quite a while. Then you repealed blanket rezoning, and I get it. That's gone, it's done. You gave us direction and a deadline. We had 18 DPs in the queue at the time, and most of them were in months before the April 8th deadline. Most have been approved now, and over 80% of them have been appealed, and that's a different story. And I can tell you that the city got slammed, and I can tell you that they did not expedite any DPs. In my experience, the only ones that got expedited were if they were in Stream 3 and they were a permitted use. Those generally go through quite a bit quicker. So we also managed to get 8 more in under the deadline. Now, since the deadline, we've done 3. And 1 got defeated in council yesterday. We've had to lay off half our staff. Clients are moving away from Calgary and looking at other jurisdictions. And we have lost confidence in council and in the building in established areas because you never gave us a replacement. How about one of you give me 900 grand for a lot, and I'll do an LOC. And it's going to take about 6 months to get in front of you at a carrying cost of 15 grand a month. So now we're at almost $1 million. And now I have to come in front of council and convince you to change our lot to RCG when you just took RCG away. What are my odds? They're slim. Even if it was in an LAP, they're still slim. That's what we're hearing, that's what we're seeing, and that's what we're feeling right now. And that's my personal opinion. So now we got SDAB, and there's going to be big trouble for council and SDAB after August 4th. So you have to think about this. Whatever you decide today, on August 4th, the rules change. I've got 15 appeals in October and November that I have to attend. SDAB has to rule on the rules of the day on appeals where they were approved with rules of yesterday, which means that some of them will have relaxations under the new rules but approved under the old rules. Oops. What does SDAB do then? How do you answer to that? That's going to be a problem for council, it's going to be a problem for SDAB, it's going to be a problem for industry, and it's going to be a problem for landowners. So you have to put something in place to take care of that anything that is under the old rules but goes into SDAB after August 4th, maybe they have to extend those rules so that they don't have to go for the rules of the day. You have to really think about that. So there's a lot going on around all of these decisions that you have to make for 7.3.1 and 2 and 3. And I just caution you to make sure that you're looking after everybody in the queue and making sure that industry, if you don't give industry certainty, it's going to go away. And that 50-50 that we got close to during blanket rezoning, it's going to go to 80-20, 90-10. Now you're way offside with your MDA. So It's a tough decision, but I thought I'd come and share my thoughts and opinions. Thank you.
Thank you for being here with us. Any questions for the presenter, colleagues? Councillor Chabot.
I thought I was going to get off scot-free.
Mr. Borkersola, well, my first question is, do you have a parent in a seniors facility?
Do I have what?
Parent in a seniors facility?
I do, actually. I have two of them.
Down south?
I have one in Seaton, oh, not Seaton, up in Shaughnessy, and I have one in Millrise. Yeah.
My mother's there.
Ah, okay.
Sorry. First of all, sorry about that.
That's okay.
Anyways.
We're not supposed to reveal the private information of third parties.
Sorry. Anyways, I guess my question is in regards to appeals currently and some of the approvals that have been processed since prior to or initiated prior to the reversal of the blanket zoning. I thought you said previously that you would like to see those, be processed, either get approved and go through the appeals process, and whether they are for or against, let them, work their way through the process. Of course, as you just said, as long as they continue to follow the rules to which they were originally approved, right?
Yeah, Councillor Spo. As long as they were in the deadline and they met the rules and they got approved, they shouldn't be reversed. If they get appealed and they go to SDAB, right now they're booking in late October, early November, and so SDAB will have to apply the rules that you put in place on August 4th, even though it got approved before that. So if you can extend that date of August 4th for any appeals that are under the old rules, that will help SDAB make better decisions, and it'll help eventually help you as well. And because what it sets up is it sets up courts of appeal. Because now SDAB, which is governed by the city and and also the province, they're going to have to make a decision. Let's say I've got one in and it met all the rules, but you change the rules from 11 meters to 10 meters and you change density, which will kill the industry if you do that later. Then all of a sudden it met the rules here, but now SDAB looks at it and goes, well, you don't meet height, you don't meet density, you don't meet this. We have to relax that to allow this to go through. And those relaxations can then be fought in Court of Appeals. So now you're creating a bigger mess.
Right. And insofar as we did talk about the possibility of speaking about all the bylaws or all the items that are before us. So the one about the density modifier, you're supportive of administration's position on that to retain the 75 units per hectare.
Absolutely. 3 doesn't work. 2 works, 4 works, 3 doesn't work with everything that's in place.
Okay. That's your perspective, and I appreciate that. Thanks. No further questions for me.
Thank you, Councillor. All right, thank you, Mr. Borkrystal. Is there anyone else here in the chamber who wants to speak to this item? Is there anybody else on the line who wants to speak to 28P 2026? Going once, going twice, last call. All right, we will close the public hearing on 28P 2026. So for item 7.3.1, we have conducted the public hearing for 27P 2026 and for 28P 2026. I understand from speaking with some of our colleagues that prior to us going into questions of clarification of administration, there was a desire to move a motion to go into closed session to receive legal advice in terms of potential amendments. At this time, did a council member want to make that motion? Okay, Councillor Chabot is making that motion. Councillor Johnston, did you want to second that? Okay, Councillor Johnston has seconded that. Is there any debate on this motion? Madam Clerk?
We're just updating the wording because I heard that it's for the purposes of receiving legal advice. We will just put in the appropriate section before casting the vote.
Yeah, I'd say it would be legal and advice from officials. Or client solicitor privilege and advice from officials.
Mayor Farkas, the vote is ready.
All right, let's engage the e-vote, please.
Mayor Farkas, all the votes are in.
Thank you. Please display the results. On that, the motion is carried 12-3 with Councillors Schmidt, Clark, and Ewell opposed. All right, we will head to the council boardroom.
public hearing meeting of council will be resuming in public meeting shortly. Please make your way back to council chamber. Thank you.
All right, welcome back to Calgary City Council. Madam Clerk, please call the roll.
On the roll, Councillor Kelly.
Present.
Councillor McLean. Okay, Councillor Pantazopoulos. Councillor Schmidt. Councillor Tyers. Councillor Ward. Councillor Wyness. Councillor Ewell.
Here.
Councillor Atkinson. Councillor Chabot.
Present.
Councillor Clark. Councillor Dhaliwal.
Here.
Councillor Jameson. Councillor Johnston. And Mayor Farkas.
Here.
Thank you, Mayor.
All right, I believe we require a motion to rise without reporting. So moved by Councillor Chabot, seconded by Councillor Ward. All in favor? Any opposed? Seeing none, that motion is carried. Unless there's an objection, I'm going to recess to the call of the chair for approximately 7 minutes to allow council members the opportunity to check their email for the draft versions of motions arising and amendments that will be distributed. Seeing no objection, we'll recess to the call of the chair, coming back approximately 9:03. Welcome back to the call of the chair and Calgary City Council. Madam Clerk, please call the roll.
Thank you, Mayor. On the roll, Councillor McLean.
I'm first. Yay. Yes, I'm here.
Councillor Pantazopoulos. Councillor Schmidt. Councillor Tyers. Councillor Ward. Councillor Wyness. Councillor Ewell.
Here.
Councillor Atkinson. Councillor Chabot. Councillor Clark.
Present.
Councillor Dollywall.
Here.
Councillor Jameson.
Yep.
Councillor Johnston.
Yep.
Councillor Kelly.
Here.
And Mayor Farkas.
I'm here.
Thank you, Mayor.
All right, colleagues, we've concluded the public hearing for the two bylaws under 7.3.1. We've emerged from closed session. We have some potential motions arising and amendments once the main motion is moved. I'm going to suggest, colleagues, we commit that we're not going to undertake the remaining public hearings, and we're just going to push through tonight as long as it is required to conclude 9.3.1, which is 27P and 28P 2026. I think it's probably not going to be a ton of time, but I think it'll push just a little bit past 9:30 this evening. Or sorry, 7.3.1. Whoops. Yep. All right, so with that, we're at a point now for questions for administration prior to the moving of the main recognitions. All right, so let's all make sure that we're in the right teams. If anyone wants to go first, just give me a wave. Deputy Mayor Kelly.
Thanks. I just wanted to refer to the spreadsheet. There's a couple of items in the parcel reference sheet that have application submission dates from back in 2023, and that their application decision date was in April 2024. May 2024. I'm just wondering if I can get a little bit of clarity from administration in terms of how did those end up finding their way into this particular spreadsheet? Because I think the criteria that we use for the most part from previously was January 1st as sort of the cutoff, and we had those in what we looked at in April, but these ones are obviously before that. So I'm just wondering if I can get a little bit of background about how these ones found their way into the spreadsheet.
Thank you very much. When we were reviewing the parcels that were to be included with this, we also looked at some historical LLCs to see ensuring that they were included. When we looked at the exempt maps and if they were included in the March 23rd, they appeared to be missed, so we just wanted to include them with this batch.
Thank you. Second question, just we heard from a couple of the presenters, especially those in Ward 4, who they have developments in their neighborhood that are currently zoned as RCG, that at the conclusion of this would go back to RC1. But the development that is currently approved or under review is a duplex, effectively, that would meet the criteria of RC2. Is there any opportunity in this process before us? I don't see it, so I imagine the answer is no, we can't do it. Is there any way to rezone those properties to RC2 instead of RC1 to meet the request of those community associations?
The short answer is no. It would not be possible with this public hearing.
Yeah, that's what I figured. It would require a completely new public hearing and an application and whatnot in order to rezone those properties from either RCG or RC1, depending on the outcome of this hearing, to get to the RC2.
Yes.
Okay, those are my questions, Your Worship.
All right, I see no further questions of clarification. Is there a mover for the main item here? Councillor Chabot.
Well, I guess being as I started this process, I probably should move the
We get to blame you? Start what you, or finish what you started?
Administration, well, at least we've landed on something that we can work with, and I think some of the proposed amendments will help to clarify some of the things that we may not necessarily agree with the recommendations, but happy to put the recommendations on the floor, and there's going to be some amendments that I may be supporting and some that I may not be supporting, but at least to get this on the floor and try and address any issues in my close that come up during the course of the debate.
Okay, that's been moved by Councillor Chabot, seconded by Deputy Mayor Kelly. That's on the floor. Any debate for this? Deputy Mayor, please.
Yeah, I think that this was a procedural thing. We heard from many, many people in this process, so it didn't feel very procedural. It definitely felt like a big change that people were experiencing. But at the end of the day, this is a cleanup process for us to execute what it was that we said, both in the notice of motion and then again in the repeal of the blanket rezoning that we said that we would do. We said that there would be exemptions in that process in order to provide procedural fairness for individuals who owned properties like this, who wanted to submit a development permit, and we have to, the way it works, we have to approve their development permit under the law at the time when they submitted it. And so this is a procedural cleanup in order to be able to make sure that we're following through on what it was that we said to Calgarians in those two processes, both the original notice of motion in December and then the repeal of blanket rezoning. For me here, when we're looking at this today, I see why we can call it a cleanup or a procedural thing. This is us following through on what it is that we told Calgarians from the very beginning that we would do in order to be able to provide as much fairness as possible to as many Calgarians as possible. So happy to vote in favor of this here today.
Thank you. And quick question maybe to Clerk's Administration. I believe there's some amendments from Councillor Johnston. Are they put at this point or is it after the first reading?
It's after the first reading, Mayor Farkas.
I'll enter debate myself maybe with a just very brief question. So when Council approved the bylaw in March, baked into that bylaw were the exemptions that were effective up until December, right?
December 31st, correct.
Yeah, so even in the repeal that we approved previously, as part of that repeal, there was significant amount of exemptions or maybe holes in the Swiss cheese that were on the table that we approved at the time.
The lion's share of exemptions were approved at the March 23rd public hearing.
Okay, so I'll start with that. This council's already given near unanimous endorsement to the exemptions previously, and this is just the finality that's required. It's important to remember what we're actually debating today. This is not another vote on blanket rezoning. Us as a council, we made that decision months ago. Calgarians elected a mayor and council that promised to repeal it, and that we did. Today's question is different. The question is whether we honor the transition rules that council adopted as part of that repeal and were reconfirmed based on the public feedback that we heard. To me, this comes down to one simple principle, that we have to keep our word. When council establishes a process, people are entitled to rely on it. If someone followed every rule we put in place, submitted their application on time, met every deadline we established, it isn't right for us to come back later and say that we've changed our minds. If we do that, what kind of message are we sending? Why would anyone trust the next rules we pass if we're willing to rewrite the last ones? The easiest thing for us politically is to move those goalposts. The harder thing, though, and I believe the right thing to do, is for us as a council to keep our commitments. I understand why emotions are high on this. I've heard from thousands of Calgarians who felt blanket rezoning broke trust in the planning process, and I agree with them. And that's why I supported repealing it. We said that we would restore certainty, and certainty has to apply to everyone. It applies to neighbors, but it also applies to applicants who followed the rules that we established as a council. I know that some people will be disappointed with some of the exemptions that we approved back in March and some of the exemptions that this motion represents. And I know that there are people who would like us to stop projects that are already underway or even tear down projects that have already been built as part of that past set of rules. And I want to say that I understand those frustrations. Many people felt that the previous policy was the wrong approach, but our responsibility is to govern fairly. Once people have relied on the rules that were in place and have moved forward with that approval process, we don't get to pretend that those rules somehow never existed. We don't get to tear down these projects because a different council made a different decision. And I've grappled with this a lot as mayor. I've lived with the arena agreement, which I disagree with. I've lived with the Cowboys Park agreement that I disagree with. But once those decisions were lawfully made, my responsibility as mayor became to honor the city's commitments. And we don't get to rewrite agreements because a different mayor, a different council would have preferred a different outcome. And that's really, as mayor, what I want to push for is the institutional credibility. And I think Councillor Panazopoulos, you said it earlier, that our credibility is built one decision at a time. It takes years to earn and minutes to lose. And I do believe that this debate is bigger than just a few hundred applications. It's also about whether Calgary is a city where we have a local government that keeps its word, whether you're a homeowner, a builder, a small business owner, or a family trying to make one of the biggest investments of your life. You need to know that if you follow the rules, that City Hall will follow the rules too. And that's why I'll ultimately be supporting this. A deal is a deal. We made a commitment to Calgarians that we would repeal blanket rezoning. We kept that commitment. We also made a commitment that applications already in the system would be treated fairly under the transition rules that we ourselves agreed to, and we need to keep that commitment as well. And I think that moving forward with this approach is how we restore trust in the planning process. It's how we build confidence in City Hall, and it's how we demonstrate that when the city gives its word, when we give our word, that means something. So that's my debate. Over to Councillor McLean to weigh in.
Yes, thanks, Mayor.
I think Madam Clerk wants to speak.
Apologies for the interruption. Just looking at the clock, it is 9:29. Council must recess at 9:30 unless the time of recess is modified by a 2/3 vote.
All right, Councillor McLean, would you like to modify the time of recess to get the conclusion?
Modify to right after my debate.
Let's say at the conclusion of this item and the motions arising.
Okay, I'm good with that.
Okay, Councillor McLean has moved that. That's been seconded by Councillor Tyers. All in favor? Any opposed to that? Seeing none, that motion is carried. Carry on, Councillor McLean.
Okay, thanks, Mayor. Yeah, I think we have spent a lot of time in this chair on blanket rezoning, listening to a lot of people. The first round, hundreds of people, maybe 3 weeks, then repealing it, and now cleaning up some of these remnant things. But I'm always touched, and I think it's part of our job that I probably, maybe it can be tedious and time consuming, but we're listening to the public. Mm-hmm. And in this case, I got to say, I always side with the public. I understand the reason to clean up some of these remnant parcels. There was some confusion, even in the repealing bylaw, but a lot more confusion out there with the public. There's a lot of people that didn't know that they were going to be in a position where some of these developments were going to go forward. And for that reason, I can't support this. I understand the reason behind it, and that there's development permits, if they're still there, it may still get built, but I think there's just to send a message to the public over top of the development community, because there are some concerns there for them as well, for where the risks are out there, or for I'm just going to wrap it up and bring it around. It's been late. We're tired. I think we should still not support this side of the public. This is 250 properties and impacts a lot of people. So for that reason, I'm going to vote no, and I suggest others do as well.
All right, Councillor Schmidt, please.
I'll go back to the numbers that were given to us when we came to this. 306,000 properties with blanket downzoning, 247 left over. And we've spent a lot of time looking backwards as a council so far. I hope that when this is done, that we make a decision that is sound in our governance role, and that we can finally start looking forward as a council, because the problem we keep landing on with everything is that we have a land use bylaw that is almost 20 years old. And by going through these things, by trying to extend the rules, change our decisions, extend debate, we are taking away valuable time from a new zoning bylaw that could put our stamp on development and solve a lot of the problems that we are hearing from all the members of our community that are involved in development. So we spent a lot of time looking backwards with this one today as well. And at a certain point, it's also incumbent on those who have an interest in this to read and understand something that was put in place in December, and to access help or resources or contact us if they want clarity, but we ultimately have a responsibility to the entire city, and we need to make decisions that help us move forward. So I'm glad that we've gotten through this one, but it's time to stop looking backwards.
All right, I'm going to go to Councillor Chabot to close.
Okay, thanks. Just as a point of reference for some members of council, this item deals with two specific bylaws. One is the exemption of some properties that had applied in alignment with the direction that council had previously given. 28P, of course, is one that I think everyone can support, which is ones that were accidentally, put into the exemption list and were corrected. So now they're going to go back to RC1. And 28P is one that I think everyone should agree to support, because it's essentially strengthening the repeal more so than anything else. So I just want to point that out. The other one, I think, from procedural fairness and I guess taking into consideration the amount of investment that some of these developers have put into some of these applications, one of the questions that was brought forward in clarification is, why do some of those DPs have a 23 in front of it? Because they started in 2023, and so they only reached completion just prior to, or subsequent to, prior to the repeal bylaw getting first reading. So these are major investments made by individuals, and in some cases, maybe they're not appropriate, but we should at least give them the ability to follow a due process, which is getting the development authority to either approve or not approve them, because some of them are still pending. And then if they are that egregious, they are discretionary. The community association can appeal it, can take it in front of SDAB, and if they are truly not suitable for the locations that they're being applied for, then they would revert back. Of course, this is subject to a motion arising that's going to be coming as well, as far as extending the period to allow some of these appeals to actually be implemented, to revert it back to the original base zoning that it was prior to the blanket zoning. But anyways, first and foremost, we have to get past first reading on these so that we can make some of these amendments, including some of the other amendments where some members of council feel that this is going too far. Again, you can't amend this without doing that. Otherwise, you have to refuse them all. I don't think refusing them all at this point is the right thing to do either. So putting it on the floor, hopefully we can get past first reading so that we can get to other proposed amendments prior to second reading, and then subsequently get to some of the motion arisings that I think will help to find some middle ground that provides some, I guess, certainty for all parties. So, closed.
Thank you, Councillor. Let's engage the vote, please.
Is it too late to see if we can call these separately?
Nope. Not too late, no.
Okay, I'd like to call them separate.
Let's give our clerk's team a time to get that ready for us, though.
Well, that's it.
Could we do a voice vote on 3 and 4? Would that be okay with you, Madam Clerk? And then e-votes for 1 and 2?
Sure.
Okay. So I'm gonna call the question on 3 and 4, which is keeping the attachment confidential, the distribution, and it's the closed meeting discussions and the legal advice. So I'm calling 3 and 4 right now. All in favor of 3 and 4? Any opposed? Seeing none, that is carried. And Madam Clerk, let's engage the vote on 27P 2026 when you're ready to do so. Recommendation 1.
Mayor Farkas, all the votes are in.
Thank you. Please display the results. On that, the motion is carried 10-5 with Councillors Ward, Johnston, Jameson, Tyers, and McLean. Opposed? Let's engage the e-vote on recommendation 2, which is 28P 2026.
Councillor Jameson, your vote, please.
No.
Thank you. Mayor Farkas, all the votes are in.
Please display the results. And that motion is carried 14-1. Councillor Jameson, I just want to double check with you and make sure your vote was correct on that. This bylaw that you voted against was actually to repeal even more properties. So I'm not sure if that was your intent or if I explained it correctly.
I appreciate you saying that, and yes,
Okay.
it should be.
Okay. Yeah, because I know in Councillor Jameson's debate, he indicated that he wanted to support this. Madam Clerk?
Just unanimous consent. Should that not be granted, we'll need a motion.
Do we have unanimous consent to allow Councillor Jameson to change his vote? Okay. All right. So that, based on that result, that motion is carried unanimously. All right. So we're going to move to the readings of the two bylaws. This first bylaw 27P, I understand there's 2 amendments to it. So after I give the first reading, should the first reading pass, then I'll go to Councillor Johnston for his 2 amendments. So first reading of bylaw 27P 2026. Anyone opposed? Hearing none, that is carried. And I'm going to recognize Councillor Johnston now to speak on the First Amendment.
Yeah, to me this is pretty simple. We explained it in camera with legal a little bit, but basically we have 2 lots that were subdivided and they were granted under our direction, of course. But if they were to revert back and to be removed from Schedule A, they would revert back to the original RC1, which does allow them to continue building the same amount what they could have built under the previous one, but it allows it to go through the development permit. And that's my intention on this one. And I think Councillor Chabot has a better description of it, so I'm hoping with his debate he can help me out here.
Yeah, that's been seconded by Councillor Chabot. I'll just jump in and support. I'm happy to support this. I don't have an issue. I actually see it a bit contrary to what the original intent from Councillor Chabot was. This is, if anything, removing the 2 parcels, and that I believe it's a bit of a use of a loophole on the intent. It's not the pure, or at least it's not congruent with the intent of me originally supporting that notice of motion. So happy to go over to Councillor Chabot.
Yeah, no, I think you pretty much covered it. The intent of the original motion was to make sure that we didn't inadvertently penalize some of the greenfield developments in the outline plans and subdivision plans. And so we didn't want them to be captured in the repeal. Of course, there's nothing wrong with what this applicant did. It did follow the letter of the law, which is the way it was written, is that subdivisions qualified for an exemption. But that wasn't the intent of this council, or at least not from me, and I don't believe of this council. So it's kind of it's one of those ones that I don't think warrants that retention of that RCG zoning. Of course, there's nothing that prevents them from applying for it into the future. This doesn't necessarily have any financial implications for these particular properties. They have been subdivided, so they have gone from 2 properties to 4. So from my perspective, I think they've already gotten some benefit from whatever investments they've made, and if they want to invest further to redesignate, then they're certainly subject to, or welcome to put forward an application and have council deal with it and get the public to weigh in on it. So for me, 100% support this.
All right, Deputy Mayor Kelly.
Yeah, I'm wondering if I can get a little bit of clarity here, either maybe first from admin or from the councillor on his close. Taking a look at the exemption criteria said A is received a decision of approval on any of a development permit, subdivision, or building permit. This is a subdivision. I'm from administration, maybe I'll start with you just in terms of, it looks to me like this was included properly based on what it was that council originally said. And I'm a little confused from the councilor's debate saying it wasn't the original intention when it says subdivision.
Thank you. You're correct. It meets the exemption criteria A. It is a subdivision. And under the exemption clarifications, both established area and our developing area subdivisions qualified for that.
Yeah, then maybe I'll look to Councillor Johnson on his close to explain what's different about these than what was intended when we approved subdivision originally.
All right, back to Councillor Johnston to close.
Yeah, sorry, I thought Councillor Chabot described it really well, and that his intent wasn't for properties like this to have used what his intent for the subdivision, which would have been more greenfield application. And so this kind of slid, yes, legally in the right spot, but again, the intent from the mover at the time and from the people that supported it, that it wouldn't affect inner developed areas or established areas, sorry. And so vote with your conscience on this, but for us, this is one that should be removed, and I hope you guys can support me on this. So.
All right, Madam Clerk, let's engage the vote, please, on this amendment.
Mayor Farkas, all the votes are in.
Thank you. Please display the results. On that, the motion is carried 9-6 with Councillors Schmidt, Kelly, Panazopoulos, Atkinson, Clark, and Ewell opposed. All right, back to you, Councillor Johnson, for another amendment.
Yeah, second amendment. There we go. Nice long list. Can we scroll all the way down and then all the way back up and then all the way down again? Maybe zoom out. So recommendation on this, or amendment on this, is to remove all non-approved development permits from the Schedule A that was presented to us and to the public at this. Sorry, was the Schedule A presented to the public at the start of this meeting? I just want to double check.
Yeah, it should be one of the scribe attachments. Yeah.
Yes, so everybody has seen the list. Well, these are all the non-approved. Again, what I understand is that the intent was that the approved up until a certain date would have been allowed, which is why we keep the approved part of the list intact. But all the non-approved, again, I felt would have been the intention of a clean repeal, and that these should not be exempt and should be removed from the list.
Okay, is there a seconder for this amendment? Seconded by Councillor Jameson. Any debate on this? Councillor Clark?
So I guess for clarity, because of course this brings forward like loose or unfinished business that we've talked about over the last number of days, or last number of hours, which have felt like days. So can I just hear from administration, like, these are people in process, right? These aren't just like, can you talk a little bit about that?
You're correct. These are all development permits that are in the process that met exemption criteria B. They submitted before first reading, and their permits are in the process of being reviewed. What I like to say, the engine doesn't stop, and so they could be close to their approval. They could be within weeks. They could be in months.
Okay. And so these individuals have all, or corporations or whichever, there's money on the table. These folks have put money down to make this happen. Have they paid us? Like,
Yes.
Yeah.
There is an application fee to do this work, and they made their application, and they're following the process.
Okay, thank you. I suppose I'll just proceed with a bit of debate here and say that, well, I appreciate the spirit of this. I think we've heard some really beautiful words about being taken serious as a business, as a partner for business, and to follow through on our word and our commitments. And so while I know that this looks juicy and beautiful and exactly like a great thing to do, it seems to be kind of cutting the throat of a lot of individuals who've acted in good faith. So I won't be supporting this. Thank you.
All right, Councillor Chabot, please.
Yeah, I'm of the same opinion, although my original motion was looking for an end date, a very specific end date. I was of the opinion at the time that we would be able to process all these applications in advance of that date. And we selected August 4th because that's when we anticipated that we'd be able to have all these processed. But of course, as we know, with many development permits, there's all kinds of little nuances associated with each individual site that requires some back and forth between the applicant and the approving authority, and they can't always all be finalized by a certain date. There's some that are probably really close to being finalized, and this essentially says that as of today, as opposed to as of tomorrow, even by August 4th, we probably could have had several of these taken off this list. So for me, I'd much rather see them be permitted to have due process. They've made some investments, not only in the application for the permit, but investments into plans, architectural drawings, whatnot, for their own application. So for me, I'd rather see them go through a due process, and if they are in fact that egregious, then we should look at a different process.